chaos in the past. I mean, drug problem, but because it looks like this case, the 22 case condition in drug court, so that I'm thinking I may, but I'm trying to figure out. Years of age. Hold on one second. He wants no position. He's been for 2 years, but. That's why. And so now we can. But he's not going to be able to add to it.
All right, good morning, everyone. Oops. Go. We have a trial calendar to call and an inquiry calendar. I don't actually have the inquiry calendar in my hands right now, so we're going to start with the trial calendar. If you're here for the trial calendar, it's a 2-week calendar. If you do not resolve your case today, then either next Monday or the Monday after, you will be here and we'll pick a jury in your case and the jury will figure out what's going to happen with your case. Position 2 is our first. That's Marvin Tank. Is Mr. Tank here? Mr. Tolles? Ms. Dilligard, I know you told me you had been chatting with folks and thought this was being resolved.
And I believe he sent me an email. No, he didn't send me.
I know we told Mr. Tank through his lawyer specifically he had to be here. He has often appeared virtually. I think there's some mobility issues. There's also an ankle monitor, and Mr. Tank needs to be here. So we'll get through the calendar and see. It's not super late yet, but I trust he'll make it. And
I did speak with Mr. Tolles yesterday. This is going to be a resolution. I'm not sure.
Okay, well, we'll work on getting him here. Thank you. Now I have the inquiry calendar. But you continue to believe that will resolve today?
Yes, Judge.
Great. Positions 3, 4, 5, and 6, Ryder, Lemons, Hardy, and Robinson. We have Ms. Rockwell on the call, filling in for Ms. Bumpus, who called in sick. We have Ms. Feely here. I'm not sure who's here from the state. I know Mr. Abate was in trial, probably still is in trial.
Yes, Judge. He's still in trial in Carnesville.
Okay. Do you have words from him to share with, and Ms. Cabrera is on leave, so she's excused. Mr. Regis, who represents Mr. Hardy, has said, I'm ready either Monday. And so he was excused from being here right now. Any update from Mr. Abate?
Texting him right now, Judge.
Okay, all right. Ms. Feely, my recollection is you and Mr. Ryder are ready to go. Monday, the 3rd or Monday the 10th? Okay. And no discovery issues you're aware of? All right, because Ms. Bumpus had said, I'm ready subject to discovery, but this case is old enough and no one has squawked about discovery. That was a little confused by that. Good morning, Ms. Rockwell. How are you?
Good morning, Judge. I was texting with her. I'm not aware of any discovery issues. I know they are talking. There might be some resolution short of trial, too complicated for me to go into. But she says she will see y'all next week if need be.
Okay.
And I did talk to Mr. Banks, who is on trial with Adam Abate. And so I think they're both still grinding away in Judge Carnesale. So I'm sure that Kayla will be in touch with Mr. Abate.
Okay. Yeah, I know I had Mr. Abate has been otherwise occupied, except that, of course, this case is 2.5 years old. So we'll see what happens there. I will be letting the lawyers know via email today the lineup for next Monday and the Monday after. I will not email you, Ms. Rockwell. I'll email Ms. Bumpus. I know she's able to monitor her emails, so she'll know the situation. And I guess we'll take it from there. So thank you for filling in for her.
Thank you, Judge. May I be excused?
Yes, ma'am.
All right.
Bye. Ms. Feely, anything else you want to talk about at this juncture? Okay, and you're available either week. Okay, what's going to happen to non-complex if you're on trial? They'll survive. Okay. Is this your last case in this division, or can we find one more?
I'm hoping to continue trying cases in this division.
Okay.
I don't have anything in my name.
No, okay, nothing directly assigned. You might have a supporting role. Excellent. And I never closed the loop because you did what you needed to do, but that case that you tried in front of Judge Emerson, where the shooting or robbery part was a not guilty, but the drugs was guilty, you filed what you needed to. That's done. So we're all set with that. I won't bug you again about that one. All right, thank you. Mr. McGriff, is Ms. Clark not here? Okay.
She's in a different courtroom.
Okay. I was just going to let her, I think she was on the email. I'm having to bug that lawyer. I don't know that Mr. McGriff can go through DBHDD, given that he's got private counsel and everything, and then it's just going to get stuck, which seems to be the defense approach. All right. I know we've got some people here for this. Mr. Muse. Morning, Mr. McClendon.
Morning, Your Honor.
Good to see you.
See you. It's going to be a negotiated plea.
All right. Are you ready on that? Or do you need to talk with, I know we'll do it today. I'm asking only because I'm going to call the calendar and then go through the inquiry calendar. And if we've got something that's ready, we'll do that first. Otherwise, I'm fine going back there and working for 15 minutes, 20 minutes while lawyers put the final marks on things.
We need the final marks.
Okay. Mr. Muse is here, Deputy Gordon? Okay, great. All right, then I've got that down as ready to go at some point today. For the lawyer planning purposes, we're good until about 12:20, and then I got a lunch meeting and we'll reconvene around 1:45. So we'll work. I can work until 12:20 taking pleas or doing other things. But then everyone gets a lunch break, which you should want anyway. And then I don't have anything this afternoon other than this calendar and the inquiry calendar. So as you are jockeying for position, just know, hey, I'm number 6 in line. We'll do that after lunch. Okay. That's Mr. Muse.
I have one quite fast plea downstairs in state court. Is it okay with the court if I go take care of that and come back, given that you have other business?
You bet. As long as we're taking care of Mr. Muse today, I know this is a long-awaited resolution for him. I'm happy to take things in whatever order. So go forth and return.
Yeah, we're closing all of his cases today. So we're
Okay. Before you go, you say all of his cases, and that reminds me, he had others, and I don't think you represent him on all of them.
He's gonna take the plea on that case. We've been emailing.
Good. It wasn't Ms. Cabrera, it was you. Okay, good. So we've got all the lawyers we need. It sounds like you're gonna sort of umbrella everything when you're resolving this one.
Yes, Your Honor.
Great. Okay, like it. Alonzo Miller. I don't remember if we had him brought over. His lawyer, not here. Good. Okay. The state remains ready, and Ms. Cabrera, this would be a week 2 because of her leave. All right. That's not a change. Mr. Williams, not brought over. And that'll have to go another time. Mr. Craig. Good morning, sir. I don't know your lawyer, so I don't know if he's in here. Okay, I left that open to him, whether he was gonna go to magistrate court first or here. So if you don't mind just sitting tight when Mr. Wilson gets here, I'll hear his announcement. And Ms. Dilligard, you had explained that maybe there was just I don't know if it's miscommunication, misunderstanding as to this working out or not. Where do you think we are right now?
The last email, Judge, that I received last night at 9:15 is that they're taking the plea.
Okay,
So that's
great. We'll see when he gets here. All right, we did not produce position 12. Mr. Dennis. Javon Christian. Don't think we had him brought over. Is that how we left it?
He's here.
Oh, he is here. Okay. He's here. You can talk with him. His final plea rights are preserved. I don't know. It may be that's fascinating, but the offer is 1,000 years. We're going to deal with this case, I suspect, this cycle. And Ms. Clark's going to need to navigate the DNA situation. I don't want you to have to go back to back. And we can't do right the first week. So we'll figure that out. But you can let Mr. Christian know. All right. And then I don't think we brought Mr. Wright over, or did we bring Mr. Wright over? He's here. Okay. Okay. But that's one that we remain good to go. Week 2, the blood spatter expert will be back.
Yes, Your Honor.
From Houston.
Yes, Your Honor. Thank you.
Testifying for the defense.
Right.
In Houston, not here.
Correct.
Yeah,
Yes, sir.
okay. All right.
One thing I didn't bring up the other day was one of our fact witnesses is in custody.
Okay.
There's currently a keep separate order. His name is also Quantavius, but also.
But last name is not right.
Correct.
Okay.
But we'll need, I'll send to your chambers a production order.
But it's production from Rice Street, not production from like Valdosta State Prison. Okay.
But
We'll certainly do that. And as this is gearing up, you can say, probably Tuesday. And we'll have him here each time. And then we'll just work with Deputy Gordon so that they are transported separately and don't bump into each other as best we can make that happen.
Thank you, Your Honor.
Okay. Thanks for flagging that. Mr. Long, we had to move. Mr. Anduke. Good morning, sir. Any word from your lawyer as to where she is?
She said she will be here in about 9:30.
Okay,
We're holding for her report, Judge.
sounds good. And Ms. Dilligard, this was on the list of it's working out.
Yes, Judge.
Okay, hopefully that's not a surprise to you, but when your lawyer gets here, she'll probably talk with the prosecutor and we'll have that conversation when everyone's ready. Mr. Harrison was diversion. Dontius Brown. Uh-oh.
I do expect him here and I expect a resolution.
Okay, please do. And I had an update on Ms. Brown. That's the next position. Ms. Brown, are you here? Maddie Brown? She may be arriving with her son. Oh, this email, you got this email, Ms. Dilligard. So it got forwarded to me. All right. It sounds like these are working out. We don't have Ms. Cabrera, but we would be working out Mr. Brown's case today, even though Ms. Brown's case may not today, only because her lawyer's not here. Okay. Alexander Ikoku should not be here. This is a plea on Friday. Tomorrow. James Kimbro in jail. Here?
Should be a plea, I just need to speak with him and Ms. Clark once more.
Okay. And we expect to see Ms. Clark. She's just stuck dealing with a calendar somewhere. She's not stuck all day.
I don't believe so, Judge. I think she's in Judge Williams making announcements.
Okay. Robert Phillips.
Morning, Judge. That's gonna be a negotiated plea this morning. I just need to finish filling out the paperwork for my client.
Sounds good.
Thank you.
Let me know when you're ready.
Yes, Judge.
Larry Lawson. Hey, Mr. Lawson, how you doing? Ms. Rios, this remains, you're good right there. You don't need to come up this time. This remains ready to go? Okay, do we need to keep Mr. Lawson here at all, or you want to talk to him, or were you wanting to talk?
Something quickly after the call out.
Okay, Mr. Lawson, I remember from the last time we spoke, you were very anxious to have this go away, I think was probably the language you used. But it's going to be a trial unless the state dismisses charges. Ms. Rios told me a couple days ago she's very ready to represent you and take this to trial. So I think you were here when I was explaining that probably is going to be next Monday. But Ms. Rios will get an email letting her know the order in which we're calling the cases. You just need to be, as you always have been, here on time, ready to roll. And trial will be longer than the times we've been together so far. I'm making it up, but it could be 3 days. And so you'll be here Monday, Tuesday, Wednesday, however long the trial takes. Okay? Any questions about that?
Pay for this. I work every day, right? Who gonna pay for this? Is anybody? So I got shot.
Yeah, so Ms. Rios can talk to you about that. I don't think you're gonna like her answer, but if you want your case resolved, then you show up for court. If you don't show up for court, other things happen. But I appreciate that you're anxious to get this resolved. And you've told me before, and you'll get a chance to tell the jury, you got shot. And we'll see what happens from there, okay? But don't leave. Ms. Rios wants to talk to you before you go. Thank you. All right, Coleman and Frederick were resolved. Quantavius Hammond. Hello, Mr. Hammond. Have you been able to, I can't remember if you were moving to mom or you were moving to dad. And has that happened? Not yet. How come? It's been snowing? Okay, it must have more snow where you are than where I am because it's all gone now. But you plan on moving to mom's? Okay. Ms. Wood, what is your announcement on behalf of Quantavius Hammond?
I need to speak with him and have some updates, so I will have an announcement soon.
Great. Okay. Mr. Quantavius Hammond, sit tight. When we take this early morning break, Ms. Wood's going to talk with you before we all talk again, all right? Jaquavius Hammond.
Good morning, Your Honor.
Mr. Kraft, good morning.
Your Honor, I've conveyed the latest offer to Jaquavius. I'm going to speak to him this morning to see if we're going to go forward with that. I do have one matter in front of Judge Barwick at 9:30. It's just a BOP hearing. If I can be allowed to handle that, I'll just be back and forth.
Not a problem. I'm fine with shuttle diplomacy today. Like I said, we're here all day. Just let Jaquavius Hammond know he shouldn't go anywhere because you and he and I and Ms. Dilligard need to have a conversation about what's happening. Before you go, I know you had been receiving discovery through your own means, and that's been shared with Ms. Dilligard. If Jaquavius Hammond says no deal today, I'm hopeful that we can, on one of these 2 weeks, try the case.
I've spoken to Jaquavius that it would probably likely be on the first week.
Okay, as in next Monday?
Yes.
Okay. And you have found that the discovery you obtained was digestible in the brief amount of time you've had it?
I was able to. I don't know about the state because I do think the ADA that was reviewing it is also on trial. So I'm not sure, but I don't think that it's a ton there.
Okay, got it. They have a bigger team than you do, so I'm less worried about them. All right. Then you should go to Judge Barwick, Jaquavius, Hammond, sit tight. Mr. Kraft will be back and we'll see what we're doing today, okay? Thank you. Jasper and Wright, Johnson and Ross. I think Mr. Frazier is the last one on the calendar. Good morning, Mr. Frazier.
Good morning, Judge.
Good to see you again. Ms. Wood, your announcement?
We are ready to go, Judge.
All right. Ms. Dilligard, anything we need to do today, or Frazier is another one that we could have on that list for Monday?
Judge, after speaking with the defense, there's one piece of evidence that we're still seeking. It's a surveillance video, which is pretty important for our case, and possibly for resolution purposes as well. I've requested, it's not in the file, so I don't have it right now. However, I've requested that my investigator seek it immediately and give me an update. I've spoken with the victim, who is very close with the manager at the establishment, and there was talks that there is a surveillance. I'm just still inquiring whether or not it was preserved, if it still exists.
Got it.
So it's but I think it's very pertinent to the case.
Sure.
And so I'm requesting some time to seek that through a little further.
So it's not surveillance video that discovery suggests the police already have. It's surveillance video that might be out there, but in third-party hands.
Judge, the report says that officers may have it. I've reached out to the officer as well as reached out to my personal investigator to work on her own with her own resources. However, I'm not sure because I haven't heard back from the officer, and I've reached out and called, still waiting a response from him. But while I'm working on that avenue, I'm also having my investigator work her hopeful magic.
Okay. But it could be as simple as getting this from law enforcement rather than working through a third party.
Could be.
Okay, could be. All right. I don't know what time means for you and your investigator, but you don't have to keep standing, Mr. Frazier. Thank you. There's a speedy that's been filed, so all the times will be compressed in this case. But I'll keep that in mind as to the order in which we list things for next week versus the week after. And we'll see what happens. And that'll help you prioritize as well, based on how we list them. But the speedy clock ticking means Mr. Frazier's case probably would move towards the top. But we'll figure that out.
Yes, Judge.
All right. Did Mr. Tank make it yet? I saw Mr. Tolles. Hey, Mr. Tolles. Good morning. We're moving on. Your client's not here. Or maybe he's outside.
I expected to be Plea. I expected him to be here. I'll go find out.
Okay, if you check on him, and I know that he sometimes has some mobility issues, so I just want to make sure he's en route.
Yes, sure.
Thank you. And did either of the Browns arrive? All right, I guess during the break, you will reach out for your client, and that may find us Maddie Brown as well. Okay. Was there anyone else who didn't show on the trial calendar that I ought to call again? Okay, let me turn to the inquiry calendar and see what we are teeing up there. I see our first position is Demarion Stewart, and Mr. Brown is here for that, and Ms. Singleton is here. Mr. Rao was here briefly. We'll need someone from the state. This is one of the infrequent but important. Someone reached the age of majority under state law and was sentenced, and we need to figure out what's happening now. And so I want to prioritize this just because we've got Ms. Singleton and Mr. Brown here. So it doesn't need to happen right this second, but it will be one of the first things we do when I get through calling the calendar.
Yes, Judge, and Kelsey Connor Jones is on her way.
Okay,
Is
great.
this a homicide case?
Yes.
It is, okay.
It is.
Okay.
Yep.
I'll let her know, but she was on her way when I pinged her when we were talking about Mr. Abadi.
Okay. Mr. Brown, you ready to go? And once we get Ms. Connor Jones here, you're good to go?
Yes, Lord.
Okay. And Mr. Stewart's here? Not here yet because he's coming from a YDC? Okay, so we will tackle this as soon as we know he's here. And so if you've got other courtrooms you need to be, either of you, let me know. But at some point, we'll get everyone in the same room and we'll tackle this. And Ms. Singleton, I got your report. Thank you.
I do have that hearing with Mr. Kraft and Judge Barwick.
Oh, that's you too. Okay. Why don't you guys go be together there?
Okay.
Thanks. Lionel Bateman.
Yes, sir.
Hello, Miss Taylor.
Yes, sir.
Yeah, no, I'm sorry. I didn't mean to have a collision there.
Good morning, Judge. Happy New Year to you.
Happy New Year to you. So Mr. Bateman has two cases and we needed to confirm that you were representing him on both.
Yes.
You are. All right, let me check our system to make sure we've got entries in both. If not, you're not leaving without filling out one of those forms.
Okay, you should have it.
Okay, I trust you. I'm just gonna look in the system and see what's showing up there. And then we, of course, need to say, is this waiving arraignment in both cases, or does he want to be arraigned? And we'll get them rolling. But let's see what the system says. All right, yes to the case. One case is drug allegations. You are in and you've waived arraignment in that one. And the related case, which is an obstruction allegation, you have waived arraignment and filed an entry. Bravo. Ms. Dilligard, anything we need to know from the state on these? I'm assuming I'll do a scheduling order now, which will trigger a discovery deadline. Ms. Taylor doesn't have any deadlines till that discovery deadline, and then it's motions, et cetera. State is good to go on these cases?
Yes, Judge.
Okay. Mr. Bateman, do you have any questions about what we're doing today? Well, your lawyer's already done this. She has filed entries of appearance. She's your lawyer on both cases. She's filed pleas of not guilty for you in both cases. So that joins the issue. The state's job now is to get to Ms. Taylor all the discovery, whether that's police reports or body cam or drug report, whatever they get to Ms. Taylor, so she and you can look at it to decide, well, what do we do here? Is this one where we file motions, or dang, they caught me, I got to figure out a plea, or whatever it's going to be. You and Ms. Taylor will work on that. I will see you again in court, either because we're working these cases out, or Ms. Taylor's filed some motion that we need to litigate and the state will need to prove some things up. Okay?
Yes, sir.
Any questions about any of that?
No, sir.
All right, let me check one thing on you. So I've got a couple mailing addresses. One is Terrian Way in Decatur.
Yes, sir.
Is that the correct one?
Yes, sir.
Okay. If you move for some reason, make sure you let Ms. Taylor know so she can get us to change the address. Your mail is going to go to that Terrian Way address. And I just don't want you to miss court saying I didn't get anything in the mail. Notice will go to Ms. Taylor as well. And as long as she's got your number, her team will be bugging you anyway. But make sure that that's your address, okay?
Absolutely.
All right. Thank you, Ms. Taylor, for being here.
Thank you, Judge.
Ricky Pierce. Can we bring him out? Don't bring him out?
Yes, we're trying to figure out who represents him.
Well, I'm looking at 3 public defenders right there. I can pick a name.
Well, did the private attorney?
Oh, now I remember. So we do need to bring him out.
Yes.
All right. When you're able in the next minute. Okay, if you can do it, let's bring Mr. Pierce out, please. It's right here on the calendar. It's like, why are you guys looking at me? I hope we didn't bring Mr. New. Did we bring Mr. Newmeister over? We did?
That's good, because I think
Oh.
it was office today.
Well, boom. All right. Does his family know this?
That's, I was gonna let you know, I need to probably call his mom and see.
Okay. And in theory, the state could do that too, but okay. He can be here or at the podium, whichever you prefer. Hey, Mr. Pierce. Good morning. When we last spoke, which was in mid-December, you were telling me that there was a lawyer you were planning on hiring, or your family was, someone, you were going to retain a lawyer. So, all right, we need to be moving your case forward, but I'm going to give you about a month. Now it's been actually almost a month and a half. I need an update from you, because if I look here on in the system, still no entry of appearance, which says to me you have not hired someone. And so we need to have that conversation about, are you representing yourself? Am I appointing a lawyer to represent you, or what?
I have some things that I got wrote down that I like address.
Well, we're going to start with my question, which is, are you hiring a lawyer, or should I?
I'm American State National. I'm a representative myself. I can't be represented by attorney. I'm American State National.
Okay. So you think you want to represent yourself?
I don't have to, because me, I'm not under the jurisdiction of the government. You can let me, I got stuff that wrote down, which is all, this is tied in together. You let me sit my paper down and read it out to you.
So I'm going to let you do that. We're going to do that today. We're just not going to do it right now. I needed to get your update so I could figure out what else we were going to do today. And I'm hearing you say you're not hiring an attorney, but you also don't want an appointed one because, and you'll tell me later, you're an American national. I don't mean to use your words. You're going to tell me why you think you should represent yourself. You have a right to represent yourself, but I have to have a conversation about that. And I'll certainly want you right there where I tell you all the reasons why it's a bad idea to represent yourself. But in the end, it's your call. It's not mine. I won't say no. If you say, no, Judge, I get it. I know that I won't have someone helping me on the outside. I won't have someone who knows all about the law this way and that way. That's okay. That's a decision for you to make. But we're going to have that conversation on the record. And during that conversation, if there are things you want to tell me about the fringe on the flag and whether you're under the jurisdiction of whatnot, I'm happy to listen to that. And we'll go forward. But we're going to do that a little later this morning. Okay? All right. Thank you, Deputy, for bringing Mr. Pierce out. We'll get him back out. So if Mr. Pierce ends up not representing himself, Ms. Feely has been looking for a case. Yeah. All right. I would ask that, I think you'll be here most of the day anyway, but if you could be here, Ms. Rios, while Mr. Pierce and I have that conversation. So Mr. Neumeister, tell me what you think is going on.
We worked with Dr. Norman and we are good to move forward.
And this is a revocation. This would simply be a revocation.
That's right.
Okay.
And he has been working somewhat with Ms. Ross, and so I've spoken with her. I want to speak with him, and then I want to touch base with his mom, who I've had contact with.
Good.
And then I'll look for it out. But I think we're going to resolve it today.
That'd be fantastic. Ms. Dilligard, Mr. Neumeister's cases are very old, as you can see. It's a 17 SC and a 19 SC. Have you familiarized yourself at all with these?
No, Judge. I believe this would be an SAU case, which would be Miss Nix.
I don't see Ms. Nix.
She's in Judge Williams, and
okay.
reporting here right after announcement.
Okay. She'll remember it a little bit, but it predates her too. Mr. Neumeister has struggled with a lot of mental health issues, and when he's not taking care of them well, it gets problematic for his family. So all of the victims here are I think it's just mom, but it's a internal household thing. It's not stranger, which is why you've heard Ms. Wood say, I'm going to try to get it. I'm familiar with his mother. She's very supportive, cautiously supportive of Mr. Neumeister's situation. So I'm glad Ms. Wood's been in touch, but someone on the state side probably wants to dial in on the victim side as well. So if you could alert Ms. Nix that we may well be handling Mr. Neumeister's case. It's been on many, many calendars where we've simply said, how's he doing now? And the answer was, he's not ready yet to engage in a meaningful way. But it sounds like today he may be, which is great. He has been in jail for a long time. on this revocation. And really the goal has always been, is there a safe, stable place for him to be? And maybe that's been found. So it would be great if we could have that conversation today, but I don't know why I'm telling you, because it's going to be Ms. Nix.
Yes, Judge, we're texting her right
All right, thanks. All right, Samantha Harley. In custody, Judy Kim. I thought she wasn't taking cases anymore. We don't know. Let's see if I got a text from Ms. Nelson. Nope. All right, well, we'll see what we can learn from Ms. Nelson about Judy Kim's availability. So Ms. Harley's in custody. She's in the building. Okay. Do we have an update on Mr. Stewart in the building yet? No? Okay. Yeah, I know you've been busy. Mr. Statum, we have a bond hearing?
Yes, if that is not resolved, I've been talking.
We might work it out.
Yeah.
Okay. And Mr. State, I don't remember this case. It's just that it seems like it's old, although the booking number is new. I was looking at these charges. There's not an issue of you and Mr. Statum connecting. It's just, is there a disposition that would work out?
Yeah, so
Okay.
He was the one, I think early in December when he was brought over, who had been in prison and was in drug court, and they revoked him from drug court.
Okay.
And so he did 2 years on a revocation. He has 2 cases. One is not on the calendar, but we would do a global resolution for both cases.
Okay.
We're just trying to work out what it would be, but I think he was to have this done with.
Okay, great. Yeah, you're definitely gonna be here all day. Daily Strickland. Oh, okay. Ms. Wood, this said inquiry. I'm just not remembering.
So he's here on a production order from Gwinnett County.
Oh,
He was actually already, I think I asked for the production order to have him brought here so we could have DBHD engage with him. However, I spoke with Ms. Green and DBHD went to visit him at Gwinnett. So they've already done the interview, now I'm just waiting.
oh, just waiting on a report. Okay, so, okay, I see. So he was brought over proactively to say this would be the easiest way to connect with DBHTD because Ms. Green has that good pipeline into our jail. But lo and behold, they did their magic already. Would it help if I spoke with Daily Strickland? Okay.
Because I haven't seen him since he got here. So
Okay. Any sense of how that will go?
let me see, Judge.
Okay, all right. If you could bring Mr. Strickland to the door, please. Hey, Mr. Strickland, how are you?
Good.
Good, I'm doing well. Thank you for asking. I'm Judge McBurney, and we may have seen each other on a screen once before. I'm not sure, but I have your case, and we had you brought from the Gwinnett jail to the Fulton jail so that you could meet with some doctors. But it turns out you already met with those doctors when you were at Gwinnett, and we didn't realize that. So I just wanted to explain why you've been moved around some. Ms. Wood, is it your sense that Mr. Strickland will go back to Gwinnett?
Yes, Judge. The case that he has in Gwinnett is further along than where we are.
Okay.
Yes, we'll be.
Got it. So Mr. Strickland, you'll be going back to Gwinnett to work on that case. In the meantime, those doctors who talked with you are going to be preparing a report for your lawyer and for me. We're the only ones who'll see that. And that'll help us figure out what we're going to do, if anything, with the case that you have here. And it may be, if we are able to move forward with your case here, that your lawyer in Gwinnett works with Ms. Wood to see, is there a way we can resolve everything together? But what I wanted you to know is you're going to go back to Gwinnett. We didn't mean to waste your time. We just didn't know the doctors had talked to you in Gwinnett we thought they needed to come here. So you'll go back to Gwinnett, we'll look for that report, and then Ms. Wood will let you know what's happening next, okay? You bet. You bet. So if we set this out 60 days inquiry, okay. Bryant Murray. Hey, Mr. Murray, how are you? Well, you've heard me, I'm doing all right. I think when you and I last spoke, there was a question about whether you were going to be hiring a lawyer. Is that correct? Am I remembering correctly? No. You had plea and arraignment on the 5th of December. So you were either here in court or you were on a screen. Otherwise, I would have issued a warrant for you. So we wouldn't have skipped this one. But let's not worry about that. The question is whether you're hiring a lawyer. You have another case. Who represents you on your other case?
I just got my time plate. We did that like on the 15th.
Yeah.
Yeah.
And who was it who represented you?
I think Ms. Cabrera.
Let me look it up.
This is Cabrera.
Oh, Ms. Cabrera. Okay. And
She's also, I emailed Ms. Cabrera on this case and showing her that when our office did a conflict on it, so, and I think she was looking into something else, but it should be with conflict.
yeah, okay. I don't know why we didn't resolve both your cases at the same time. Maybe just because they hadn't figured out who's going to represent you. I'm looking at your other case. You did resolve that a few weeks ago. So is there any reason you're aware of, Ms. Rios, why this wouldn't naturally go to Ms. Cabrera, other than people have not handled the paperwork?
I don't know, this was placed on the calendar, I think, to figure out if it was conflicted off, and then I looked in our system and showed that it was conflict, we did a conflict earlier last year, and so then I emailed her, letting her know and showing her the conflict, so I'm not sure.
Okay, this came to us in October from non-complex, but you clearly conflicted off the case that Mr. Murray just resolved. So I'm going to assume Ms. Cabrera can handle this case, but Ms. Nelson can work with her. And I want to get Mr. Murray out of here. You don't have to stick around. You still live on Lumbee Drive?
Yes, sir.
Apartment 1023?
Yes, sir. He called the close for me because I'm still, you know.
Okay, 30334. Okay. Ms. Cabrera knows how to reach you, I guess, because you all worked together on that other case. And so I'm going to confirm that she's going to handle this case for you. I'm looking at the charge. It seems pretty resolvable. So we just need to get her plugged in. She's on leave right now. She'll be back sort of in the middle of next week, although she is able to do some things on email. So I'm going to have my staff reach out to her, say, is there any reason why you can't handle Mr. Murray's other case? And if she says, no, it's appropriate for me to do that, then we'll put this down again to get the case moving along so that you can get it resolved. All right. But keep her contact information because that's probably who's going to be reaching out to you.
Okay.
How'd you know to be here today if you don't get mail?
You remember I told you the last time I had came to the court, they told me my last trial date, and they told me you got a court date tomorrow.
Yeah.
You remember that?
I do. Yeah. Like, yeah, what a crazy coincidence that you walked in like, you don't have anything today, my friend, but tomorrow you better be in court. So did you show up in court yesterday? And they said, hey, yeah, come back tomorrow.
Yeah,
okay. All right. Hold on. I just got an email in connection with your case. Okay, yeah, they are exploring why it's not with you already. Okay? All right, I appreciate you being here. You are free to go. And I will not have you come back here till we know for sure who your lawyer is so we can move it along. Thanks. You too. That's it for that calendar. Did Mr. Tank make it yet? Mr. Tolles, any update on Mr. Tank? Okay, he's in the building. Okay, great. All right, and how about Dontius Brown? Good morning, sir. And Maddie Brown.
Yes, sir, and I apologize.
It's all good. Mr. Brown, I've been told your case is probably working out today. Ms. Brown, your lawyer is actually the same lawyer I was talking to this gentleman about. She has a leave and can't be here today. She tried contacting you, but it sounded like you had already left to be coming to court to say, hey, I can't be here. But you may have been coming anyway because Mr. Brown was coming. But we're not able to, your lawyer told me it sure looks like your case is resolving. But she's not able to be here today. So we'll need to do that on another day. It'll be during the course of this trial calendar. So in the next couple of weeks, it just won't be today. But I think, Mr. Brown, we are resolving your case. You'll need to speak with Ms. Wood, who just said, I'll talk to you. And that's what we'll do. Okay?
Okay, thank you so much.
You bet. Is there anyone here who did not hear their case called? Hi.
Yes, Your Honor, I would like to make an announcement to the court.
Sure.
I'm turning in the house car and my client.
Thank you so much.
You bet. Mr. Phillips. I'm looking. I see Robert Phillips. But there's a.
Yeah, we represent Mr. Phillips by opposite.
Okay, I had a notice when I represented on the previous case. I had a notice for this case. Also, if I could chat.
Yeah, you guys should talk because I've already heard, hey, his case is working out.
Let me just speak with her.
Sure, Mr. Phillips is a popular guy. Okay. Anyone else not hear their case called? Okay, then it sounded like we don't have Mr. Stewart yet. Once we do, Mr. Brown will tackle that, assuming we get Ms. Singleton back in here. Ms. Nix, good morning. Mr. Neumeister may be able to go forward with his revocation today. But Ms. Wood was going to try to connect with his mother, who's probably who you'd want to talk to as well. I think that was the main matter of you may have something on the trial calendar as well, but on the inquiry calendar, it was Neumeister. And Ms. Dilligard's eyes got really wide and he said, oh, wait, never mind, that's Ms. Nix. So I know you've been sort of plugged into it. It actually was resolved well before your tenure as well, but it's yours.
Yes, and Ms. Clark and I we'll discuss it and we'll
Okay.
we'll work on it.
Great. Okay. Anything ready right now, or should I give you all that time you need to plug in with folks? All right. Not hearing anything ready right now. I'm gonna go work and let Deputy Gordon know once something is ready, maybe a couple things, or we get Mr. Stewart here. Oh, he's here, but you got to go get him. So I got to get off the bench anyway. So we'll take about 15 minutes, and when I come back, we'll do Mr. Stewart, although we need a prosecutor for Mr. Stewart. Oh, yeah, where's Ms. Jones-Connor? It's, oh, you get, okay, 15 minutes, okay? Yeah. Not for Mr. Tank, he's good.
Okay.
Well, the colloquy with the prosecutor is sufficient in Mr. Tank's case.
We'll be ready when you come out.
Okay, good.
And Judge, may I be excused?
Yes,
I
ma'am.
will be available if Mr. Wright wants to take a plea, though.
Okay, let us know.
Thank you, Judge.
All right.
You okay? You okay?
Yeah.
Here's what I conviction. It's not. Did you agree to fire?
No.
Okay, so she didn't agree. Kick it.
Hi, how are you?
Hi, Crystals. Good.
All right, so the only thing we were stuck on is the moving, right?
Yeah. That's why.
Still working on it, it's awesome. But he told me we could still put it up and let judges decide on that one condition. I have been back to yesterday, I can try her.
That was a quick 15 minutes.
Um,
I signed up for.
So I spoke to Casey says what call today. You will come forward saying, are we moving forward? Are we moving forward? Are you going to get EEO? And, first of all, the cost of the area, I mean, I'm ready to go with you and if I was there, only be one, person, that was just recommended by a while. That's like, make it close to yeah, I would say, I would be more positive or something like that. There's something wrong with it.
pleas, and then we'll listen.
That's
All
what I'm.
right, let us refocus. That was more than 15 minutes. These breaks expand. I see Mr. Brown, I see Ms. Hudson, Ms. Singleton, and I know Mr. Stewart is here now. We just need a deputy. And then Mr. Tank will be next. I saw Mr. Tolles, he may be getting his client. Then we'll do Phillips. And Ms. Kim is here, so we'll talk about that. So we've got things to do. So let's.
It's like 5 minutes.
Okay, then we'll pivot. We'll probably do one of these other things first while you're doing that.
That'd be fine.
Perfectly appropriate.
That's why I make sure you know, so no.
Pardon me?
I want to say I arrived and I signed up for a plea on Elijah.
Oh, great, thank you. And it's ready, like signed up as in it's ready to go. Okay, good. So let me put a little mark. We can do Anduke, we can do Tank. Did Mr. Wilson ever make it? We don't know yet. His client didn't disappear. Ms. Kim, we're gonna handle your situation and then we'll start with Tank. And then once Mr. Brown is ready, we will take up Stewart. Let me find your case, other calendar. Ms. Harley. Okay, so it was on a trial calendar and she disappeared. She's in custody. I guess we need to figure out what's happening. Why don't you give me a heads up, then we'll bring Ms. Harley out. We can't really do anything till a deputy returns.
I think she's still downstairs. I just asked the deputy.
Okay, well, I know they were bringing up Mr. Stewart. He told me they were bringing up Mr. Stewart and Ms. Harley.
Right.
So that may be why they're not quite at the door yet. But while we're waiting for the elevator to arrive, what is it you're hoping to do today with Ms. Harley's case?
I've spoken to the state. I think they're still trying to make victim contact. I'm hoping you will hopefully allow me to adjust bond.
Okay, that might be tricky with the no victim contact, but I guess we could have the conversation and I could give the state 48 hours to reach a victim or whatnot. Am I correctly remembering, remember is the wrong word because it's happened long ago, but basically the facts were we had a court date, I think it was a trial calendar, and Ms. Harley didn't show. And so there's really nothing's been happening since then except a year and a half passed. She got scooped up either on a bench warrant or for some other reason and is stuck in custody.
That's correct.
Are you aware of whether there's anything else keeping her in custody besides the bench warrant?
No, I know she picked up a misdemeanor and I think that's resolved already. She's on probation, so I think
Okay.
that's why she got arrested.
Got it. So arrested for some misdemeanor conduct, bench warrant has grabbed her and she's stuck with that.
That's it. Judge.
Okay. Got it. Well, we will take care of that. I don't know the order in which we'll do it, but why don't we start with Mr. Tank then while we're waiting for Mr. Brown to be able to see Mr. Stewart?
Would you mind if your sister?
Not at all.
I'm 79 years old.
Sure. Mr. Tank, you should come on up here, take your time getting here, and your sister's gonna come with you. If it would help to have you sit rather than stand, our conversation may be about 10 minutes long. Can you stand up here or would you rather sit?
No, I like that.
Okay, come on up and be by Mr. Tolles, please.
Stand right here. No, come on. All the way.
You're welcome to be, if it helps him, you can be right there.
Thank you.
Sure. Ms. Rivers, good morning. Are you ready to go?
Good morning, Judge. Yes, I am ready.
Excellent. This is position 2 on our trial calendar, State versus Marvin Tank, 22 SC 184534. Mr. Tank is represented by Mr. Tolles, who's here in court with him. Ms. Dilligard is handling this for the state. Mr. Tank, I'm Judge McBurney. I've seen you on the screen a bunch of times, but now it's in person. Mr. Tolles tells me that you're ready to enter a plea in your case. Is that correct?
Yes.
Okay. Ms. Dilligard is going to put you under oath in just a moment, and she's going to ask you a bunch of questions. I need you to answer those questions to the best of your ability. If at any point you're confused by something that's asked, or you can't hear it, or anything like that, will you let Mr. Tolles or me know that?
Sure will.
Great. And if you ever need to sit, let me know. For now, we're going to keep you standing right there, okay?
All right, good.
Sounds good. Ms. Dilligard, when you are ready.
Mr. Tank, please raise your right hand.
Right.
You swear or affirm that any statement or testimony that you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
I do.
You can lower your hand, and please state your true, correct, and legal name for the record.
Marvin Joseph Tanks.
Mr. Tanks, are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No.
You're not taking any medicine?
Yes, I'm taking medication.
Okay. Tell me what you take medication for.
High blood pressure and 1 pill of high blood pressure, 1 pill for diabetes, and sleep medication.
Okay.
Triple.
Did you take any sleep medication in the last couple hours?
No, that was last night.
Okay, so it helps you go to bed at night.
Yeah, 9 o'clock, take it every time.
Okay, does the blood pressure medication or the diabetes medication, does that make you woozy or confused?
No, I've been taking it since the late early 70s.
Okay.
When I came home for the war, I got on the medication, so.
Okay, so you are understanding what we're talking about?
Oh, yes, sir, I do.
Thank you.
Yeah.
Well, can I interject one question,
Please.
sir? Do you take any medications for any type of mental health or?
Yeah, I'm a triple.
Okay.
I take for.
What do you take that? What is
post-traumatic stress? I have post-traumatic stress disorder.
Okay, PTSD, you
Yes,
take
sir.
medication for that?
Yeah.
Did you take that medication, when do you take it, morning or night?
Morning, nighttime. Now, he said everything 9 o'clock at night.
9 o'clock at night. Did you take it last night?
Yeah.
Okay.
Yeah.
Thank you, Mr. Tolles.
Mr. Tanks, how old are you?
78. 79, I'm sorry.
And how far have you gone in school?
High school education. I also went to military school when I was in the military. Being out there seeing stuff.
Do you understand that you've been charged with the following offenses? 1 count of aggravated assault and 1 count of possession of a firearm during the commission of a felony.
Yeah, I have the firearm in the car.
So I want to make sure we answer your question, but the question that you have in front of you is, do you understand what you're charged with in this case? And
yeah.
Charged with 2 things. You're charged with supposedly pointing a gun at Ms. Fannie Smith. That's the aggravated assault. And then you're also charged with having a gun when you did that, because of course the claim is you pointed a gun at someone. You understand the 2 things you're charged with?
I understand what you're saying.
Okay. Now, did you have a question about that?
No.
Okay. We'll keep going.
That's what happened.
Okay.
I ain't got to be sad and die about it. Yeah. All right. In the car.
Well, we'll get to that in a minute. Let Ms. Dilligard keep going.
We did down there. We always have kept weapons, a lot of weapons around.
Okay. We'll talk about weapons at the end.
Yes, sir.
Okay.
Always have.
Answer her question.
Okay. Do you understand that you have the right to plead either guilty or not guilty to those charges we just stated?
Yes. I'm here.
Do you understand that if you plead not guilty or remain silent and refuse to enter a plea at all, then the state is required to prove those charges against you at a jury trial?
No, I want no jury trial.
But do you understand that if you wanted to plead not guilty, we would have to prove these charges at a jury trial?
I understand. I understand.
Have you had an opportunity to review the waivers of rights form with your attorney?
We did not do one.
No, I told Mr. Tolles they didn't need to do that because you'd be covering it.
Have you had enough time to speak with your lawyer about all of the charges that are in this indictment?
Yes, I have. Yes.
Would you like more time to discuss the case with your lawyer?
I agree with what he got, what he got said today. I'm going along with that. I agree with all of that. Things look pretty good, but I like it.
Are you satisfied with your lawyer's services?
Yes, I am.
Counsel, do you waive formal reading of the indictment for purposes
Yes, we
of the
do.
plea? Do you waive any and all defects in the indictment for purposes of the plea?
Yes, we do.
Mr. Tanks, do you remember being arrested on these charges?
Well, yes, I do. Yes.
Has your attorney advised you of the minimum and maximum sentence for each charge which you are pleading guilty to today? So you're charged with aggravated assault. The minimum and maximum on that is 1 to 20 years. However, we've agreed to reduce the aggravated assault to disorderly conduct, which is a maximum of 12 months. And then we also agreed for the possession of a firearm normally is 5 years consecutive is the maximum. We've agreed to reduce that to pointing a pistol under OCGA 16-11-102. The maximum on that is 12 months. Do you understand that?
Yes, I understand what you're saying.
Do you understand that today you are entering a negotiated plea of guilty, which means that the state will recommend the following sentence to the court? To judge on count 1, we agreed to reduce it to disorderly conduct under OCGA 16-11-39 for 12 months probation. On count 2, reduce the pointing a pistol under OCGA 16-11-102 for 12 months probation consecutive to count 1 for a total of 24 months probation.
Okay.
The conditions we've agreed on all, but there's one that's kind of looming that we're going to leave in the discretion of the court.
Okay.
So no contact with the victim, to continue with his VA treatment plan, and to take all prescribed medicines determined by that plan. Also, any additional treatment required by probation. No drugs or alcohol unless prescribed, and no firearms or replica of firearms. The one condition that is kind of in the loom, which was one of his bond conditions, was to move from this incident location. The victim still lives there as well.
Oh, okay.
And so that would be the request of the state. However, we do understand that Mr. Tank's age and ability to move is stipend, so we'll leave that condition up to the court.
Okay. It would make no contact pretty complicated if they live in the same place.
Yes, Judge. My understanding is that it's speaking with defense counsel, it's a large apartment complex. They live on opposite ends.
Oh, so same place doesn't mean it's a 3-bedroom house and Miss Smith is in one bedroom and Mr. Tank is in another. He's in unit G17, I'm making this up, and she's in A9, but it's the same apartment complex. Okay, we'll talk about that more.
Do you understand that to be the recommendation that myself and your attorney discussed?
Yes.
Okay. Do you understand that the court is not required to accept the state's recommended sentence?
Yes.
Do you understand that the court has the right to sentence you to the maximum possible sentence on each charge? You have to say yes or no.
Yes.
Do you understand that if there are multiple charges to which you're pleading guilty today, that the court also has the right to run those sentences consecutively?
Yes.
Do you understand that if the court decides to order a sentence that differs from what you were expecting, that you have the right to withdraw that plea?
Yes.
Do you understand that if you're currently on probation or parole, your probation and parole may be revoked based on your entering of a guilty plea today?
Yes.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Understand.
Do you understand that if you're on probation, you must follow all of the special conditions of your probation?
Yes.
Do you understand that if you fail to follow all the special conditions of your probation, then you will be subject to revocation and of that probation for the balance of your sentence?
Yes.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Are you a United States citizen?
Yes, I am.
Do you understand that by entering a plea of guilty today, you're waiving any and all defenses, including any mental health defense?
Yes.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to the assistance of counsel, the right to the presumption of innocence, and the right to appeal if convicted of these charges at a trial?
Yes.
Is it your decision to waive these rights, which means not to use them, and enter a guilty plea today?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes.
Mr. Tanks, how do you plead to the reduced charge of disorderly conduct and the reduced charge to pointing a pistol in indictment number 22 SC 184534?
Yes.
The question is whether you're pleading guilty or not guilty. If you plead guilty, we move forward. If you plead not guilty, guilty. Okay.
Yes, sir.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
You understand that you only have a limited right to appeal this guilty plea conviction?
Yes.
You understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
Yes.
Do you understand that for a misdemeanor charge, you only have 12 months from today to file a habeas corpus petition?
Yes.
Judge, if this case were to proceed to trial, the evidence would show that on August 5th, 2022, Atlanta Police Department responded to a dispute call at Oglethorpe Place Apartments. The victim is Fanny Smith, stated that she was walking her dog and disposing of his poop in a receptacle near the defendant's vehicle. According to Ms. Smith, the defendant rolled down his window and asked why she was so close to his car. He then reached over and grabbed his firearm and pointed it towards her. Ms. Smith denied having any previous issues with the defendant, and all of this occurred in Fulton County, Georgia. State has been in contact with the victim. Victim's wishes is primarily for the defendant to receive the treatment and help that is needed. And that is all from this.
Okay, appreciate that. Thank you. Good morning, Ms. Jackson. How are you doing?
Good morning, Your Honor. I'm well. How are you?
I'm all right. Do you have any criminal history information on Mr. Tank?
Yes, sir. He has 9 cycles. The last arrest was July the 14th, 2023 in Fulton County for a failure to appear. The underlying charge was not listed. He did receive first offender treatment in 2018 for aggravated assault and possession of a firearm during commission of a felony. That case was sealed February the 14th, 2023. He does have 1 misdemeanor conviction that was in 2008 for disorderly conduct. Nothing in addition, Your Honor.
Thank you, ma'am. So, Mr. Tolles, share with me what you want to, and if you have information about it, let me know a little bit about this first offender. Charge-wise, it sounds awfully similar to what this is, and I just want to make sure we're going to keep that apartment complex calm and that Mr. Tank doesn't have a proclivity of getting frustrated about something that maybe he misapprehends, and then all of a sudden there's a gun brandished.
Understood, Judge. The issue, Judge, was that he possessed a gun. And in his mental health condition, that should have never been, that was probably like mistake number 1, because I don't think it was.
Probably 1 through 10, right?
Yeah, because he's PTSD, he's being seen by a doctor, his age, and he's getting up there in age. And so he should have never even had a gun. And so both cases, I think, were probably like similar, like where because of his PTSD, it was triggered by the young lady being behind him. It wasn't anything that was targeted at her. They never had any issues or any problems. It was just that paranoia of just having someone behind him and behind his car and so close, because that was the question that was posed, like, why are you so close to my car? It was more of a paranoia thing. And so that's when the gun was produced. He never meant the victim any harm. And in the time that after he's gotten arrested, or anytime that he's been on bond, he's never done anything to her. I remember at a hearing, she had mentioned coming in contact with him one time. And then upon him seeing, he walked the other way, which is what you're supposed to do. Mm-hmm. And so he's not a harm to anyone, Judge. And now that his family is, and I think when he was with mental health court for a veterans court for a little bit, they went in, what is the word I'm using? Approved his home. They approved his home. And so for a very long time, even during this case, there was no provision for him to not be in that home. It was just that when he had gotten revoked because he didn't successfully complete the veterans program, largely in part because you could tell he's not the type, he's not going to be able to sit down in front of a circle and things of that nature and talk about it just wasn't the right program for him, so he got revoked. When we were trying to get him his bond reinstated, the victim had come up and had just said something about that. But this is like almost a year and a half into the case, but she did not provide any information that Mr. Tanks ever threatened her or anything. My argument would be that that's why we have, the aggravated stalking statutes. Mr. Tanks has lived in his house for 10 years, and so and it's his home. It's everything that he has, and with his age, it was hard for him to move out. And then when his family tried to get him a new place, that contributed to a lot of his incarceration. Nobody would do it because he had all these pending charges, the aggravated assault, things of that nature. And he also gets assistance with the federal government to get reduced housing. So it was a hardship, and I think it was an unnecessary hardship because he's not in any way harmed. I don't even know if he saw her again, would he even know who she was? Because I think that question was posed, like, did he recognize you? Did he appear to recognize you? She wasn't sure. And so I'm asking the court, he's been there, Judge. He was on the ankle monitor as well, all this time as well. And all he's done is, he's pretty much on house arrest except for his appointments. All he's done is just go home, go to his doctor's appointments. He's not bothering anybody. Guns isn't an issue. So we're asking the court to follow the recommendation, but allow him to live in his home. It would be a great hardship. And I'm just hoping that you can just see by my client's demeanor that, he's up there, Judge, and the mental health is there. And so, but he's got great family support. His sister always comes to court with him. They make sure that he's doing right. And I think that since the 2.5 years that he's been on bond, he's not had a firearm. He hasn't had any more assault cases. He hasn't had anything. And so I just think it would be unnecessary. I thought it was unnecessary at the time. I would still think it would be unnecessary to remove him from his home of 10 years. And so in light of the fact that the state has now prosecuted this as a misdemeanor and understands that it wasn't any malicious intent against the victim, that it was more PTSD based, that I'm asking the court to follow the state's recommendation, but allow him to stay in his home. Obviously, a strict no contact order with the victim, and she can be advised that if there's any harassment, intimidation, or anything like that, contact the DA, contact the police. We'll get an aggravated stalking warrant for him immediately, and then we can move him to the Fulton County Jail. But that's not going to happen. That's not going to happen. And so another thing that we'd ask for, Judge, and I talked to the state about this earlier, was that we're asking for credit against that sentence for the time he served, because he did do, I want to say, she said 160.
I've got the numbers here. I'm going to talk about that with Mr. Tank.
Yeah. And just give him credit for the time that he did serve for the 2 stints that he was in. But Judge, it's been an honor and a privilege working with his family. Mr. Tank served this country. He did a lot of things that a lot of people didn't want to do, and he came back and he's paid an ultimate price. And so I would ask the court to recognize his service and his sacrifice and allow him to live out his golden years. We've gotten rid of the guns, so I don't think there's, again, any issue. So I would just ask the court to rule as, but allow him to and give him credit for the time he served. Thank you.
All right. Thank you. Mr. Tanks, I have a couple questions for you, and then I'm going to see if you have any questions. First, who is here with you?
This is my baby sister, Abundance Tanks Hood.
Last name is Hood?
H-U-I-T-T-E, Hewitt.
Hewitt.
H-E-W-I-T-T.
All right, Ms. Hewitt, thank you for being here. You don't live with your brother, but you're here to help support him. Is that correct?
Yes, we've done this constantly and consistently. throughout this entire process.
Does anyone live with your brother in his apartment?
No.
Okay. Mr. Tanks,
I'm 7 minutes away from him.
you're close. That's good. Mr. Tanks, do you get disability or social security? How do you get food on the table in your apartment?
I'm disabled by the government, and I'm retired from the post office and board education.
Okay. So you have a pension?
Oh, yes, sir, yes, sir.
Okay.
Yeah.
All right.
Disabled, Vietnam best.
Got it.
And seasons.
You served overseas in Vietnam?
Yes, I served in Vietnam.
Okay. Well, I appreciate your service.
15 years, in all.
Do you have a driver's license?
Oh, yes, sir. I have a driver's license.
Do you drive?
Yes.
What do you drive?
07 Buick.
How often do you drive your 07 Buick?
Yeah, yes, sir.
How often did you drive it here?
No. My sister brought me.
Okay. Why would you be driving? What do you need to drive for?
Bank.
Okay.
All that what people mean most of them.
Your basic needs.
Yeah.
Okay. When did you last have a driving test?
I think last year. I had two. I got 2045. I got a brand new life just now.
Okay.
Brand new life.
Are you wearing an ankle monitor?
Oh, yes, sir.
All right, that's going to come off real soon.
Yes, sir. I appreciate that. This big 31 anyway.
Okay.
Because I was in the program.
Do you have any guns in your apartment?
No, sir. No, sir. No guns.
I've asked what I need to ask. Do you have any questions?
No.
No? Well, Mr. Tank.
That's fine.
Okay.
I live with that.
Mr. Tank, I find that there is a factual basis for your plea, meaning, based on what I've heard from both the prosecutor and from your lawyer, it sounds like you got a little upset with this lady and did something you should not have done. I also find that your plea is what we call knowing, meaning you've understood what we talked about, and voluntary, meaning no one's forcing you to enter this plea, but you're ready to be done with this.
Yes, sir.
Okay. Then I'm going to accept your plea. Mr. Tolles, is it all right if someone from my office signs the indictment indicating the guilty plea to 2 misdemeanors?
Yes.
Signs for you.
Yeah, we have no objection to that.
All right, Ms. Dilligard, can we sign for you?
Yes, Judge.
And Mr. Tanks, is it okay if we put your signature on the document indicating that you pled guilty to the 2 misdemeanors?
Yes, sir. That's fine.
We'll do that. I'm going to sentence you as follows, Mr. Tank. You spent 6 months in jail when you were first arrested on this. You were arrested on or about the time it happened, and you didn't get out for 6 months. So I'm going to give you credit for those 6 months. I'm going to sentence you on count 1, which has been reduced to disorderly conduct, to 12 months to serve 6 months with a balance on probation. Count 2, which has been reduced to pointing a pistol, I'm going to sentence you to 12 months probation. That's going to run consecutive or after your other sentence. So basically, you're going to have 18 months, a year and a half of probation. I am waiving your probation supervision fees. Basically, the government is paying you. We don't need to then move that money to another part of the government. So you'll have no supervision fees. The most important condition of your probation is that you leave Ms. Smith alone. You know where she lives in the apartment complex?
I don't even know her.
Good. So, but if you see her, just turn around and go the other way, okay?
I sure will.
Good. Number 2.
I don't know nothing about it.
Let's keep it that way. Number 2, I want you to keep up your treatment at the VA.
Yes, sir, I do that.
And any medication that your doctors prescribe, you take that medicine.
Yes, sir.
If it makes you feel bad, you talk with the doctor and they'll give you different medicine, but you don't decide all by yourself, I don't need this medicine anymore, okay?
Yes, sir.
Finally, no guns in the household. It sounds like there are none, but don't go get any either now that you're getting this ankle monitor off.
Yes.
If someone finds a firearm in your apartment, to me, that's almost as bad as you bothering Ms. Smith, and there'll be bad consequences for that. Otherwise, you live your life as you've been doing it for 79 years, mostly staying out of trouble, serving our country. And as Mr. Tolles put it, you're in your golden years. You may even be like in your bronze years by now. So I want you to stay safe and take care of yourself, and you leave Ms. Smith alone, okay?
Yes, sir. I'll make sure I do that, sir.
All right. Now, misdemeanor probation probably will just be something you do over the phone. you might once, with your sister helping, you have to go meet them. They have an office about 2 blocks from here. But they're probably going to reach out to Mr. Tolles to say, how do we get in touch with Mr. Tank? And Mr. Tolles is going to help build that bridge. Do not ignore probation, because if they can't find you or you're not returning their call or doing whatever they need you to do, then they reach out to me and then I get frustrated. Mr. Tanks, all you need to do is call them back. So make sure you follow their directions, okay? And if at any point you're confused by it, you reach out to Mr. Tolles. He can help you navigate it.
I make sure I remember that.
Ms. Dilligard, anything else on behalf of the state?
Nothing further from the state.
Mr. Tolles, I'm assuming it's a county-funded ankle monitor, which means now it's Second Chance that is the entity that will be removing that. And so I'm going to rely on you to reach out to Second Chance, the bonding company, and they'll give Mr. Tanks instruction. They probably won't come to him. He'll need to go to one of their offices to get the ankle monitor off. But the ankle monitor's been on for so long, it probably was a different bonding company back when it went on. Your brother's not paying for the ankle monitor, is he?
Yes, sir, he is.
Oh my gosh, he is. Okay.
$305.
Well, that's going to end now. That's a lot of money. And I take back what I said about Second Chance. If he's paying for it, it may be a different vendor. I don't know. You'll know he's paying that money.
We know it's Telex.
Oh, Talatrix. Yeah. So you reach out to Talatrix. If they don't immediately say, here's what we're supposed to do, let Mr. Tolles know, he'll let me know, and I will lean on them, because that should be no longer a stream of income for them or an expense for your brother. Okay. Mr. Tolles, anything else on behalf of Mr. Tanks?
Yes, Judge, the 180 days that you did mention, there was an additional, another.
There was, because he didn't come to court. So I'm giving him credit for the time I'm going to give him credit for, and he's going to be on probation for 18 months.
It wasn't that he didn't come to court. It was because he got revoked.
Whatever happened, it may have been the Veterans Court situation.
Yes.
Be that as it may, that was separate conduct, unrelated to, he was in for 180 days to the day on these charges, unable to make bond. He bonds out, he's in Veterans Court. That ends in a way that's not favorable for your client, but those consequences are due to different conduct and not the conduct that forms the basis for his plea. So I heard you, and I see the numbers here. I'm giving him credit, getting rid of 6 months of that probation for the dates in custody that are directly related to what happened with Ms. Smith. And then that just gives us an 18-month buffer to make sure you are doing what you need to do and Ms. Smith is able to do what she needs to do. You're not paying supervision fees. And really, other than maybe having to call probation once a month, this is going to be pretty low impact. No ankle monitor, nothing. Okay?
Thank you.
Mr. Tolles, anything else?
No. Well, there was. What is the piece of paper he's going to need to show? The ankle monitor? There'll
be a final disposition that I will sign probably today. Today's a little zany. I might file it tomorrow. Ms. Nelson can get you, if you can't get it through Odyssey, Ms. Nelson can email you a PDF of it. But my guess is Talatrix will say, where's the final disposition? So it may be a day or two, but I'd call them today saying, hey, my brother just pled guilty. What do we need to do? And they'll say, where's the final disposition? I'll get that to Mr. Tolles. Mr. Tolles can get it. I don't know how he'll get it. And then they'll just need to see that.
Come through Odyssey.
Yeah, it'll definitely come through Odyssey. And if you're able to get that, then you just get that to Mr. Tanks or his sister, and Talatrix should do what they need to do. All right?
All right.
Thank you, everyone.
Thank you.
Good luck, Mr. Tanks.
All right. Your Honor, that's my only case. My big excuse.
Yes, sir.
Thank you.
Good seeing you.
Good seeing you too.
Mr. Brown, you were able to speak with Mr. Stewart.
I was.
Okay, and we have Ms. Hudson. Great, Ms. Singleton. And we have a prosecutor. Excellent. Let's bring Mr. Stewart out. After that, we'll do Mr. Phillips and then Mr. Anduke. And I think you're Mr. Wilson?
Yes, sorry, I think you were told I was stuck down the magistrate court for a little bit.
Sure, yeah.
I'm here for Mr. Gray.
Yep.
I need to talk to somebody from probation real quick before we can tell you exactly what.
Those are the probation people right there. If you can talk to them in hushed tones, or they'll go into the jury room with you or out there, that's fine. I'm going to deal with Mr. Stewart, and then we'll figure out what we're doing with your client. Sure. So Ms. Hudson, I haven't done one of these before. You and Mr. Brown will be standing up here with Mr. Stewart. Is that how, or you're going to give a report and then I hear from I'll hear from everyone. I just want to make sure we sequence it in the way you're familiar.
Usually I would report, Mr. Stewart can stand here.
Great.
If he wants to.
Hey, Mr. Stewart, if you'll come stand next to Ms. Singleton, please. And we got Mr. Brown on your other side. So let me get us on the record. This is 23 SC 190.
Right now, please, step out forward with their cell phone. Yes, step on out.
This is my favorite.
Yep, you can, you're connected to this?
Yes.
Okay,
She is the guardian.
that's fine. Just make sure the cell phone's off. We'll get her right back in. 23 SC 190987. It's State versus Demarion Stewart. Mr. Stewart is here with his trial attorney, Mr. Brown, along with Ms. Singleton, who is with the Department of Juvenile Justice. And we are having a hearing in connection with OCGA 49-4A-9E. And that's a lot of letters and numbers, Mr. Stewart. But what that means is you have turned 17 or about to turn 17. About to. You were sentenced as a juvenile for an adult crime. And a juvenile, someone under 17, who is sentenced to a felony, and in this case, a pretty serious one, when he is about to reach 17, we have to have a hearing where I decide, as the judge who handles your case, whether we keep your sentence in place, whether something else happens. I've received a report from the Department of Juvenile Justice about how you've been doing at the YDC. But I want to make clear on the record before we dive into that, the full context. You pled guilty to voluntary manslaughter in connection with the murder charges of Mr. Homer. And you, through your attorney, agreed to a sentence of 25 years to serve 20. That's more years than you've been alive, balance probated, in lieu of going to trial, where if you went to trial, you face the possibility of a life or life without parole sentence. And you were there when I heard the factual basis from the state about how many times Mr. Homer was shot. You have a co-defendant who also pled guilty. But based on negotiations between your lawyer, Mr. Brown, and the prosecutor, and the information I heard at your sentencing hearing, I concluded that a sentence of 20 years to serve, followed by 5 years on probation, was a reasonable sentence, despite your young age, given the seriousness of what happened and really the lack of a defense to what happened to Mr. Homer. All that being said, we still need to have this conversation because by law, I'm required to consider, now that you're about to turn 17, is it appropriate for you to continue to serve your sentence, and you'll get credit for all the time you served, but you'd shift over to the Georgia Department of Corrections because at 17, you're deemed an adult. You may not feel like you're at adulthood yet, but that's where you'd go to serve the remainder of your sentence until you were paroled out because you're parole eligible or the 20 years were up. But I have a couple other options that I am authorized to consider. And that means I need to hear from Ms. Singleton first, and then from Mr. Brown, and then finally I'll hear from Ms. Jones-Connor, who is a prosecutor. I don't know, you've met her before, but she's familiar with the facts and circumstances of your case. And so I'm going to hear from all these people, and then I may need to take it under advisement and enter an order. I may tell you right here and now, here's what I'm going to do. But I want to make sure you understand. I just said a whole lot, but I want to make sure you understand the purpose of the hearing.
Yes, sir.
Okay, have you had a chance to talk with Mr. Brown a little bit about the purpose of the hearing?
Yes, sir.
Okay, you have any questions for me yet?
No, sir.
All right, Ms. Singleton, if you would, please.
Sorry. And, Your Honor, I actually work for, Fulton County pretrial.
Okay.
Okay.
Associated with DJJ?
Yes.
All right.
Your Honor has laid out everything, as to the purpose of why we're here, as well as the previous sentence. Going into the purpose a little bit more, the options that the court would have, as stated, is to either do nothing and Demarion would transition over to Department of Corrections, re-sentence the Demarion to a reduced charge, not a reduced charge, I apologize. Re-sentence Demarion and, change the sentence, the amount of time that he is to serve. Your Honor does have that option, or to, re-sentence Demarion and release him onto probation.
So option two, as you understand it, and I think I share your understanding, is obviously it wouldn't be an increased sentence, but I might hear these things and say, you know what, I think changing this to 10 years to serve is the right thing to do.
That's correct, Your Honor. And since the hearing is going to be based on his behavior in the facility, what I have seen is some years taken off of sentences in some sentences.
Okay. Got it.
But yes, Your Honor, and that would be based on the behavior. Your Honor has received a letter from the Department of Juvenile Justice, and I've also provided one to defense counsel and to the DA. Just going through the letter, it shows that the defendant the defendant is in general studies at BJJ. He does attend school regularly. The grades listed on here, literature 82, biology 91, geometry 78, team sports 90, and personal financial literacy 71. While Demarion has been in custody, I have received report cards at the end of each quarter for him. These grades are the standard grades for him. He typically, the 71 is actually a surprise because he's usually an AB student during the time that he has been in custody. That has been continuous. The education department speaks highly of him as far as his behavior. He's always in school, always polite and respectful. He's also participated with programs in the standard programs in the facility that they allow, as well as he was working on assessment needs for disruptive behaviors or personality and peer relations. They also work with him on life skills, how to deal with anger, things of that nature. He is always compliant. He is not on the mental health caseload. However, Mr. Perry, the social worker, did send a statement to me that he wanted the court to know that Demarion is always polite and respectful, always follows direction. And just putting that in context, Your Honor has heard from me before speaking about the situation at Metro, which is totally out of control. I was there yesterday watching 3 hours of video from a riot that they had last Wednesday, where they had to call the Department of Corrections for help. Took them 4 hours to get the facility back. I have been out there monthly for the last year watching these same types of videos. They had a significant riot last summer that involved staff and youth being taken to the hospital. And so I'm called in because oftentimes it is the SB 440 units, they're housed on the same units, that are the main parties in these situations, and they want me to let the court know who the individuals are and exactly what they're doing, which is why I'm watching video. Demarion is not and has never been seen in any of these videos that I have seen. He's typically either walking to his room to shut the door or just standing back. So they did, multiple staff members wanted the court to know that he does not participate in anything that they have shown me. Pastor, and I do have a statement on it, if I did kind of preface it. The chaplain at the facility, volunteer chaplain, was intending on being here today, Reverend Dr. John Richardson. I've known him for many years at the facility. He said that he has been there for 8 years. He is the chaplain there as well as at Burris, which is the facility the 17-year-olds go to. And he wanted the court.
Are they at Burris until 18?
Until they're 18.
So it's almost like a transitional facility, but boy, once it's 18, you're in with everyone else.
Correct, Your Honor. And I went to visit Burris about 1.5 years ago because I wanted to see.
Sure.
I keep hearing and I wanted to see what the facility was like. So I went down there and the warden was kind enough to walk me through the facility, let me visit all of the Fulton Senate youth and talk to multiple other inmates there and the services.
How did it compare to Metro YDC?
Calmer.
Okay.
It was calmer. It's considered a transitional facility. They are a specialized program. They do have adults there. However, they are 17-year-olds are all housed together. They have no contact with the adults, even though I was able to walk through and see the adults as well. They have multiple programs there, high school program, a GED program, mental health. I spoke to the coordinators from each program. They do have issues, but it's much quieter and calmer. And then some of their staff recently came to Metro to try to figure out some of the behaviors that they see when the kids transition from Metro specifically. Metro Youth Detention Center is considered to be, Regional Youth Detention Center is considered to be the most uncontrolled youth facility in the state, is what I've been told. Have not being a employee from DJJ, but having them tell me.
You're with pretrial services.
So what they typically do is they're starting to send the kids all over the state. When they can't control them, they're just moving them out of there. They have a lot of gang issues at Metro. So boroughs had been starting to have some more problems than they've had in the past. And so they came up and walked through Metro to try to, on a day when there was major activity. And so they got us to see. And so it helped them to better understand.
Okay.
But it is calmer. But Pastor Chaplain, Your Honor, did want the court to know, he thought that it was a situation in Superior Court where he would show up at 9 o'clock, we'd have the hearing, and so he had planned other things.
Sure.
So he was not able to
Be nice
stay.
if it worked that way.
But he wanted Demarion to know that he was here to support him, that his statement is that Demarion is a good kid with a great heart. He has a strong sense of right and wrong. He does not shift blame for any actions of his own. If anyone deserved mercy, it would be Demarion. He would love to mentor him if he is allowed to go into the community. He said that he had really hoped to be here as moral support for him because he has helped Demarion bear this burden for almost 500 days that he has been in custody, and that there's no one more deserving than Demarion. The reason why that was significant to me is that Pastor Chaplain has never asked to come to court or ever shown up to court for anyone in Fulton County Superior Court. He was very saddened to find out that Demarion had taken the plea and he had not been able to come. He did not know that that was going to happen. He had prayed with him previously before the court date, but didn't know that that was the way it was going to shift. So he had tried very hard to be here today. But he did want the court to know that. Your Honor, I believe that's all the information that I have to present on Demarion's behalf.
All right. Mr. Brown, good morning.
Good morning, Your Honor.
What would you like to add, if anything, to that?
First, if I can have she's back in. Okay, good. As Your Honor has well stated, you have a number of options pursuant to OCGA 49-4A-9 subsection E. You can, upon reviewing my client's case, you have the authority to release him, put him on probation, have his sentence reduced, or to transfer him to the Department of Corrections for the remainder of the original sentence. I would ask, before I ask, I would like to note for the court that the report I received from Ms. Singleton stated that he's remorseful. And I think that's significant because 32 years, I've represented a lot of people who are not remorseful for what they've done. And so I would concur with the pastor who wishes for mercy upon this young man. And I ask that he be released and put on probation. I know the charges are very, very serious. They don't get any more serious.
They're pretty serious.
Yeah, but that's what I'm asking for.
Okay.
And in the alternative, if that's not what the court is inclined to do, I ask for the court to do what you mentioned, reduce the sentence to 10 years.
That was a hypothetical, but you're seizing upon 10 years.
Absolutely.
Okay. All right. Got it.
And Your Honor, I'm sorry, there was one of them. If the court, one of the things that I always try to make sure I present is if the court did do a release, I have spoken with the guardian. Ms. Stewart is here. The defendant worked with her previously. She owns a furniture store. He would work there. He would enroll in a GED program at the Promise Center that I would refer him to, as well as the Chris 180 mental health, which is at the Promise Center. I would refer her to all of those things, just so that the court knows that there is a loose plan, but it can be made into fruition.
Got it.
And
okay.
Your Honor, if you don't mind, could Ms. Stewart, his aunt, come and just confirm what Ms. Singleton has stated? She's right there.
Hi, good morning.
So yes, Demarion, like I have been working with him before all this incident happened. We had a game plan, he had a whole vision, everything that he was gonna do from the time he was 15 all the way through graduation. And we sat down and went through a lot of stuff. He was employed at my business and he worked there 4 years before this incident happened. So he would be back with me in my custody, living with me back at working and doing everything he needs to do to get him back on track with his vision and with all the plans that we had set forth to go with him.
Got it.
He is a good child and despite his circumstance and despite this condition, I just ask that you do have mercy.
Okay, thank you. And thank you for being here on his behalf. Ms. Jones-Connor.
Yes, Your Honor. And am I okay to remain at the table?
You are. That's great. As long as, is that microphone showing a happy green light?
It is not as showing no light at all.
Oh, tap it with your hand.
Okay, it's not red, so I believe it's on.
Yeah, it's fine.
Okay.
But tap the microphone with your hand. It's on. Okay. Great. You can stay right there.
All right. Thank you, Your Honor. The state comes before the court and we thank Ms. Singleton for her report. We did have a chance to review it. However, all it does is highlight the fact that in the joint resolution that was presented to the court, I believe a little shy of 2 months ago, that we came to the right conclusion. That was to a reduced charge for murder, which carried a minimum of a life sentence and a maximum of a life without the possibility of parole sentence if he were convicted at a trial of his case. We went down to voluntary manslaughter, which is also a parolable charge. So that agreed upon time of 20 years in custody also carries the possibility of parole long before he would have been able to see it at the minimum if convicted on murder. The fact that he is doing well by all reports is comfort we can take in knowing that all parties with a sound mind after long deliberations and communications came to the right conclusion in presenting a chance that at an appropriate time, weighing all factors, including the circumstances and the fact that we do have the death of Mr. Homer, came to the right conclusion. And so we would still argue that it was an appropriate sentence, that all parties agreed to that sentence just a month and some change ago. And we would ask that that sentence hold. Nothing further.
Is it your, two questions for
Yes,
you.
Your
One, do you have any input other than they agree with me from Mr. Homer's family?
Your Honor, they, as you know, they were not on board fully even with the reduced sentence. So
A fair statement.
know that they absolutely agree that the sentence should stand and there should be no modification.
Okay. Second question. What is your understanding of the output of this proceeding? Do I enter an order or it's sort of like a pocket veto? If I do nothing, then the status quo is maintained, or there ought to be something in the docket that says, I had a hearing pursuant to 49-4A-9, and as a result of the hearing, I am ruling X.
And so that is my understanding, Your Honor. I know I will defer to Ms. Singleton, who I know has done a few more than I have at this point. But I know that I have looked at a case before and not seen that order. So I would prefer, even if the sentence will remain, that is entered into in this case.
Okay. Ms. Singleton, is there a best practice that you prefer, or it's by the wrong, because it's not your, but that you've seen judges do?
What I've seen, Your Honor, is no order entered.
Okay.
We just had a hearing. My thought process on it would be to streamline everything. A order would be a good idea.
Okay, me too. I'm sort of surprised that you haven't seen that more frequently. All right, Mr. Stewart, I didn't mean to exclude you from the conversation. Ms. Singleton spoke highly on your behalf based on what she has seen and heard. It sounds like the pastor would have said good things. Obviously, your aunt has lots of good things to say about you. And Mr. Brown, who got to know you as your lawyer, is there anything you want to add to what I've been hearing?
No, sir.
Okay. So, Mr. Stewart, I'm going to take this under advisement. I want to manage your expectations. I'm not sure what I'm going to do, but one thing I am not going to do is release you now. That won't be the outcome. There are three choices I have. One is to say, we're done. You can go. It wasn't just go free. It's Chris 180. It's at promise. It's working with your aunt, etc. That's not what's going to happen. I'm going to consider, based on all this information I've received about how seriously you have taken rehabilitation, education, doing something different in your life than this situation. And we call it an incident or a situation. Someone was murdered and life was taken. This is the most serious thing someone could have done, which is why that first option is not on the table for me. If what you had done was stolen a car, that's a bad choice, but people can rebound from that. And I hope you rebound from this, but you know what? Mr. Homer cannot rebound from this. He could get his car back or get a different car if that's all that happened, but he's dead. And so his family has a forever loss and he is no longer with us. And so there will always be serious repercussions for something like that. But I need to think seriously about whether the sentence that was imposed remains the right outcome based on this additional information I had. I didn't have 2 more months of you being at RYDC. There are plenty of people who, after they plead guilty, say, well, I'm done having to behave and now I'm going to revert to the way I normally am. And what I'd hear from Ms. Singleton is you'd stabbed 3 guys and broke someone's nose and you were getting all 40s in your classes, or you don't go to class at all because you don't have to go to class. You're in custody. But that's not what you've been doing. And so I need to think about whether that's something that ought to shape what happens next. I will enter an order. It's not going to be a secret, and I'll do that shortly, and that'll be how we proceed. But I appreciate the input from everyone, to include Ms. Jones-Connor, on behalf of the state, as well as on behalf of Mr. Homer's family. Unrelated question. Mr. Ware, also a juvenile, and so we'll be doing this soon, or he turned 17 before the plea?
That's correct, Your Honor. He turned 17, so we will not.
So this is the only one we have to do this with. Okay. All right. Thank you for the work you did. I apologize for misidentifying your employer. I'm sure that's happened before. It won't happen with me again. I didn't realize we were coworkers that directly. Yeah. Mr. Brown, thank you for the additional work you've put in here, coming on Mr. Stewart's behalf.
Absolutely.
Okay.
You're welcome.
Any questions, Mr. Stewart?
No, sir.
Okay. Good luck with everything. Thank you all. And Ms. Jones-Connor, thank you for parachuting in. Do we have other things you're going to help with today?
I do, Your Honor. One was position 3 on the same calendar, Mr. Ricky Pierce.
Yes.
Knew there was some issues with representation.
Yeah, we're not gonna, that's gonna be an after lunch thing.
Okay.
And frankly, any ADA, any bar card will do, but it's a Feretta hearing that he wants to have.
Okay.
And so you're welcome to be here for the spectator value of that. But you could always just patch in because that's all. Ideally, we do an arraignment, but he's announced that he isn't under the jurisdiction of this court and you can't have an appointed lawyer.
Okay.
That's when we'll say for later in the day.
Okay, and then the other case was the co-defendant case on the trial calendar, positions 3 through 6. I was hoping I could get a chance to talk to defense counsel. I apologize. I was around this morning.
I think they're probably all gone. So Ms. Cabrera is on leave.
Okay.
But that's the one that Mr. Abate claims he's been communicating with.
That is correct.
So that would be a stream you want to pick up on. He suggested that was the most productive one.
Yes.
Ms. Bumpus called in sick, so Ms. Rockwell appeared for her and said, I don't know anything about the case, but we're ready to go.
Okay.
Mr. Regis was excused.
Yes.
But he is ready, believe it or not, either Monday, next Monday or the Monday after. He doesn't have a conflict.
Okay.
I'm going to seize that opportunity. And then Ms. Feely, who was a PD in this courtroom and is now a supervisor elsewhere, she stayed on the case for her client. And her client was actually here for a little while. They spoke, and then Ms. Feely left. She shared with me that Mr. Abate hadn't connected with her, so that would be a productive line to open as well.
Absolutely.
I know it's a lot of moving parts, but it's so old and these gentlemen are all in custody that it will be my priority. Do you have a sense of how long the Judge Carnesale case is going to go?
The projection is to be done and the jury will have the case and hopefully have a verdict in Tuesday at the latest.
Of next week?
Yes, of this coming week.
Okay. And he's lead or only on that?
Lead.
Okay. All right.
Yes, Your Honor.
Thank you for that.
I am somewhat familiar with the case, but I've talked about negotiations and all that, so I'll start making some calls.
Excellent.
Today.
Good.
Thank you.
Thank you. Mr. Wilson.
Yes, Mr. Craig just has an announcement.
Hey, Mr. Craig. Yeah, why don't you come on up? You're sort of jumping in line, but if it's just an announcement, we'll do that. And then we'll turn to Mr. Phillips's plea next.
Your Honor, that concludes my business matters.
Yes, sir. As always, good to see you, Mr. Brown. Thanks for your help.
Great week.
Soon. All right, let's see. We don't have to get this on the record, I think, but I want to get to your case on the calendar. There you are. Mr. Craig, position 11. What did you want to say? I'm happy to hear it through Mr. Wilson, but if there's something you want your client to say?
Perfectly from you. We're just going to be announced and ready for trial.
Okay. And are you available either week?
I prefer the second week because I know next week on Monday, I am going to be having a trial in Gwinnett County. So.
Is it a felony trial?
No, it's actually a magistrate court trial.
Okay.
So
sort of like today. Today, calendar call, being in magistrate court's fine with me. But Mr. Craig's case would take precedence over the magistrate trial.
Yes, and it sounds like you already have something coming up on Monday, so I'd be free. If there's a trial coming up on Monday and Tuesday, then
okay,
I'd be free beyond that.
So what I'm going to do is shift Mr. Craig's case over to the trial side. And I am hearing you say your preference is week 2, but the conflict that you have on Monday of week 1, so next Monday, you and I are agreeing, I think, that actually this case would win the conflict.
Yes, I'm sure.
Your preference would be, since they're both Mondays, hey, let's move Mr. Craig's to that following Monday. And I try to accommodate those things. I will tell you that there is a murder. The only week which I can try it is that second Monday.
Okay.
And that gentleman is in jail and has been for a long time. And you just heard from Ms. Jones-Connor, the 4 defendant murder where people have been in jail even longer. I couldn't start on Monday because the prosecutor is stuck in trial. So that would probably be the second week as well. Second week is looking pretty congested.
Yes.
So.
Yes, I'm sure if I talk to the magistrate court, they'd be.
I'm happy to help.
If they need to continue that.
Yeah. And I'm happy to help you with that conversation. I will stay out of your way, but if you need coverage, I'm happy to have my team reach out to say, Mr. Wilson is popular. He's going to be informed.
Yeah, if I need someone to strong arm him, then.
That'd be Mr. Foy, but I will help with other things.
Okay.
Mr. Craig, I want to make sure you understand you are 100% exercising your right, which is to go to trial. I will be emailing Mr. Wilson and other lawyers what the plan is for the next 2 weeks, but it's entirely likely that you will need to be here Monday morning, 9 a.m., ready to roll. And just looking at the charges, it's a case that might take 3-4 days, and you'd obviously need to be here for all of that. Understand?
Yes, I understand. You talk about this Monday coming.
I am.
Okay.
Yeah, like 5 days from today, 2 business days. So yeah, Monday the 3rd, whatever it is. But Mr. Wilson will let you know. I don't email you directly. The email will go to the lawyers. And so just make sure you are staying close to Mr. Wilson. My forecast is that it would be this Monday because of what I just shared about these murders that are stacking up for the second week. Okay?
Yes, sir.
Mr. Wilson, that email will also have in it some basic directions on, hey, I need voir dire by this date and jury charges, et cetera. And we'll roll from there. Ms. Dilligard, if this went to trial, how long do you expect the state's presentation to be?
So I would estimate 3 days.
Okay, so it's doable within week 1.
It is.
Good. Yes. Okay. All right. Mr. Craig, you remain on bond. Those conditions apply. You just want to make sure you're here on Monday if that's what Mr. Wilson says you need to do. Okay. Any questions?
No, sir.
Anything else, Mr. Wilson?
My only question would be the email. Would that probably come out today or tomorrow?
My goal would be to get it out today because Monday's not far. And in particular, there are a few lawyers who've got 3 or 4 cases and they'd like to know which one do I spend the weekend working on. You have just one. So I always try to get that out as soon as I can. But we got some pleas to take. And so if it's not, my guess is it may be after business hours today, but it would be today.
Okay.
Okay.
All right. Well, thank you.
You bet.
Can we be?
And don't panic. It will actually come from me. I'll copy my litigation manager, but it'll come from me. So don't disregard. Like, I don't know McBurney. You do. It'll come from my email address.
Okay.
Okay. You guys are free to go.
Okay. Thanks.
All right. Let's get Mr. Phillips up here before someone else. Did you sort out who his lawyer is going to be for the day?
Very strange, Judge. So
Yeah.
Mr. Phillips County hired another attorney 2 years ago, never had any contact whatsoever. So hired our office.
Okay.
And then that was the first time that he had met her. So interesting.
Did you hire that lawyer in particular, or it was an office, a firm, and she was part of that firm? Okay, I need you two to switch spots. Sure. Yep. Thank you. All right, Ms. Rivers, you still good to go?
Yes, I am.
Great. Let me switch a couple cameras here. There we go. All right, this is position 22, State versus Robert Phillips, 24 SC 003-873. Mr. Phillips is here with his attorney, last name Goldstein, colleague of Mr. Smith. Ms. Goldstein is here, and Ms. Dilligard is representing the state. Mr. Phillips, in just a moment, Ms. Dilligard is going to put you under oath, ask you a bunch of questions that really mirror a lot of what you and Ms. Goldstein already talked about. You need to answer her questions truthfully. If at any point you've got a question or something that just isn't computing, call a timeout. Let me know, and you and your lawyer can talk, or you can ask me the question and we'll work through it, okay?
Yes, sir.
All right, Ms. Dilligard.
Mr. Phillips, please raise your right hand. Do you swear or affirm that any statement or testimony that you shall give in the matter currently before this court will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You can lower your hand. Please state your true, correct, and legal name for the record.
Robert Timothy Phillips.
Mr. Phillips, are you at this time taking or under the influence of any medicine, drug, or alcohol?
No, ma'am.
Is there any medication that you normally take that you have not been given today?
No, ma'am.
How old are you?
47.
How far have you gone to school?
GED.
Do you understand that you've been charged with the following offenses? 1 count of trafficking cocaine and 1 count of possession of cocaine with intent to distribute.
Yes, ma'am.
You understand that if you plead not guilty or remain silent and refuse to enter any plea at all, then the state is required to prove those charges against you at a jury trial.
Yes, ma'am.
Have you had the opportunity to review the waiver of rights form with your attorney?
Yes, ma'am.
Have you had enough time to speak with your lawyer about all the charges in this indictment, including the facts and circumstances relating to these charges?
Yes, ma'am.
Do you need any more time to discuss the case with your lawyer?
No, ma'am.
Are you satisfied with your lawyer's services?
Yes, ma'am.
Counsel, do you waive a formal reading of the indictment for purposes of the plea? And do you waive any and all defects in the indictment for purposes of the plea? Yes. Mr. Phillips, do you remember being arrested on these charges?
Yes, ma'am.
Has your attorney advised you of the minimum and maximum sentence for each charge of the indictment? For count 1, the maximum for trafficking cocaine is 10 to 40. And for count 2, it's also 10 to 40.
Yes, ma'am.
So
the drug ones are always changing, and I just was surprised that possession with intent to distribute was the same as trafficking, but it's oxycodone, and so maybe that's a different sentencing range.
Also, this would be his second conviction for possession of
Okay.
intent to distribute.
I wasn't disagreeing, and as long as the sentence is within the range, we're okay. You don't have an issue with those ranges?
I don't judge, and just to clarify, he is actually pleading to a lesser included.
Okay, we're gonna get there.
Perfect. Thank you.
Okay.
Okay, and has your okay, do you understand that today you're entering a negotiated plea of guilty, which means the state will recommend the following sentence to the judge? For count 1, Judge, we are reducing the trafficking cocaine down to possession of Schedule 2 to distribute in accordance with OCGA 161330. And we are recommending a total sentence of 15 to do 2, commute it to time served, balance probated, with the special conditions that the defendant enters and successfully completes the Georgia Sky Detox Program. No drugs, no alcohol, no firearms, 100 hours of community service, to actively seek and remain employed.
Okay. And Ms. Goldstein, you'll be telling me a little bit about this, or your client will, about the Sky Detox Program?
I will, Judge.
Okay.
Mr. Phillips, is that your understanding of the recommendation that me and your attorney discuss?
Yes, ma'am.
You understand that the court is not required to accept the state's recommended sentence?
Yes, ma'am.
You understand that the court has the right to sentence you to the maximum possible sentence on each charge?
Yes, ma'am.
You understand that if there are multiple charges to which you're pleading guilty today, that the court also has the right to run those sentences consecutively?
Yes, ma'am.
Do you understand that if the court decides to order a sentence that differs from the plea, you have the right to withdraw your guilty plea?
Yes, ma'am.
You understand that if you're currently on probation or parole, your probation or parole may be revoked based on your entering of a guilty plea today?
Yes, ma'am.
You understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Yes, ma'am.
You understand if you're on probation, you must follow all the special conditions of your probation?
Yes, ma'am.
You understand that if you fail to follow all the special conditions of your probation, that you'll be subject to revocation of that probation for the balance of your sentence?
Yes, ma'am.
You understand that you're not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you you're not asking to be under first offenders? Do you understand that by entering a plea of guilty today, you are waiving any and all defenses, including any mental health defenses?
Yes, ma'am.
You understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to the assistance of counsel, the right to the presumption of innocence, the right to appeal if convicted of these charges at trial.
Yes, ma'am.
Is it your decision to waive these rights and enter a guilty plea today?
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter this plea?
No, ma'am.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes, ma'am.
Mr. Phillips, how do you plead to the charges of possession of Schedule 2 with intent to distribute and possession of oxycodone with intent to distribute in indictment number 24 SC 003873?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
You understand that you only have a limited right to appeal this guilty plea conviction?
Yes, ma'am.
You understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
Yes, ma'am.
You understand that for a felony charge, you only have 4 years from today to file that petition?
Yes, ma'am.
Judge, if this case were to proceed to trial, the evidence would show that on January 1st, 2022, officers were traveling on Old Bill Cook Road when they noticed a white Jeep Cherokee that appeared to be exceeding the 35-mile-per-hour speed limit. Officers accelerated past the vehicle, was within passing distance, and were able to clock the vehicle between around 55 miles per hour in the 35-mile-per-hour zone. A traffic stop was initiated. Immediately upon walking up to the vehicle, officers could smell marijuana coming from the driver's window. They spoke with the defendant and asked him to step out. They conducted a probable search cause of the vehicle, found a small baggie with black spades on it full of cocaine and the center console. They also found marijuana, MDMA, and oxycodone with some more empty small baggies. They also found around $1,700 of United States currency on his person. The GBI tested the drugs and they were able to confirm 28.01 grams of cocaine.
That's an unlucky day.
Right.
Make it up, Judge.
Wow. It's like do a retest on that one. Just sneeze and it's going to be less now.
And 7.5 grams of oxycodone. All this occurred in Fulton County, Judge, and that is the reason for the reduced charge down to possession with intent. Judge, this defendant spent 4 months on a revocation based off of this case, and then also an additional 9 months, which I'm sure counsel will tell you about, in DOC completing an RSAT program, the RSAT program.
As a result of the revocation, that was the basis of this.
Yes, Judge.
All right, I'm feeling better about that because he served 2 days in jail here. Like that's not a 15 serve 2, but there's a little more traction here. Okay.
Yes, Judge. And so my understanding is that the defendant is battling drug addiction, and that this program, which I'm sure counsel will tell you more about, is very intensive and my understanding is that's the help that he needs. And so that is why we recommended the sentence that we did, and nothing further from the state at this time.
All right, thank you. Ms. Jackson, good morning. Can you share criminal history on Mr. Phillips, please?
He has 34 cycles. The last arrest was November the 5th, 2024, out of Clayton County for trafficking cocaine or illegal drugs, and possession of marijuana with the intent to distribute, and possession of Schedule 1 or 2 controlled substance with the intent to distribute. 3 counts. And possession of Schedule 1 controlled substance, 3 counts. And there were 2 counts of possession and use of drug-related objects, and possession of a firearm during commission of a felony, and possession of a firearm by a convicted felon. There was no disposition for that arrest. He does have prior felony convictions, one in 2015 out of Fayette County for possession of cocaine. I apologize for being out of order, Your Honor. There was one in 2016 for possession of a firearm by a convicted felon. One in 2008 out of Henry County for possession of cocaine with the intent to distribute. One in 2003 for possession of controlled substance with the intent to distribute, and possession of marijuana with the intent to distribute. One in 2000 for robbery. He does have misdemeanor convictions. One in 2010 out of Clayton County for DUI and driving while license suspended or revoked, and possession of marijuana less than an ounce. One in 2006 for fleeing or attempting to elude an officer and reckless conduct. And one in 2003 for driving while license suspended or revoked. Nothing in addition, Your Honor.
Thank you. So, Ms. Goldstein, I'm curious about Sky Detox. I'm also curious about a trafficking arrest 3 months ago.
Yes, Judge, we don't represent Mr. Phillips on that case, so I don't know the merits of that case to discuss.
Okay.
Actually just became aware of it fairly recently.
Did you know about it, Ms. Dilligard?
Did not, Judge.
Did not. So he's got an open trafficking case with a gun out of Clayton County. Okay, keep going.
Yes, Judge. I believe that Mr. Phillips' criminal history, it's extensive. And I don't think that we can ignore that, but I do think that it speaks to the addiction that he has struggled with all of his adult life. He is 47 years old, lives with his wife, his fiance, who's present in the courtroom. There are 2 children who are 12 and 15 years old. He is actually this school year, their 12-year-old daughter was identified with some learning disability, so he has been responsible for her schooling. As Ms. Dilligard pointed out, this case led to a probation revocation out of Fayette County.
That's the 2015 case?
That's correct, Judge.
Okay.
In which Mr. Phillips served 4 months in custody in Fayette while he was waiting for bed space in RSAT. Then he completed the RSAT program through DOC. Mr. Phillips has shared with me that RSAT was the first time that he has really heard any sort of hope or any sort of hope for help. That program, I don't know if, I'm sure you're familiar with it in Dearborn with drug court. It's not therapeutic as it probably could.
It has a punitive component to it that, in my experience, has lessened the therapeutic side. We get a number of people in drug court who went through RSAT. And when I was first starting, well, wait, you did RSAT, you did this curriculum, but it's in a very different setting.
I agree with that, Judge. And I think that the message of hope that was presented was the first time that Mr. Phillips had heard that. So he is looking at this as an opportunity to get the help that he needs. As far as the Georgia Sky program goes, it is kind of an umbrella program. It will be administered through Acworth Outpatient Detox. The original detox, the initial detox phase is 15 to 22 days of intensive detox with medical professionals. He has already been accepted. He has an appointment to start that on Monday at 10:30 a.m. They do an evaluation to accept you into that program. I have an acceptance letter the court would like to see. Then at the completion of the detox phase, you reassess, meet with the doctors, and they recommend you an ASAM curriculum, if you will. After that, Mr. Phillips' insurance will cover 16 weeks. That's not enough, Judge. And I've spoken with Mr. Phillips and his fiancée at length that they are willing to pay out of pocket for whatever is required to get him the help that he needs. I am happy to answer any questions about the detox program or provide any more information you might need.
What language should I put as a special condition of probation that ensures that I've got some leverage over Mr. Phillips if he walks away from it? If I say you must enter into and complete the Sky detox program, is that sufficient, or do I need to say Ackworth, blah, blah, blah?
Judge, I think Ackworth outpatient detox would probably be more specific, if Ms. Dilbert agrees with that.
But that's only the first part.
Correct, and then I think that you could also include in the language that you must complete, I guess the recommended ASAM treatment that comes at the end of the initial detox phase.
ASAM?
Yes, Judge, it's ASAM, level 2, which is also known as the intensive outpatient program. That's kind of, I think, the more common name for that program.
And that's administered through where?
It will be wherever Ackworth outpatient detox then sends him.
Okay, not known yet.
Sky program. Yes,
Okay.
exactly.
Okay, I'll put together some words. We'll see how that goes. Ms. Simpson can say that doesn't work. Okay, Mr. Phillips, you have insurance, which says to me you work or you were in the military. How do you have insurance?
It's marketplace insurance.
You just are paying for it. And how are you paying for it?
My fiance.
Your fiance works.
Yes, sir.
She's the legitimate breadwinner in the household.
Yes, sir.
Okay, and what does she do that's legitimate?
She's a manager at the corporate of a bank.
A bank? What bank?
Wells Fargo.
Wells Fargo. Okay. When's the last time you had a job that had paychecks rather than bags of cash?
Well, I was running my lawn service that just hit rock bottom.
Okay.
So I just been chilling at the home while she's been handling everything, taking care of my little girl.
Okay. And what was your little girl diagnosed with?
She's not diagnosed with nothing. She just got a hard time with learning
Okay.
for other kids. I don't know if it's through my genes or whatever, but she's real active. It's hard for her to learn. And
Okay. Almost like an ADHD kind of thing.
And they said it ain't nothing wrong, but we know it's something wrong.
Okay. All right. Your case in Clayton, do you have a lawyer representing you?
What's so crazy is the lawyer that just came.
The lady who popped up in the box.
I guess she's gonna do it.
Okay. You pay her for something.
Pay her for this.
Okay. All right. So what's the status of the Clayton case? Have you been indicted yet?
No, sir.
Okay. It's just charges sitting out there.
Yes, sir.
All right.
Your Honor, can I say something?
You sure can.
Your Honor, I'm 47 years old, and I know my record tells me a lot that I've been doing the same thing. It's like a cycle with me, and I'm trying to break that cycle. I really need help. I'm asking for the court to help. I really need help.
So I can't help you. You can help you. Ackworth Outpatient Detox can help you. I can shove you in the right direction, which is what this sentence will do. But you probably will read in my face. I'm a little surprised by the sentence, given the Clayton arrest and your criminal history, et cetera. I'm going to follow it for the most part, but I am going to be watchful on the probation revocation side. And so you need to understand that if we are together again, because probation has sworn out a warrant because you got arrested for drugs, or you walked out of this program, I'm going to have a whole bunch of years to work with. And I say that not because I look forward to anything like that. I want to protect your fiance and those kids from a life of, where's dad? He's locked up again. What's this bag of money? Why is there a gun in the car? The line of work you're in is real dangerous. It can result in you being killed by a customer, using the wrong substance or whatever. And your kids and your fiance deserve better. I think you want to do better. I believe that. I work with addicts all the time through drug court. You are going into an amazing program. But I'm hoping that you're tired of all the years that you didn't take it seriously and you could run fast and play hard, because it's catching up to you. And there's so much more at stake now. 15 years ago, it was just you. But there are folks who care about you who are in the picture now. And I make it sound easy. It's not. You need to make different decisions, because otherwise you won't have the capacity to make decisions, because the Department of Corrections will be deciding when you wake up and what you eat and when you go back in your cell, and you're out of your kids' lives and your fiance's life. So I don't know when the wake up call hits, if it's the next arrest, if it was the Clayton arrest, what it was. I'm excited. Excited's the wrong word. I'm optimistic that you going into the situation up in Ackworth is you trying to bend that curve in a different direction. I have one more question. Why Ackworth? Is that you live up there?
No, sir. I stay in Henry County, but that's the only outward program it is. That is self my insurance, the marketplace insurance.
Okay. But you understand Ackworth and Henry County, they're not.
I did the thing. It's like 45 minutes.
Okay.
So it's good.
All right. Because again, I will be looking for something coming from probation saying Phillips walked away from the Ackworth outpatient detox. And I don't want there to be surprises or tears if we're back together. Like, Judge, give me another chance. I haven't worked with you before. This is your chance from me. Others have given you chances cumulatively. There have been a lot of chances. And so we're clear. This is it. I hope it works. Mr. Phillips, I find there's a factual basis for your plea. I also note that it was a long time ago when this happened. This was January of 2022. So we're playing a little bit of catch up. It's generally better when the cause and effect of I get arrested for X and here the consequences are closer in time. That's not your fault. It didn't get indicted till now. Ms. Dilligard has moved it quickly, but it sat around for a couple of years. And here we are. I also find that your plea is knowing and voluntary. Voluntary means no one's forcing you to do this. And knowing means you're going in with eyes wide open. You understand what's going on. Do you agree with that?
Yes, sir.
I'm sentencing you pursuant to the Probation Options Management Act, which means if you have a minor violation of probation, maybe you miss a reporting date once, you and probation work through that. I don't have to get in the middle. But if it's more serious, you get arrested or you violate any of your special conditions, that comes back to me and I'll handle that. Ms. Goldstein, did you cover the plea of guilty form with your client, Mr. Phillips?
I did, Judge.
And is this your signature all the way on the last page?
Yes.
May we affix your signature electronically to the indictment in this case? Ms. Dilligard, can we sign for you? Mr. Phillips, did you review the plea of guilty form and put your signature on it on page 4?
Yes, sir.
Is it okay if we electronically sign your name to the indictment indicating your guilty plea?
Yes, sir.
All right. I am going to sentence you on count 1 to a term of 11 years to serve 1 year with the balance probated. You are going to get credit for, and we'll need to get those dates from someone, the 4 months you were in Fayette County, followed by the 9 months you were at RSAT. I think it's a continuous figure. So you at some point went into custody in Fayette County, and then at some point you were released from RSAT. I just need that start and finish point so that your sentence reflects that you did those 13 months, which is more than a year. So today you're not going back into custody. So it's 11 years to serve 1 year, balance probated. Special condition of probation number 1 is that you enter into and complete the Ackworth outpatient detox program. And is it safe to say you will enter into it on February 3rd? Is that the start date?
Monday, yes, sir.
Okay. So you will enter into it. This is a special condition of probation, February 3rd. If it's February 5th and you're not in it, you've already violated your probation. You'll also be required as a special condition of probation to complete any ASAM level 2 aftercare that is recommended at the end of that outpatient detox. 100 hours community service. And when you are done with the detox, then you need to be actively seeking employment. That's not easy, given your criminal history. I get it. You don't walk into Wells Fargo and say, give me a job, because they'll say, nope. But there are jobs you can do. I appreciate you also helping take care of your daughter and handling that schooling, but that doesn't mean part-time work is out of the question. So you'll need to show the probation officer that you're looking to plug into the community in a productive way. And finally, this may have already happened, but in case it didn't, you forfeit everything that was seized back in January of 2022. So that $1,700, that goes to the state. And anything else that was taken that day goes to the state for them to dispose of as they see fit. Ms. Dilligard, anything else on behalf of the state?
Nothing further from the state, Judge.
Do you have those dates, Ms. Goldstein?
I do, Judge. So he was in Fayette County from May 6th of 2022 to September 6th of 2022. And then he was in the RSAT program from September 6th of 2022 to June 22nd of 2023. So essentially it's May 6th of 2022 to June 22nd of 2023.
All right, perfect. Those are the dates. So you're getting credit for the time you served there against that 1 year. That's all after this situation happened. So it's appropriate to give you credit for that. And that leaves 10 years on probation. Are you in probation in other jurisdictions right now?
Fayetteville misdemeanor.
Oh, misdemeanor. Okay. What's your zip code?
30344.
30344. All right. Armed with that information. First, Ms. Simpson, do you have any questions?
To correct, the Fed is a felony probation.
Okay. So you're on felony probation out of Fayette?
No, it's okay. It's a situation, Your Honor. When I came home from the RSL, Fayetteville switched it over to Fulton. Fulton wouldn't take it. So Fulton sent it back to Fayetteville. And so that's when they shifted down to misdemeanor and had me caught.
Okay, I'm gonna let DCS work through that. I'm not saying either side is right or wrong. You're only gonna have to report to one probation officer in one place, and it's driven by your zip code. So you don't need to worry about, dang, do I have to go to Fayetteville to handle that? But there may be a little more probation than you think. I don't know. They probably know better because it's in their system. But what's in their system may be mistaken, and you can work to correct that. Given that zip code and the fact that Mr. Phillips is going to be out of custody throughout all this, do you have reporting instructions for him?
Where do you reside? Like what county?
In Fulton County, 3021 Bayard Street, East Point, Georgia. That's my address. My mom, the base.
Give that address one more time.
21 Bayard Street, East Point, Georgia.
We have a different address.
Which one?
Old Billcliff Road.
Yeah, that was that's why I had paroled out to from the
So what's the zip code and it will get the rest of the infraction?
30344.
So your reporting date will be February 12th. That is on for the record, it will be 76 Memorial Drive, and that's about 5 minutes from here. That's gonna be Atlanta, Georgia, 30303.
You're going to get a piece of paper with that info on it, but you've been told here in court about that reporting date, that February 12th at 8 a.m. Don't miss that date. Okay? They're going to want to meet with you just to iron out phone numbers and that address and everything. But that's the situation. So you will have already started the Ackworth program before you report for your first day of probation.
Yes, sir.
Okay? Any questions?
No, sir. Thank you.
Ms. Goldstein, anything else?
Nothing further, Judge.
All right. Anything from the state?
No, Judge.
All right. Good luck.
Thank you.
Judge, may I be excused?
Yes, ma'am. Thanks for your patience.
No problem.
We'll see.
All right, I think we'll do Mr. Anduke. Is that right, Ms. Bando? That's your case? Okay, Ms. Kim, do you have an update?
I think she's still downstairs.
Oh,
Yeah.
okay. We're gonna be breaking for lunch after this plea. I don't want to keep you here forever, but we do need to sort out what we're doing. Do you want to come back? You can zoom in.
Or can we waiver presence?
Tell me what we were gonna do with her case.
We're still waiting to see if the victim actually locate the victim, for the named victim.
Okay,
So, my understanding is maybe 2 years ago, she went to a homeless shelter somewhere in New York City. So.
this is the alleged victim?
Yes.
Okay, all right.
If they can find her or not, I'm just trying to get her out if I can.
Okay, well, we can have that conversation. She needs to be present for that, meaning we'll bring her up. So I'll leave it up to you whether you want to zoom in after lunch or be back here after lunch.
Is lunch an hour?
Yeah, at 1:45 is when we're starting back up. We're gonna take this plea and then any other announcements. And then when I come back, we'll pick up with whatever we agree is gonna be next up.
If that's okay.
Okay, that's fine.
Thank you very much.
Sure, yes, ma'am. Did we have any update on the two gentlemen who are brothers? He's raising his hand, but I don't want to hear it directly from you. I kind of need to hear it from your lawyer. She's back there, but I was wondering if you had heard anything.
No, both
You guys can go on.
counsels were speaking with their client.
Okay. All right, good. Yeah, Mr. Anduke, you come on up. Ms. Bando's going to be on the little podium side. You'll be at the screen side.
Judge, real quick, just to update you, Mr. Phillips reporting date will be February the 6th.
February the 6th. Okay, thank you. If it's done, please. Thank you. There you are. All right, let's dive into this. This is position 16, State versus Elijah Anduke, 24 SC 003168. Mr. Anduke is here in court with his lawyer, Ms. Bando. Ms. Dilligard is handling this for the state. You've had to sit through a few of these now. You're gonna get put under oath just like the other gentlemen were, and ask many of the same questions. If at any point, sir, you've got a question or need something explained, will you let your lawyer or me know? Okay, but make sure you answer out loud. I don't worry about the sir part, but the court reporter needs to hear what you say. So if it's yes, no, maybe, use the outside voice, okay?
Okay.
Great. Ms. Dilligard?
Please raise your right hand. Do you swear or affirm that any statement or testimony that you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
You can lower your hand.
Yes.
You can lower your hand.
Oh, okay.
Please state your true, correct, and legal name.
Elijah Anduke.
Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No.
Is there any medication that you normally take that you have not taken or been given today?
No.
How old are you?
23.
How far have you gone in school?
I'm in my final year.
You're in college?
Yeah, I'm in college. Yeah, sorry.
That's all right. That's often not the answer.
Do you understand that you have been charged with the following offenses? It's 1 count of aggravated assault and 1 count of reckless driving.
Yes.
You understand that you have the right to plead either guilty or not guilty to these charges.
Yes.
Do you understand that if you plead not guilty or remain silent and refuse to enter any plea at all, then the state is required to prove the charges against you at a jury trial?
Yes.
Have you had the opportunity to review the waiver of rights form with your attorney?
Yes.
Have you had enough time to speak with your lawyer about the charges in this indictment, including the facts and circumstances relating to these charges?
Yes.
Would you like more time to discuss the case with your lawyer?
No.
Are you satisfied with her services?
Yes.
Counsel, do you waive formal reading of the indictment for purposes of the plea?
Yes.
Do you waive any and all defects in the indictment for purposes of the plea?
Yes.
Do you remember being arrested on these charges?
Yes.
Has your attorney advised you of the minimum and maximum sentence for each charge? For count one, the aggravated assault, the minimum is 1, maximum is 21 year, maximum 20 years. For count two, reckless driving, the minimum is 1 day, the maximum is 12 months. Judge, this aggravated assault will be reduced to disorderly conduct pursuant to OCGA 161139, and the maximum on that case being 12 months. Do you understand that?
Yes.
Do you understand that you're entering a negotiated plea of guilty, which means that the state will recommend the following sentence? Judge, the count one being reduced to disorderly, the total recommended sentence is 24 months probation with 50 hours of community service, no contact with the victim, and to take an anger management course.
All right.
Is that
So
your
12 months per count consecutive.
Yes, Judge.
Okay.
Is that your understanding of the recommendation?
Yes.
You understand that the court is not required to accept the state's recommended sentence?
Yes.
You understand that the court has the right to sentence you to the maximum possible sentence on each charge?
Yes.
You understand that if there are multiple charges to which you're pleading guilty today, that the court also has the right to run those sentences consecutively?
Yes.
You understand that if the court decides to order a sentence that differs from the plea you were expecting today, that you have the right to withdraw your plea of guilty?
Yes.
You understand that if you're currently on probation or parole, your probation or parole may be revoked based on your entering of a guilty plea today?
Yes.
You understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Yes.
You understand that if you're on probation, you must follow all of the special conditions of your probation?
Yes.
You understand that if you fail to follow all the special conditions of your probation, then you will be subject to revocation of that probation for the balance of your sentence?
Yes.
You understand that you're not allowed to possess or use a firearm while on probation?
Yes.
Are you a United States citizen?
Yes.
Are you asking me to treat it under first offender?
Yes.
As misdemeanor first offender.
Yeah,
Yes.
he wanted to take
Okay.
advantage of.
Have you ever pled guilty to any felony in the state of Georgia?
No.
Any misdemeanor?
Misdemeanor?
No.
Okay.
Have you ever been sentenced for any crime, whether felony or misdemeanor, under the First Offender Act?
No.
Has your lawyer explained the First Offender Act to you?
Yes.
Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status can be revoked?
Yes.
This means that you could be adjudicated guilty and can be resentenced up to the maximum sentence for each charge in this indictment. You understand?
Yes.
Do you understand that by entering a plea of guilty today, you're waiving any and all defenses, including any mental health defenses?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to the assistance of counsel, the right to the presumption of innocence, the right to appeal if convicted of these charges at a trial?
Yes.
Is it your decision to waive these rights and enter a guilty plea today?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes.
How do you plead to the reduced charge of disorderly conduct and reckless driving in indictment number 24 SC 003168?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
You understand that you only have a limited right to appeal this guilty plea conviction?
Yes.
You understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
Yes.
You understand that for a misdemeanor charge, you only have 12 months from today to file a habeas corpus petition?
Yes.
Judge, if this case were to proceed to trial, the evidence would show that on November 13th, 2022, Officers were on scene on an unrelated matter, but while on scene, was alerted by screams coming from a female. Officers then observed a woman on the hood of a black Jeep traveling at a high rate of speed. Woman could be heard pleading with the driver to stop the vehicle. The victim was then able to get off when officers were able to effectuate a successful traffic stop on that vehicle. The victim had blood running down her hands from the windshield being damaged. The victim stated that she was in an argument with her ex-boyfriend, the defendant before you today. She said that she stated her ex-boyfriend took her phone and threw it away outside of the car. The victim got out of the car to look for her phone. He tried to leave, but when leaving, he drove towards her and she jumped on top of the hood to avoid being hit by the car. And all of this occurred in Fulton County, Georgia. We've made multiple attempts to locate the victim, have not had any success at that. I will say on body cam while on scene, the victim stated that she didn't want to press any charges or to proceed. So it's one of the reasons for the reduced charge down to disorderly. And there's nothing further from the state.
Is it your understanding that Mr. Anduke and Ms. Nichols were already exes, or this was the event that made them exes?
My understanding.
Okay. This was the culmination of some set of disagreements and.
And a no contact on the first appearance.
Oh, okay. All right. But they were an item, whatever that might mean, at the time of the incident.
Yeah, back and forth.
Okay. It doesn't change anything. I'm just curious because you, Ms. Dilgard, had referred to Mr. Anduke as the ex-boyfriend. And sometimes we get these cases where an ex shows up and is mad because, hey, you're with a new guy, I'm going to beat everyone up, or vice versa. And I just didn't understand this setting. If it was, we're maybe in a tumultuous relationship, but it is an ongoing relationship until it's halted by the fact that there's a no contact bond. It sounds like it was maybe more towards the latter, but again, that's just me being curious.
Judge, I'm not entirely sure. It stated ex-boyfriend in the report and in the interview with the victim, but
that's how she referred to him. Yes. Okay, but he may be you're an ex because you tried to run me over with your Jeep. Okay, all right, thank you. Ms. Jackson, I am assuming you're going to say no cycles for Mr. Anduke, but I'm ready to hear from you.
That would be correct. There are no prior arrests on file, Your Honor.
All right, thank you. Ms. Bando.
Yes, Your Honor.
How are you?
I'm good. How are you doing, sir?
It's good seeing you. Tell me about this case and what you think ought to happen.
So we definitely agree to no contact as well as his family, because as you can hear, it's been very volatile, and this is the best thing that probably happened, the no contact bond. So it's been a hard stop, no contact. He is a senior at Georgia State, majored in sociology. He was planning to do, what was it, information?
Computer information.
Computer information, but he switched to sociology just recently. His anticipated graduation is May this year, 2025. And so he's born and raised in Atlanta his whole life. Family supports him, big family. And we just hope that you accept the negotiated plea to give him a fresh start when he graduates, he can actually be employable and get his life on the road to where he's been headed.
Okay. Mr. Anduke, what's the plan after graduation?
Get a job. Well, I had planned to go back into school to maybe study computer science so I can get my master's in that. But yeah, that's the plan.
Okay. What kind of work?
I'm trying to work in the computer field.
Okay.
Because I'm minoring in computer science right now. So.
Well, I hear there are a few jobs in the computer field. I hope that works out. First offender is something you are eligible for because you have zero criminal history other than this arrest. It's primarily an opportunity. If you successfully complete the terms of your sentence, then all this is erased. You're actually not under sentence as a misdemeanor. You have a sentence while you're on probation. Usually people don't ask if you have a misdemeanor, and so this speech has more to do with felonies, but you will not have a criminal history when you're done today, and if you successfully complete your sentence, it can all be expunged. The risk is that if you get in trouble while you are on probation, without a trial, you'd have a hearing, but without a trial, I could take away your first offender sentence and status and resentence you as a misdemeanant up to whatever remained of your probation. So if it's 6 months from now, there'd be 18 months left. And if you got pulled over for drunk driving, you'd have your drunk driving charge, but I could also send you away for 18 months because you had that much left on this sentence. And it would then show up as a misdemeanor on your criminal history. It's not a huge downside, but I need to make sure you understand it before you tell me, I get it, I want to be sentenced as a first offender.
I get it. I want to.
You do want to be sentenced as a first offender?
Yes.
Okay, I'll do that. You have questions about anything else?
No, Your Honor.
All right, well, I find there's a factual basis for your plea, that your plea is knowing and voluntary. You and your lawyer completed a plea of guilty form, which involved you putting your initials next to a whole lot of things. Did you sign this, Mr. Anduke, indicating your understanding of it on page 4?
Yes.
And can we put your signature electronically on the indictment indicating your misdemeanor pleas?
Yes.
Okay, Ms. Bando, did you cover the plea form discuss the plea form with Mr. Anduke and sign it yourself?
Yes, sir.
And can we sign the indictment electronically for you?
Yes.
Ms. Dilligard?
Yes, Judge.
Great. I will follow the joint recommendation. I'm going to sentence you on count 1 to 12 months of probation and count 2 to 6 months of probation to run consecutive to count 1. So it's a total of 18 months probation. The only reason for the reduction is this case is now 2 years and some months old, and you've been in zero trouble since it happened. And so theoretically, we could have put you on probation the day after you were arrested. And guess what? You would have completed your 2 years probation with no issue. So I'm going to make it 18 months. The main special condition is no contact with Ms. Nichols. That should be easy. You guys seem to have gone your separate ways. But if for whatever reason she resurfaces in your life, you need to cut that off and not have any contact with her. You'll need to complete 50 hours of community service and an anger management course. You can find that, or misdemeanor probation can help you find that course, but you'll need to take that. Misdemeanor probation is probably going to reach out to Ms. Bando to say, hey, how do we get in touch with Mr. Anduke? And then she'll connect you to. It may be telephonic the whole time. Their office is about a block from here, about a block from Georgia State. You may need to appear in person once, but generally it's a pretty hands-off affair, especially if you're doing well. Any questions about any of that?
No, Your Honor.
All right, good luck with graduation. Ms. Bando, anything else?
Oh, yeah.
Thanks for your help with the case. Ms. Dilligard, anything else?
Nothing further, Judge.
All right, we are good to go.
All right, thank you. I mean, we excuse.
You may. So let's take stock with where we are before we break for lunch. On my list of, wait, isn't this going to be a plea? I still have, if I can find that list, Mr. Muse. Mr. McClendon, is that ready to go? Okay. What about Mr. Brown?
Judge, it is ready to go. He's here present. Would it be okay with the court if he appears this afternoon for the negotiated plea via Zoom?
Tell me what the negotiated plea is. If you think if it goes through, what do you forecast it being?
Misdemeanor.
Yes, he may appear virtually. I appreciate your patience. What happened to your mom?
They told us she was.
Okay, I just wasn't sure if like you brought her here, like, okay, I got it. She didn't need to be here anymore. Her lawyer wasn't available. So we'll see you online. You should log in 1:45, okay? And Ms. Wood will get you the link. But we need to be able to see and hear you so the court reporter can take stuff down. You can be wherever you need to be. There just can't be like if you work in a factory, there can't be saws and other stuff going on in the background. Okay?
I isolate myself.
Good. Appreciate your patience. And then Mr. Kimbro, is he in custody?
Yes.
Okay, so we'll get to that. So Muse is ready. Do you want to be right at 1:45, or is it better for you to say, hey, could I be back at 2:30 or something?
1:45 is fine, Judge. I was gonna ask, Mr. Muse has no objection. May I take the plea via Zoom?
If he has no objection, because he'll be right there, he can see and hear you just fine. Okay. You all right with that? Are you handling it, Ms. Nix, or it's
Yes, sir. Yes, sir. I'm fine.
Okay, all right. Log in at 1:45.
I don't believe I have the link, but
One of the lawyers can send it to you. They all have it.
thank you.
You bet. Appreciate your patience.
Judge, I do need to be back in Judge Williams at 2, so if we could do that one right at 1:45?
Yeah, we'll start with that.
Okay.
That'll be meaning news.
Yes.
Yes, okay. We'll start with that. Let's get an update on the brothers Hammond. Because one of them has been raising his hand throughout all this. Like, hey, wait, I want to tell you what's going on. Like, no, don't tell me.
Still talking to Ms. Dilligard, so I just need to get back there and speak with them.
Okay.
I think we're working it out.
So they should take a lunch break. Okay. Mr. Kraft, do you view it the same way? Or Ms. Wood is saying she's thinking Quantavius's case is going to work out.
Judge, that would sort of be my announcement as well. I would ask for the same thing if you give us lunch.
Okay.
I think we should have some.
Break bread and see where we are. At 1:45, we'll do the Muse plea, and then we can roll right into this if it's ready. If you need to talk more, we have a few other things we can do. I think we still have to talk to Mr. Pierce, and I think we have a bond hearing. I think Ms. Kim is going to be appearing virtually, a few things like that. But we'll definitely start with the Muse plea and then see what's happening with the Hammonds. And then Mr. Brown will dial in, and we'll do Mr. Kimbro. Busy afternoon. Thank you all. Ms. Singleton, you're still hanging around? You just want to know what was going on? Oh, okay. Oh, right. You have one of those pieces. Okay. All right. Great.
There's an at least agreement on the sentence. If not the charges, then we went to witnessing because there was an agreement. So we should be.
All right, Ms. Rivers and Ms. Jackson, if you all could, you're welcome to stay on. I'm going to mute it and shut things down, but we'll kick back in as close to 1:45 as we can, maybe a few minutes before, okay?
Okay, no problem.
Thank you.
Charges are right. When you ask. I don't think I ever got one because I was looking for it yesterday. Julie asked me for it. Miss Nelson, can you send us the Zoom link for this afternoon?
I'll send it. It's the same as this morning. You don't have this morning's?
I don't think I ever got this morning.
Okay. Let me forward it. Forward must be saved before it can be forwarded. Let me try it again.
Oh, no, you're fine. You're totally fine.
All right, let me try again. Here we go. So to Nick's, who else wants it?
You're on, I did that.
McClendon. What's your email address?
McClendon, McLendon, law firm.
McClendon Law Firm at?
Outlook.com. Thank you.
You bet. McClendon Law Firm at Outlook.com. All right. Anyone else need the link? Just you two?
I believe Miss Kim needed it. She may already have it, but.
Yeah, hopefully she worked through. Let me see if her email comes up here. Pardon me?
She has that.
She's got it. Good. All right. Now McClendon and Nick's have it. All right. Let me mute.
She found a new home back there, Judge.
Trouble. I don't see Mr. McClendon, but I see Mr. Kraft. We could do. Oh, right, he's gonna Zoom. That's why I don't see him. But I do see him. Thank you for reminding me. Like, wait, what? There he is.
Hello.
Hey, you're good. Let me mute that. There's Ms. Kim. I think we've got all the folks who are going to be here. Before we bring Mr. Muse out, let me check. It may have hit there. Okay. I have 4 cases listed for Mr. Muse.
Yes.
That fits your count as well?
Yes, sir.
Good, because the trial calendar, or whatever calendar we're working off of, has only 1. Are we one way or the other resolving all 4?
Yes, sir.
Fantastic. On the trial calendar is the 23 SC case. There are 3 24s, one of which is a re-indictment, but they are all different cases. Is that correct?
Yes.
Okay. And Mr. McClendon, you were retained by Mr. Muse to handle 3 of them, and Ms. Rios has the 4th, but you are prepared to take the plea or whatever we're doing with all 4. Is that correct?
Yes, Your Honor.
Okay. And none of what I just said to you is going to surprise Mr. Muse?
Correct.
Okay. Then I'm ready for him to come out if, 1, we have enough deputies.
He should be up.
Okay. And 2, you're ready to go, Mr. McClendon.
I'm ready.
Okay. Right now.
Okay.
Well, before we get on the record, are we taking pleas to all 4 or pleas to some and no process to others, or what's the plan?
You're taking felony pleas to 2 of the cases, misdemeanor plea to 1, and I am not processing.
Okay. You can get all that on the record, but that's helpful for me to know what the plan is. Hey, Mr. Muse, if you'll come up to the podium and stand. Whoops, I turned off the wrong camera. You can see your lawyer. He needs to be able to see you.
I can see him.
Great, there you are. So let's go on the record. Ms. Rivers, are you ready?
Yes, I am, Judge.
Great. Mr. Muse, you are here in court. Your lawyer, Mr. McClendon, is appearing virtually. He and I had a conversation about that. He said you were okay that he was going to be virtually by your side rather than physically by your side. Are you all right with that?
Yes, sir.
Okay. You have 4 cases that we're working through today. And what's been explained to me is that you're pleading to 3 of them and 1 is going to be dismissed. Is that your understanding?
Yes, sir.
Okay. I'm just going to call out one of the cases. Ultimately, they'll all get on the record. The one that's on the trial calendar is 23 SC 190241, State versus Muse. Mr. Muse is here in court. His lawyer is appearing virtually with Mr. Muse's approval, and Ms. Nix is going to handle the pleas for the state. One last thing, Mr. Muse, before we dive into this. Mr. McClendon filed an entry of appearance on 3 of your cases, but there's one that Ms. Rios, who's seated behind you, is listed as your attorney of record. Ms. Rios and Mr. McClendon have discussed having Mr. McClendon just handle all the pleas, so it's just one lawyer for you. You okay with that?
Yes, sir.
Yes, good. Okay. Then in just a moment, Ms. Nix is going to put you under oath. Once you're under oath, make sure you answer all her questions truthfully. If you have questions at any point, let me know. If it's something you need to speak about in private with Mr. McClendon, we'll figure out how to do that, although that'll be kind of complicated. Hopefully the question will be something you can just ask me and, or you're comfortable asking him with the rest of us hearing, whatever that question is. But I do need you to let me know if like, wait, I'm not following what's going on. Okay?
Yes, sir.
All right, Ms. Nix.
Thank you, Judge. Mr. Muse, please raise your right hand. You swear or affirm that any statements or testimony that you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
You can put your hand down. Please state your true, correct, and legal name.
Shamarian Muse.
Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No.
Is there a medication that you normally take that you have not taken or been given today?
No.
How old are you?
22.
How far have you gone in school?
12th grade.
Did you graduate?
Oh.
Is English your native or dominant language?
Yes.
You understand that you've been charged with the following offenses in 23 SC 190241, 6 counts of aggravated assault,
Yes.
and in 24 SC 003877-01, carrying a weapon in school safety zone as a not lawful weapons carrier and criminal trespass.
Yes.
And in 24 SC 004695, possession of a machine gun.
Yes.
You understand that you have the right to plead either guilty or not guilty to these charges?
Yes.
You understand that if you plead not guilty or remain silent and refuse to enter any plea at all, then the state is required to prove the charges against you at a jury trial?
Yes.
Have you had the opportunity to review your rights with your attorney?
Yes.
Have you had enough time to speak with your attorney about all of the charges in these indictments against you, including the facts and circumstances relating to each charge?
Yes.
Do you need more time to discuss the cases with your lawyer, Mr. McClendon?
No.
Are you satisfied with his services?
Yes.
Mr. McClendon, do you waive a formal reading of the indictments for purposes of the plea?
Yes.
And do you waive any null defects in the indictments for purposes of the plea?
Yes.
Mr. Muse, do you remember having been arrested on each of these charges?
Yes.
Has your attorney advised you of the minimum and maximum sentence for each charge to which you're pleading guilty today?
Yes.
You understand that today you are entering a negotiated plea of guilty, which means that the state will recommend the following sentence to the court.
Yes.
Well, wait till she's going to tell you the sentence and then you can say, yep, that's what I understood, or, oop, that's not what I thought was happening.
In 23 SC 190241, for each count, each of the 6 counts of aggravated assault, the state recommends a sentence of 5 years to be probated, each to run concurrently with each other, but consecutively with the sentence in 24 SC 003877-01. In 24 SC 004695, the state recommends a sentence of 5 years probated to run concurrently with 23 SC 190241 and consecutive to 24 SC 003877-01. In 24 SC 003877-01, the state recommends, or the state will reduce count 1 to unlawful carrying a weapon under OCGA 16-11-126 and recommend a sentence of 220 days, which should be time served. As to count 2, the state recommends a sentence of 220 days to serve concurrent with count 1. And as a part of this plea agreement, the state will null pros 24 SC 004566. Special conditions of probation are no contact with Stephanie Booth, Timothy Turris, that's Turis, Azucena Flores Mora, Azucena CENAFLORESMORA. Haley Lindstorm, HAILEYLINDSTROM. Scott Voigt and Mildretta Williams. Mildretta is MILDREDDA. You can possess no firearms or replica firearms. Stay away from all incident locations. Complete 250 hours of community service. Forfeit any seized property and must maintain full-time employment or full-time school. Do you understand that's the state's recommended sentence?
Yes, ma'am.
Can you repeat you had the no contact with the victims? I was trying to keep up with the names. And then there was be in school or work, but I may have missed something in between.
Oh, yes. No firearms or replica firearms.
Okay,
Stay away from incident locations.
okay,
250 hours of community service.
yep,
And forfeit seized property.
got it. Okay, thank you.
Mr. Muse, do you understand that the court is not required to accept the state's recommended sentence?
Yes, ma'am.
Do you understand that the court has the right to sentence you to the maximum possible sentence on each charge?
Yes.
Do you understand that since there are multiple charges to which you're pleading guilty today, the court also has the right to run those sentences consecutively?
Yes.
Do you understand that if does the defendant have his final plea rights? I believe he does not in the aggravated assaults, but I'm not sure about the others.
Right, but I don't know about some of the others. I'll look in a second, but I know he does not for the aggravated assault, which in some ways is the biggest sentence. So to me, it's kind of moot, but we'll see how this plays out.
You understand that if the court decides to order a sentence that differs from the negotiated plea you're expecting today, you do not have the right to withdraw your plea of guilty.
Yes.
Are you currently on probation or parole anywhere?
No.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Yes.
Do you understand that while you're on probation, you must follow all the special conditions of your probation?
Yes.
Do you understand that if you fail to follow all the special conditions of your probation, then you'll be subject to revocation of that probation for the balance of your sentence?
Yes.
You understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Are you a United States citizen?
Yes.
You understand that by pleading guilty to a felony, you may not receive, possess, or transport a firearm?
Yes.
You understand that doing so could result in new criminal charges for which you face a sentence of up to 5 years?
Yes.
You understand that by pleading guilty to a felony, you also may not use a firearm in a crime in the future?
Yes.
You understand that if you were in the future to use a firearm during the commission of a felony, you would face a 15-year custodial sentence consecutive to the sentence for the underlying crime?
Yes.
Mr. McClendon, did we discuss first offender? I can't remember.
He is not electing to use first offender.
Okay. All right, Mr. Muse, do you understand that by entering a plea of guilty today, you are waiving any and all defenses, including any mental health defenses?
Yes.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, to remain silent, to confront witnesses against you, to the assistance of counsel, to the presumption of innocence, and the right to appeal if convicted of these charges at trial?
Yes.
Is it your decision to waive these rights and enter a guilty plea today?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes.
How do you plead to the charges of 6 counts of aggravated assault in 23 SC 190241?
Guilty.
How do you plead to the charges of unlawful carrying of a weapon and criminal trespass in 24 SC 003877-01?
Guilty.
And how do you plead to the charge of possession of a machine gun in indictment number 24 SC 004695?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you have only a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
Yes.
You understand that for the felonies, you have only 4 years from today to do so, and for the misdemeanors, you have only 12 months from today to do so.
Yes.
I'll start with 23 SC 190241. Judge, had that case gone to trial, the state would expect the evidence to show that on or about August 3rd, 2023, the defendant, Mr. Muse, did shoot a pellet gun that appeared to be a firearm at 6 individuals. Those individuals were Timothy Turris, Azucena Flores Mora, Haley Lindstorm, Scott Boyd, Mildretta Williams, and Stephanie Booth. Mr. Muse and his co-defendant were driving around shooting at these individuals.
Who was Mr. Key or Mr. Muse, the driver, from what you think the evidence would show?
Mr. Muse was the driver.
And then if I'm remembering from bond hearings, Mr. Key was like standing up through the moonroof, or this was out a passenger window?
Out of the moonroof.
Okay,
that's
or
only-
sunroof, whatever we want to call it. Okay.
Yes.
All right.
And so thereby putting each of these people at in reasonable fear of receiving a violent injury.
Were they all in the same area, as in just these guys did this once and there were 6 people standing together, or they were driving down the street, or it was 6 incidents separated by dozens of miles?
6 incidents, not separated by dozens of miles, separated by blocks.
It was all in the same neighborhood or
General
vicinity?
area, yes, sir.
Okay.
They were identified when officers were responding in the area and actually observed the defendants committing shooting at one of the individuals, and conducted an investigatory stop and arrested both individuals.
Okay.
And that occurred in Fulton County. In 24 SC 004695, had that case gone to trial, the state would expect the evidence to show that on or about March 28th of 2024, the defendant was in possession of a machine gun without being authorized under any provision of the Georgia Firearms and Weapons Act to do so. Officers came into contact with Mr. Muse and observed that he had the firearm and were able to confirm that it was altered to be a machine gun, and that occurred in Fulton County.
Meaning fully automatic?
Yes, a fully automatic.
Okay, so it wasn't necessarily some giant 50 caliber, it may have been, but it was a firearm that had been modified to be fully automatic.
Yes, sir.
Okay.
And in 24 SC 003877-01, had that case gone to trial, the state would expect the evidence to show that on or about April 27th of 2023, the defendant and a few other individuals trespassed on the property of the
Clark, Atlanta?
It's the Morris Brown Stadium, which is a defunct, it is no longer operating, but it is owned by Clark Atlanta Stadium, Clark Atlanta University. So it is technically school property, but it is, it's not being used. And so even though it is school property and the defendant was on school property with a weapon, it is a decrepit old stadium. And so the defendant is not a lawful weapons carrier. He was too young to lawfully carry a weapon. And so the state is reducing this count 1 to unlawful carrying a weapon. So the defendant and other individuals did trespass into this stadium, and officers made contact with them and discovered that Mr. Muse was in possession of a weapon, of a firearm, and that occurred in Fulton County.
Okay. So chronologically, this Morris Brown Stadium was first. We fast forward 4 months. He and Mr. Key are shooting people with a pellet gun. And then another 4 + 3, 7 months, he's got the fully automatic weapon.
Yes, sir.
Okay. The case that you're dismissing, what were the allegations?
That was a number of individuals who were, officers responded to a call about someone with a firearm, and about 5 or 6 individuals got into a vehicle.
Okay.
The officer did a stop on the vehicle, found a number of guns in the vehicle.
It's more guns, but I'm understanding why you're dismissing this one. But it's again, Mr. Muse around guns. It might have been harder to attribute one to him in that setting.
Yes.
But he's still around them.
Yes, there were, I think 5 defendants that were arrested.
I think was Mr. Key back in the mix again?
Yes, we dismissed the case against him as well, because the only gun that all of them were charged with was one that was also altered to be a fully automatic.
Okay.
It was not found at the feet of either of them.
Okay, but another machine gun?
Yes.
Okay. All right. Anything else from the state?
No, sir.
Good afternoon, Ms. Jackson. Any criminal history information on Mr. Muse?
He has 4 cycles. The last arrest was March the 28th, 2024 in Fulton County for possession of a sawed-off shotgun or sawed-off rifle. That case appeared to be still pending. That case number is 24 PI 002210. He does appear to have open cases pending. One is 24 SC 004566 for possession of a sawed-off shotgun or rifle. So additional open case 24 SC 004695 for possession of a sawed-off shotgun or rifle. Nothing in addition, Your Honor.
Thank you. Mr. McClendon.
Good afternoon. I believe the cases that were just mentioned are all the cases that we're dealing with. I believe, Your Honor, this is a fair result in our case. The facts of the aggravated assault, I agree wholeheartedly with what Ms. Nick said. The only thing I would add is that the pellets that came out of the projectiles, it was a water pellet. So I mean, it's technically a pellet. So I think a pellet gun is a fair reference. But I just wanted the court to understand that this was not a pellet that was going to wound someone, but it was certainly not appropriate behavior. I'm hearing an echo of myself. As far as Mr. Muse, I believe that I've seen like a different Mr. Muse since he has been in custody. I believe that we have received the message loud and clear that living a law-abiding, productive life is certainly a lot more beneficial, safe, and enjoyable than not. And he's here today and is accepting responsibility and asked the court to accept the plea as negotiated.
All right. I'm just looking at some numbers here. 6. Mr. Muse, anything you want to add?
No, sir.
Any questions?
No, sir.
When you get out, where are you going to stay? You don't need to give me like a street address, but like, is it your mom's house or your brother's house or what?
My mom's house,
Okay, and where does she stay?
Clayton County.
Clayton County? Is that where you were staying when these things happened, or this will be a new place to stay?
No, I wasn't staying with her then, but I'm staying with her.
Does she know that you're heading her way?
Yes, sir.
Okay. Do you have any kids?
Got one on the way.
One on the way. Boy or girl?
Boy,
When is he due?
next month.
Is mom doing okay?
Well, we've been going through it right now.
I mean, as far as you know, she's healthy.
Yeah.
Okay. I know you could be more helpful if you weren't where you are right now, but she's healthy. Have you ever worked before?
Yes.
What kind of work?
Construction and warehouse.
Where'd you go to high school?
Money's Mill.
And you went there 9th through however far you got?
No, I went to different schools.
Okay. The one you were at the very end was what you ever just said, Monday Mill?
Yeah, Money's Mill.
Monday Mill? Where's that?
Clayton County.
Were you living with your mom when you were there? Yeah. So you'll be going back to that same place?
Yeah.
Okay. The mother of your child, where does she stay?
And Clayton County.
Okay. All right. Well, Mr. Muse, I find there's a factual basis for your pleas. The common theme in all these is you and guns. And I mean, you must see this around you. You saw what happened to Mr. Key. Being around guns, whether they're on you or near you, can lead to unfortunate things happening, not just jail, but people getting shot. And the case that kept bringing you back here, which was the one where whether you were driving or Key was, doesn't really matter, shooting the, what do you call the little water pellets? There's some name for them.
Splat ball.
Splat ball. Shooting the splat ball may have seemed kind of funny, and no one got hurt. They clearly scared those folks. But the bigger risk is whether it's a police officer or a concerned citizen and they see you or Key swinging around what looks like a gun, they may have a real gun that shoots not splat balls. And then all of a sudden you get hit in the head, and then there's the end. So I'm hopeful, especially with a kid coming along, that you're going to figure out a way to roll a little differently. It will be a felony offense if you're around guns anymore. So if you're in a car and there's a gun in that car and you know it's there because it's in plain view, or you're staying in a house and there are guns in that house, that's going to be a new crime for you. You can't be around them. And so you just need to be thoughtful. And I know it's not easy, but you need to be thoughtful about where you spend your time and how you spend your time. It's very easy in Georgia and in America to have guns around you. That's just not something you get to do anymore. Fortunately for you, if you are into guns, you spend a lot of quality time with some pretty serious guns. But if they are around you in the future, if you get pulled over and all it is you had a bad taillight, which would be a citation, and then there's a gun, all of a sudden it's handcuffs and it's a felony and it's prison time. So just be thinking through that as you figure out how you're going to move forward. I'm not going to be there to be saying, don't do that. But I'll be right here when you come back because you were on probation and you got caught with a gun. So if we are together again talking about you and guns, it's not going to be probation. It's going to be something different. Is that clear?
Yes, sir.
Okay. I find there's a factual basis in each of the 3 cases to which you're entering pleas. I also find that your pleas are knowing and voluntary. Voluntary means no one's forcing you to enter these pleas, but that you've decided after having time to talk with Mr. McClendon and anyone else that this is the right way forward for you. Do you agree?
Yes, sir.
And knowing means you've understood the things we've been talking about. You've told me you don't have any questions. Is that still true?
Yes, sir.
Okay. And it's okay to have questions. Just you need to let me know what they are. No? Okay. I'm sentencing you pursuant to the Probation Options Management Act. And all that means is that while you're on probation, if you have a minor violation, then you and probation will work through that. But if you get arrested for anything, or you violate some of these no contact or stay aways, that will come back to me. Mr. McClendon, is it okay if someone in my office signs the 3 indictments to which your client is entering a guilty plea, signs on your behalf, Mr. McClendon?
Absolutely.
Ms. Nix?
Yes, sir.
And is it okay, Mr. Muse, if we sign for you as well?
Yes, sir.
Okay, we'll do that. Mr. Muse, going in chronological order, in the case of, where's the 241? 23, nope. In the case of 24 SC 003 877-01, the state has reduced the, let me get the indictment up. The felony count to a misdemeanor, and you're pleading to 2 misdemeanors. Your sentence as to both is 8 months to serve. By my math, you've actually done 250 days, 250. If we add up, you've been in jail 3 times in connection with all these cases. So I'm sentencing you to 8 months to serve, but you'll get credit for the time you've done. And that'll be 8 months to serve on count 1 and count 2. Those, am I misstructuring the case that is 877, or you reduced the felony to a misdemeanor? Is that correct?
3877-01,
Yeah.
I reduced the felony to a misdemeanor and offered time served.
Yep, but it's 2 misdemeanors then?
Yes.
Okay, so it's 8 months to serve, both counts running concurrently. Your next case chronologically is 23 SC 190241. That's the splat gun case. There are 6 counts there, and I'm sentencing you to 5 years on each of the 6 counts. It's 5 years probated. Special condition of probation number 1, no contact with any of those victims. I think they were strangers to you anyway. You don't know who they were, but stay away from them. Number 2, no contact with Mr. Key. He's not a relative of yours, is he? He is a relative?
Yeah.
How's he related?
Family, that's my brother.
He's your brother. Okay. Same mom or same dad?
Dad.
Okay. Before all this happened, were there lots of family events where you all would be together, or because it's different moms that was awkward and you didn't see him so much?
Be around sometimes, family events.
Okay, then I'm not going to say no contact with Mr. Key. Just know that his high roll in life, as his dad liked to put it, could be complicated for you if you're rolling with his high rolling kind of life. And I don't know what his life is like other than his dad got real upset when I suggested he wasn't a super important music star. So you can stay around Mr. Key. You will need to either be in school or working after you've been out for 2 weeks. You need to either be showing probation that you're trying to get a job or that you've enrolled in school. If you have done neither after the first month, then it is 5 hours of community service for every week that you aren't working or are in school. Just keep running every week. You will forfeit all the things that were seized from you in all the cases, so don't try to get that stuff back. In the final case chronologically, which is 24 SC 004695, there's just 1 count. That's 5 years probated. Special condition number 1 is 250 hours of community service. That's different from the +5 every week. That's just over the course of your probation. You need to knock those out. But that number will actually grow for the weeks you aren't in school or working, again, after 1 month. And you'll forfeit the property that was seized. That would be the gun that was seized in that case. The 2 cases with 5 years probation, they'll run concurrently with each other. That means at the same time, but they both run consecutively to the Clark Atlanta Morris Brown Stadium case. That's your 8 months to serve. So when those 8 months are up, which they're up, then you've got 5 years probation on top of that. which is what I believe you and Mr. McClendon negotiated with the state. Ms. Niles, do you have anything you want to add or questions about what I just said? I meant to say Ms. Nix.
Oh, no, sir.
Okay. Mr. McClendon, anything else?
No, Your Honor.
Okay. What's the zip code of your mom's house?
30238.
30238? Okay. Do you not need to type that, or you already know he's going to be in Clayton County? Okay. You just have memorized all the Clayton zip codes?
I used to work in Clayton.
All right, so you knew. All right, I was like, she didn't type anything in. Mr. Muse, we're going to get a couple more things on the record from Ms. Simpson, who's with probation. She's going to give you some reporting instructions, and then she may come back to talk to you just to get the specifics of your mom's address. We don't need to get that on the record. But the important part is she's going to be telling you, and she'll give you a piece of paper to that effect. Here's when you got to show up for probation. You don't want to miss that date, because if you miss it, you're starting out poorly, and they're going to just send me a warrant saying the guy didn't even show up to report for probation. Okay?
Yes, sir.
All right, Ms. Simpson?
So, Mr. Muse, you're going to report the Clayton County office, which can address under a instruction. It is tomorrow office, and that is going to be 1331 Citizens Parkway, Suite 201 in Monroe, Georgia. And your reporting date is February 6th at 8 a.m.
Any questions about that?
No, sir.
Okay, well, Mr. Muse, we'll see what happens. I'll be here, and we can talk again if things don't go well, but I hope it's a little different for you. You've been busy the last few months, okay? All right.
Thank you, Judge.
Thank you, Mr. McClendon. You're free to go.
Thank you. Take care.
All right. What are we doing? We have Mr. Brown online, so we can do that plea. Do we have an update on, because poor Ms. Singleton is still here, on either of the Hammonds?
Yes. Quantavius Hammond is ready for a non-negotiated plea. I don't know what's happening with the brother, so I didn't know if this should be done separately.
Okay.
Mr. Kraft is right outside.
Okay. Let's see what he has to say. Do you know what he's going to say?
I think it's negotiated.
Okay, so one negotiated, one non-negotiated. Interesting. Same set of facts where we could do the plea together, or we're not sure? Okay, we'll see what Mr. Kraft says. It's not two separate incidents?
No.
Okay. Hey, Mr. Kraft.
Yes, Your Honor.
I just got an update from Ms. Wood that her client, Quantavius Hammond, is ready for a plea. But if we can do them together because you have the same announcement, then I thought we should do that, unless you think there's a reason why the plea should be taken separately.
I don't believe there's any reason they should be taken separately. It's just that Jaquavius has a lot of questions that I've been going over.
Okay, I'm not rushing anyone, so if you want more time to work with him, I can take Mr. Brown's plea. He's sitting right here online, and we can check back in 10 minutes.
I think we might be finished by then.
Okay, let's do it. Mr. Brown, you are on, oh, you went to the tropics. You went far away.
Oh, yeah, this is back.
Okay. Let me know, Ms. Dilligard, when you are ready.
Ready to go.
All right. Mr. Brown, you're able to hear us?
Yes, sir. Loud and clear.
Okay, this is 24 SC 003210, State versus Brown. Mr. Brown is appearing virtually. His lawyer, Ms. Wood, is here in court, as is the prosecutor, Ms. Dilligard. Mr. Brown, before you get put under oath, I need you to tell me on the record that you are okay with us moving forward with your plea when you're not here in open court. You're appearing virtually. You're okay with that?
Yes.
Okay. Second, your lawyer is not right next to you. She's here in court, and if you guys need to speak privately, we can make that happen. But you have a right not only to be here in open court, but to have Ms. Wood right next to you so you could lean over and ask her a question. Are you allowing us to go forward with Ms. Wood here and not by your side?
Yeah.
Okay, then we're going to do that. Ms. Dilligard, when you're ready.
Mr. Brown, can you please raise your right hand? Do you swear or affirm that any statements or testimony that you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, I do.
You can lower your hand. Please state your true, correct, and legal name for the record.
Dantis Demore Brown.
Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No.
Is there any medication that you normally take that you have not taken or been given today?
No.
Excuse me, say it one more time.
No.
How old are you?
45.
How far have you gone in school?
GED.
Do you understand that you have been charged with the following offense, charged with 1 count of aggravated assault?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to that charge?
Yes.
Do you understand if you plead not guilty or remain silent and refuse to enter any plea at all, then the state is required to prove the charge against you at a jury trial?
Yes.
Have you had the opportunity to review the waiver of rights form with your attorney?
That's the list of- That's the list of questions we went over, but we did not fill it out.
Okay, and I don't know that Ms. Wood's microphone works, but I don't think it works. I think it's broken. Tap it. Yeah, it's broken. There was a form that Ms. Wood covered with you, I think when you were here. Do you remember that form?
Think so.
I don't mean, do you remember every word of it, but I'm gonna have Ms. Wood come up to the podium. She can explain better.
Yes, Judge, so because I've done so many pleas in this courtroom, I can roll them off the top of my head. So we went over the questions in the hallway, we just didn't fill out the form.
Got it. Okay, we're good.
Yes.
Have you had enough time to speak with your lawyer about the charge in the indictment, including the facts and the circumstances relating to that charge?
Yes.
Would you like any more time to discuss the case with your lawyer?
Kinda, yes. Well, no.
So I think part of the confusion, Judge, is because while what we've gone over so far is about what he's actually charged with, it's not what he's pleading to. And also, I do want to remind you, Mr. Brown, that I get to speak at the end, so don't worry, okay? I'm gonna say all the things we talked about.
Okay.
Right, and I want to also preserve this for you, Mr. Brown. Before I say, here's what I'm going to do, I'll be sure to ask you again. All right, we've covered everything. Anything you need to talk to Ms. Wood about? And you then, oh, no, I'm good now, or no, there's still something I'm not clear about. I'd like to speak with her privately, okay?
Okay, thank you.
All right.
Are you satisfied with your lawyer's services?
Yes, I am very much.
Counsel, do you waive formal reading of the indictment for purposes of the plea?
So waived.
And do you waive any and all defects in the indictment for purposes of the plea?
We do.
Mr. Brown, do you remember being arrested for this charge?
Unfortunately, yes.
Has your attorney advised you of the minimum and maximum sentence for this charge for aggravated assault? The range is 1 to 20. Judge, we've agreed to reduce to disorderly pursuant to 161139, the maximum on that charge being 12 months. Do you understand that?
Yes, you talking to me? Yes.
Yep.
Oh, yes.
Do you understand that today you're entering a negotiated plea of guilty, which means the state will recommend the following sentence to the court? Judge, again, we are asking to reduce the one count of aggravated assault to disorderly conduct pursuant to OCGA 16-1139 for 12 months probation, an anger management course, and 40 hours of community service.
So I missed the part about anger management, but I'm happy to address that at the end if we want to function this as a non-negotiated judge.
Okay. We'll let you revisit that when it's your turn.
Thank you.
Do you understand that recommendation, Mr. Brown?
I understand it.
That's all the question is, not do you like it or anything like that. Do you understand that's what the state will be recommending?
Yes, I understand.
You understand the court's not required to accept the state's recommended sentence?
Yes.
You understand that the court has the right to sentence you to the maximum possible sentence on this charge?
Yes.
You understand that if the court decides to order a sentence that differs from the negotiated plea you're expecting today, that you have the right to withdraw your plea of guilty?
Yes. Then one thing, what you mean withdraw my plea of guilty? I haven't pleaded guilty to anything.
We'll explain.
So you may, in a little bit, that's the point of this whole conversation. And all that Ms. Dilligard is letting you know is that if things don't go the way you were expecting, you will have the ability to say, wait, nope, I'd rather go to trial.
Okay, I understand. I just want to make sure I'm understanding her verbiage correctly.
You need to, and so I appreciate you flagging it when you're confused.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on your entering of a guilty plea today?
Yes.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Yes.
Do you understand if you're on probation, you must follow all of the special conditions of your probation?
Yes.
Do you understand if you fail to follow all the special conditions of your probation, then you'll be subject to revocation of that probation for the balance of your sentence?
Yes.
You understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Are you a United States citizen?
Yes.
Do you understand that by entering a plea of guilty today, you are waiving any and all defenses, including any mental health defenses?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to the assistance of counsel, the right to the presumption of innocence, the right to appeal if convicted of these charges at a trial?
Yes.
Is it your decision to waive these rights, which means not to use them, and enter a guilty plea today?
I'm sorry, can you repeat that?
Is it your decision to waive those rights that I just listed and to enter a guilty plea today?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to enter a guilty plea because you're in fact guilty?
No.
I didn't hear the answer.
No.
Okay, so Ms. Wood, can you help us navigate this?
So I just want to make sure it's to the disorderly conduct, not the aggravated assault. So she's asking if you're accepting a guilty plea to disorderly conduct.
Yes.
Okay. Is that good, Judge?
Sure, but the question, it is, that's helpful, thank you. It's focusing us on what the actual charge is that we're going forward on, which is disorderly conduct, acting sort of in a tumultuous manner. But what Ms. Dilligard's question is, are you pleading guilty to disorderly conduct because you are in fact guilty, as opposed to someone has a gun to your head or they're threatening to take your kid away or something like that?
Yes.
Okay.
Mr. Brown, how do you plead to the reduced charge of disorderly conduct in indictment number 24 SC 003210?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charge against you?
Yes. I really need more time to speak to my attorney.
Okay, can you come back down here? I don't know where you are.
Yes, I can.
All right, how long does it take you to get down here?
30 minutes.
Okay, that's probably smarter, just so folks aren't back and forth on the phone. I had to take a break at 3 anyway, so you'll be able to engage with him then. I'm sorry, Mr. Brown, to make you go back and forth, but you are 100% doing the right thing. If you are having reservations, concerned, confused, it'll just be a lot easier to have Ms. Wood by your side, so you guys can talk about this, okay?
Yes, sir. Thank you.
We'll be here.
Thank you, Judge.
Yep. All right, so I got about 20 minutes before I need to be in a meeting for a little bit. Should we do Statum? Oh, Miss Kim is on. What about that?
That should be quick, Judge.
Okay. Can we bring Miss Statum out? Is she up?
Oh, sorry.
No, I don't know why I'm saying, hold on. Let me say the right words. Ms. Harley.
Yes.
Ms. Statum is the plea, and we'll do that also, but Ms. Harley, I don't understand what, I think we're just talking about bond. Are you optimistic?
On here.
I'm sorry we waited too long. Hello, Miss Harley. If you come right to where that microphone is, keep walking towards me and turn. That's great. Miss Harley, we are trying to figure out what's happening with your case. Ms. Kim is on the screen, if you can see her. She was here all morning, but we weren't able to get to your case because it took a little while to get you here and then get you up. Not Ms. Kim's fault. She had to attend to some other business, but she's here virtually. You were on a trial calendar, I think, and we lost track of you. And you are in now on a bench warrant that I signed because I think you missed a court date. But I'm going to let Ms. Kim talk about what was going on, and then you can add to it.
Okay.
And then I'll hear from, I think, Ms. Nix.
Yes, sir.
From the state about what we might do, both in the short term, i.e. about bond, and then in the longer term, what are we doing with your case? Is it a trial? Is it a plea or what? But let's sort out that bond thing first. Ms. Kim?
Thank you, Judge. My client is 36 years old. She did miss her court date. She has picked up no new felonies. She did have a misdemeanor charge, and as I mentioned this morning, that's why she landed in custody, but she's been in custody in the Fulton County Jail since January 1st. I believe she was in prior to that on the other charge, but we're asking if you would allow her to come out on bond. I believe we should be able to resolve this case. My understanding from her family is that the named victim in this matter a couple of years ago was last known to have moved to a homeless shelter with her 2 minor children up in New York City. So I'm not sure where she is, but I'm hopeful that the state and I can resolve it. We've been in communication about it, so I think we're getting close.
Okay, thank you. Ms. Nix.
Judge, Ms. Kim and I did speak briefly yesterday about this case. I've not spoken myself with the victim, so I've not been able to confirm that she is in New York. I am concerned about the defendant also has another case pending in state court with the same victim. I'm not sure if that's the misdemeanor that Ms. Kim described. That is listed as in bench warrant status, but I'm not sure if
So what I thought Ms. Kim said this morning, and Ms. Harley can help us with this, I think you got arrested for some misdemeanor last month, this month?
This month.
This month.
On the first.
What was, so New Year's Day, you got arrested for what?
I was arguing with my spouse.
Okay,
The
and,
cops got called in the neighborhood and they picked up my warrant.
okay, is your spouse Ms. Burrows?
No, that's the one that I caught this year.
Sure.
She's in New York.
Okay,
She's in
so
the
this is what Ms.
New
Kim
York.
is saying.
Yeah.
And so Ms. Nix, you're saying this would have to be an old misdemeanor case then, the state court case?
This is probably the first time I got locked up dealing with Miss Burrows.
Okay.
Yeah.
But the most recent situation was you and your spouse got into an argument.
We handled that already.
Okay, and you've already been to court and dealt with it?
We good. We good with that.
What does "we good" mean? Like you pled guilty?
Well, I pled
it got
guilty.
dismissed?
I pled guilty. They gave me probation and anger management.
Okay.
And they basically I could go back home to her. Like we worked it out.
Got it.
Yeah.
But you just haven't been able to start that because this warrant's holding you.
Right.
Okay. Got it.
Judge, I just looked it up on Fulton County's website. Both the misdemeanors are all disposed of and closed.
The misdemeanors are what?
Disposed of and closed. They're closed.
Okay.
So I have 22 CR 000332E, which is listed in bench warrant status. And it is with the same victim as our case.
Okay.
Judge, I don't it doesn't sound like let's say I'm not jumping up and down about recalling the bench warrant. I just wanted to make Your Honor aware that there are 2 cases pending with the same victim.
Got it. When you say 2, there's this one, the 23 SC, as well as the 22 CR.
Yes, sir.
Okay, those are the 2.
And the case that is before you today, the aggravated stalking, the fact that the victim is in New York is she's not our only witness to this incident.
Okay.
So her being in New York does not lessen our case.
Got it. Ms. Harley, do you have a way, you seem to be pretty sure that Ms. Burrows is in New York. You know that?
I'm still in contact with her sister. I got a pretty good relationship with her sister. So
Okay.
That's how I know she's in a shelter in New York.
Okay.
But I don't talk to her, no.
No, I'm good. I'm glad to hear that. But it sounds like what I'm thinking about is this. I'm inclined to put a bond back in place, but I want Ms. Nix to have an opportunity to try to speak with Ms. Burrows first.
I don't have her number.
No, but you've got the sister's number.
Yeah, but it's in my phone. I don't know about her.
Okay.
I don't have no way of contacting nobody.
Got it. And your phone is sitting in property?
Yeah.
Okay. Ms. Kim, do you have any contact information for Ms. Burrows' sister? Pardon me?
I do not know.
Okay. Oh, we do have the officer who's a witness too, it looks like, from some of the counts.
Correct. And the officer is actually one of the victims. There is also a obstruction in this
Right.
case, but there's also some worker at the apartment complex who escorted Ms. Hurley off the property a couple of times on the incident date.
Okay.
That's where I was living at as well.
Okay.
Mhm.
All right. So what were you going to do, Ms. Nix, in an effort to try to reach Ms. Burrows?
We have already, I have already requested a victim locate, and I followed up yesterday with the investigator in my new unit about that. I've not heard from that person. I've not actually met that person in person, so I'm not sure if they thought, I don't know who this is. So I'm gonna go once I get out of court to go and follow up in person with the investigator. And I will keep working on this.
Okay. Where would you stay, Ms. Harley, if you got out?
Oh, I'm going to my grandmother's house, 1183 Oak Street.
Okay, that's the address we've got in the system. So here's my proposal. I'm gonna give Ms. Nix's research team a little bit of time to try to track down Ms. Burrows. And I will look for an email from Ms. Nix sometime on Monday. That email should go to Ms. Kim as well, letting us know we found her. She is in New York, so we're a little less concerned about the bench warrant because that's far away. We found her, and here are 10 reasons why Ms. Burrows is concerned about Ms. Harley being out, or we didn't find her. And then I'll react accordingly. And likely, if it's the first or the third options, figure out is your request, Ms. Kim, is to reinstate the bond that was there before?
If possible, Judge, she's been in custody, so obviously she's not working and has limited means to be able to post another bond.
Okay. You know, it does say on the bond, in big, all caps, bold, victim relocated to New York. So, and that bond was.
Yeah, excuse me, she went to New York when I had got locked up the first time.
Yeah.
For this case, she went to New York from then.
Yeah. So I'm just saying that Judge Borski, when she signed this bond, put in big letters, victim relocated to New York.
Yes, sir. And that was what, 2023? So.
No, 2022. So things could have changed.
Things could have changed.
Yep. Okay. All right. So that's the plan. And this case was on a trial calendar. I'm gonna put it right back on a trial calendar. And hopefully Ms. Kim and Ms. Nix, our 2 3-lettered attorneys, will try to sort this out.
Do you expect it to be, I guess, the end of February? Is that when you're next?
It's not till March something.
March, okay.
Yeah.
Yes, sir.
All right, Ms. Harley, any questions?
No, so I gotta stay in here until
Monday.
Okay.
And then by then I may hear something tomorrow from Ms. Nix, but Ms. Nix is going to send your lawyer and me an email saying, here's what we found Ms. Burrows. We couldn't find her. Okay. If they can't find her, that's not your problem.
Okay.
And so I will likely reinstate this bond. I'll modify the conditions a little bit. But the bond that you got is what the state recommended back 2 years ago.
Yeah.
Almost 3 years ago. And so it seems to me we ought to put that bond back. The wrinkle was you missed court. So don't miss court anymore.
Yeah.
But we've got a good address for you in the system, so you'll know, and Ms. Kim will know when you need to be back in court. Okay?
Okay.
Anything else, Ms. Kim? Hold on 1 second.
Nothing further, Judge, maybe.
Oh, my probation.
Oh.
My probation.
Okay, so you can't go anywhere anyway.
No. I
Got
have to
it.
go to Clayton County after this.
Okay. I could still reinstate your bond, but Ms. Simpson is providing the helpful notification that you would then go to Clayton and have to deal with that.
I have to, after this, I have to go to Clayton.
Okay. All right. Good to know. Thank you. All right, give me a second. All right. I got about 5 minutes before I have to go to this meeting. Is there something quick we can do, or should we map out what remains? Okay. Let's start with the trial calendar. Go with those guys. Tim. So, Mr. Craig, the magistrate judge has thrown down and said, I'm not continuing his case. We're more important. Okay, we'll see, but I also understand the subpoena situation. Kimbro, so we still have a plea on Kimbro. That's ready to go. You don't need to talk to him anymore as far as you know?
I've already talked to the judge. It'll be round 2 of a non-negotiated, and I believe,
When you say round 2, we tried to do a non-negotiated before?
it's before Mr. Jordan left.
Oh, okay. And we got through and he said, no, we didn't even get through the plea. He didn't like the answer.
Right.
Okay.
Something different I'm gonna put up.
Okay.
And I think Ms. Hodge is on to cover for Ms. Clark. I think she's on the Zoom.
Okay, I'll check and, on that case?
Yes.
I am. Hi, Judge.
Hey, Ms. Hodge, how you doing?
I'm doing well. How are you?
I'm well. You're gonna be able to take a break for a little bit because I gotta go to a meeting. But we will do the Kimbro plea when I get back. We have the Hammonds. And I know Mr. Kraft was wanting more time to speak with his client, and he can have even more time because they're not back in here yet. The goal would be to take those pleas together, if we can. And I think that's it for the trial calendar, which then gets us back to the inquiry calendar and Mr. Pierce. Newmeister, is he doing okay and we'd still be able to do it, or he's been here too long?
He's okay, and I think we can get through it.
Okay, and then we have a plea with Mr. Statum, but maybe it's 2 cases?
There's 2 cases for the plea.
Okay, all right. You guys can talk through the order in which we're gonna do that. Pierce will be last. Pierce may be another day. I may bring Pierce back. Were you gonna be here? You weren't gonna be here tomorrow. I don't wanna make you show up when you don't have to.
I'd like not to be tomorrow so I can prep for this.
Yeah, okay, we'll figure that one out. Okay, we'll figure that out. All right, I will be back in a little bit and you guys can decide the order in which we're gonna do things, okay?
So I'll tell you, Peter's that.
Why don't you bring him to the door? I have time to tell him we're not gonna get to it today, but we will bring him back. Pierce? Because I don't want him to not be told. Everyone wants to belong to something. Hey, Mr. Pierce, I gave you some bad info. I am running into a whole lot of cases that we need to resolve, like people are gonna plead guilty. So you and I are still gonna have that conversation about you representing yourself and your rights and jurisdiction. Promise you that. We might not fit it in today. And so I didn't want you to be surprised if these gentlemen take you back downstairs. It's not because I'm ignoring you in any way. I will get you back here soon so we can have that very same conversation. You can have all your papers with you. You'll get to be front and center and we'll talk about all that, okay?
Is there a way I can give you a copy of my, American National Standing right quick?
If it's a copy you don't need anymore, you can leave it with the deputy and he'll get it to me, okay?
I got a copy for the DA, the, court clerk, and you.
Fantastic. If you leave that with me, I'll make sure it gets to all those people.
Okay.
All right.
I also filed, I filed my executive letter, I got it sent to certified mail. And I also filed a pro se ex parte with prohibition. So this is my case, but it's in the mail right now.
Okay, we'll be looking for it.
Okay.
Thank you.
Yes, one for the judge, the court clerk, and the DA.
We're keeping you up? Yeah, okay. Mr. Brown, you're back. Did you get a chance to speak with Ms. Wood? Are we back on track? Maybe not, we'll see. Okay. Where's Ms. Wood?
She was just here.
Okay, my thought would be, since we got halfway through Mr. Brown, we finished Mr. Brown. What do we know about your client, Mr. Kraft?
Your Honor, we are gonna go forward with a non-negotiated.
Okay, so 2 non-negotiated pleas. Any reason why we couldn't have your client take his plea at the same time with his brother?
I don't think so. I think the only thing we need to make sure of is that Ms. Singleton is on the Zoom, because I think she had to go back to her office. Okay, she has this day job that's getting in the way of this. So let me see. I don't know if she is the Samsung, but we're going to finish Mr. Brown anyway, and that may give Ms. Singleton a chance to get to her office. Ms. Wood, Mr. Brown, I think is back on track. That's what he was saying. Did you get a chance to speak with him?
I did, Judge. I don't think this is gonna be a plea, right? Okay, yes.
Okay, so, on a different track, Mr. Brown, this is the trial calendar. So if you are not resolving your case now, which is fine, then I'll probably see you on Monday or the following Monday for a trial of your case. You're charged with actual felony, the aggravated assault. You and your mother, I think it was a pole allegedly, and something else, whacking Sterling Ridley. So that's what we'll do if we're not resolving your case today, is have that trial. So we'll bring in a jury, they'll hear the evidence, but you'll need to be here for all of that. It's not a, hey, I'll be back in a little while. But as long as you understand that, then we can move what I thought was over here on the plea column over to the trial column. You understand that's what will happen if you step back from the plea. Okay. Ms. Wood, do you have a preference as to week for Mr. Brown's case?
Given that I'm thinking my other murder case will go the week 2, I would prefer week 1.
Okay.
But I'll be around. So.
You will. Any reason to think that Ms. Brown's case is not going to be a plea? I know her lawyer's not here, so you're speaking for someone you don't represent, but it would make more sense to try the Browns together, which would mean we would want to do that week 2 because Ms. Brown's lawyer can't start a trial on Monday.
Judge,
and you might say, I'm not going to offer a plea to Ms. Brown. It's got to be a trial for both if it's not a plea for both.
So Ms. Cabrera and her client have been working on getting a piece of crucial mitigating evidence that for me to consider. And so she's still working on that. And I think it would be mitigating evidence in both cases. And so it may change the resolution that was offered today, but I just haven't received that yet. I understand she's been on leave. And
sure.
So I believe it's going to be a resolution if I receive that mitigating evidence.
Okay.
And so I can't really give a very clear answer, and I apologize, but I do believe that it's forthcoming after my conversations with her,
okay.
Even last night.
Is it something that Ms. Cabrera has to get, or is something that Ms. Brown or Mr. Brown could be getting?
Ms. Brown is, I think, my understanding of the email that I got today was that she was going down to police headquarters to try and retrieve it herself.
Okay.
Brown.
Okay.
And so I've also asked if he had that information, and I don't believe he had it in his possession, but they were working on getting it.
What is it? The police have someone's cell phone, and there's something on the cell phone, or what are they going to have?
It's so they presented some information that our victim may have been an aggressor in the issue, and that they've had issues with the victim in the past. And
okay.
I had to call 911.
Got it.
I've asked my investigator to seek those calls and incident numbers. They weren't able to find anything, so they're trying to retrieve those reports.
Okay. That makes more sense. Okay. Ms. Wood, do you need Mr. Brown to stick around? Mr. Brown, it was nice seeing you twice. I'm sorry you had to do the double commute. But look for a phone call or an email from Ms. Wood letting you know you got to be here this coming Monday or the Monday after for trial or something else with your case. All right? All right. You're good to go. Can we do the Hammonds now? Yes. All right. Let's do that. Ms. Singleton's not on yet. As long as she gets on during the course of this, are we okay? Or does she need to be on from the get-go?
I don't think she needs to be on yet.
Good. Then let's get started while we got everyone here and see what we can do.
Judge, where do you want us?
Let Deputy Gordon array you all. Just follow his direction as to where people are going to be standing other than Ms. Dilligard. You ready? Okay, let's go on the record in 24 SC 003942. We have two Hammonds, and so when I refer to you two, I'll use your full name. It may be when Ms. Dilligard is asking questions, because you all are going to have the same questions a bunch of times. Well, there'll be many questions, but they'll be the same for both of you. She may say simply Quantavius and then Jaquavius. She's not trying to be informal, but if she says Mr. Hammond, it's not going to be clear who she's talking to. But the way we're going to work it, just sticking in the order of the calendar, one of the questions that Ms. Dilligard will have is, how old are you? And what she'll say is, how old are you, Quantavius? And you'll always get the question first. That's going to help our court reporter. So she'll know the first answer is always coming from Quantavius, whether it's yes, no, I don't know, I'm 25, and then it will be Jaquavius. And that's just because that's the order on the calendar here. And there'll come a point where we're working with you individually. So it'll be Ms. Wood and Quantavius Hammond and Mr. Kraft and Jaquavius Hammond. But for a whole bunch of it, you have the very same questions. And so Ms. Dilligard will simply ask that question once, and then each of you will answer whatever your answer is. Make sure you answer out loud. You're welcome to nod your head, shake your head, but you also need to verbalize it and not but yes, no, maybe, whatever it is, so the court reporter can take that down. Quantavius, does that work for you?
Yes, sir.
Jaquavius, does that work for you?
Yes, sir.
Great. Then Ms. Dilligard is going to put you under oath. You'll start answering questions. If at any time you're not following what's going on, stop us so that either your lawyers or I can explain what's going on. Will you do that? Quantavius.
Sir.
Jaquavius.
Yes, sir.
We're ready.
Okay, can you both raise your right hand? Do you swear or affirm that any statements or testimony that you should give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth? Quantavius?
Yes, ma'am.
Jaquavius?
Yes, sir.
Quantavius, oh, you can both put your arms down. Quantavius, can you please state your true and correct legal name?
Quantavius Hammond.
Jaquavius?
Jaquavius Hammond.
Are you at this time taking or under the influence of any medicine, drugs, or alcohol? Quantavius?
No, ma'am.
Jaquavius?
No, ma'am.
Is there a medication that you normally take that you have not taken or been given today? Quantavius? Jaquavius?
No, ma'am.
How far have you gone in school, Quantavius?
11th grade.
Jaquavius?
I'm currently in 11th grade.
Quantavius, you're not in school anymore, or you are in 11th grade right now?
I'm not in school no more. I enrolled in the GED program.
Okay, so you're in a GED program. You went through 11th grade. But Jaquavius, you are in 11th grade right now.
Yes, sir.
Where are you in high school?
I actually go to South Atlanta, but they got me placed in an alternative school due to the situation.
Okay, thank you.
Do you understand that you have been charged with the following offenses? Charged with armed robbery, 1 count of hijacking a motor vehicle in the 1st degree, one count of aggravated assault, and one count of possession of a firearm during commission of a felony. Quantavius.
Yes, ma'am.
Jaquavius.
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges, Quantavius? Jaquavius?
Yes, ma'am.
You understand that if you plead not guilty or remain silent and refuse to enter any plea at all, then the state is required to prove the charges against you at a jury trial. Quantavius? Jaquavius?
Yes, ma'am.
Have you had enough time to speak with your lawyer about all the charges in this indictment, including the facts and circumstances relating to these charges? Quantavius? Jaquavius?
Yes, ma'am.
Would you like any more time to discuss this case with your lawyer? Quantavius? Jaquavius?
No, ma'am.
Are you satisfied with your lawyer's services? Quantavius? Jaquavius?
Yes, ma'am.
Counsels, do you waive a formal reading of the indictment for purposes of this plea?
Yes.
And do you waive any and all defects in this indictment for purposes of this plea?
We do.
Quantavius, do you remember having been arrested on these charges?
Yes, ma'am.
Jaquavius, do you remember being arrested on these charges?
Yes, ma'am.
Has your attorney advised you of the minimum and maximum sentence for each charge to which you are pleading guilty to? So for armed robbery, Judge, the state's recommendation is going to be reducing that to robbery
Okay.
under OCGA 16840, the minimum being 1 year, the maximum being 20 years. On hijacking a motor vehicle, the minimum being 1 year, maximum being 20 years. Aggravated assault, minimum being 1 year, maximum being 20 years. Possession of firearm during commission is 5 years consecutive. You understand that?
Yes,
Quantavius? Jaquavius?
Yes, ma'am.
It's,
I think, is it 10 to 20?
yeah, hijacking a motor vehicle is 10 to 20.
Okay, I just looked at that. So for hijacking a motor vehicle in the first degree, the minimum is 10 years, the maximum being 20 years. Do you understand that, Quantavius and Jaquavius?
Yes, ma'am.
Do you understand that your pleading guilty today is called a non-negotiated plea and that the state may recommend a sentence to the court even without your having agreed to it in advance? Quantavius? Jaquavius?
Yes, ma'am.
Are you aware that the state's offer is for count 1 to reduce the armed robbery to robbery pursuant to OCGA 16840, combined sentence of 12 to do 2, 100 hours of community service, actively seek remain employed throughout the length of their probation, no drugs, no alcohol, no firearms or replicas.
12 served 2 balance probated.
Correct.
Okay. Can you start the conditions over again?
Of course. There is 100 hours community service.
Yep.
Actively seek or remain employed.
Okay.
No drugs, no alcohol, no firearms or replicas. There is $875 in restitution, which would be total, Judge. So we don't need that paid twice.
Okay.
And then there's a no contact with each other for 3 years of the sentence.
With each other. Okay. I assume there's a stay away from Ms. Jackson.
Yes, there is.
Okay. Okay. All right. Thank you.
Are you aware that's the state's offer?
Oh, yes, ma'am.
Yes, ma'am.
Okay. And have you discussed this with your lawyer?
Yes, ma'am.
Quantavius?
Yes, ma'am.
Jaquavius?
Yes, ma'am.
Okay. Do you understand that the court can impose any sentence authorized by law, including a higher sentence than that recommended by the state, up to the maximum sentence on each charge? Quantavius. Jaquavius.
Yes, ma'am.
Do you understand if you enter a non-negotiated plea, you do not, is that correct, Judge? You do not have the right to withdraw?
Correct.
Okay, you do not have a right to withdraw your plea once the court enters its sentence.
I think final
Right,
rights
are
are
reserved.
preserved.
Oh, did we preserve
I
them?
believe
Okay, it
we
wasn't on the calendar, but
So I wanted to just.
I believe, my notes say that they have been
they
preserved.
were, okay, and it may have been because of that discovery issue. Mr. Kraft was waiting on some stuff, and so we said, let's just table it until now, and hopefully the discovery will have come in. Okay,
Judge, just so I'm clear, we reserve final rights, but after you pronounce sentence, I'm still clear that that's final, correct?
so if your final plea rights were preserved, and I'm recalling that they were,
Yes.
then we'll get a little further along. I'm going to hear from everyone, and then I'm going to say, here's what your sentence is. And if the sentence that I impose for Jaquavius is more than what you asked for him, you guys can huddle up. He can say, yeah, it's not what I wanted, but I'll take it because I don't want to go to trial. Or he can say, no, thanks. I was willing to take what Mr. Kraft asked for, but not what you imposed, Judge. And so he effectively backs out, no questions asked, no harm, and then we go to trial.
Okay, all right.
Did that answer your question?
It did, Your Honor. I just wasn't aware of the wrinkle that final plea threw in there.
Okay.
But I'm fine. I'm clear.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history? Quantavius, Jaquavius.
Yes, ma'am.
You understand that if you are currently on probation or parole, your probation or parole may be revoked based on your entering of a guilty plea today.
Yes, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit? Quantavius.
Yes, ma'am.
Jaquavius.
Yes, ma'am.
Do you understand that if you're on probation, you must follow all the special conditions of your probation? Quantavius.
Yes, ma'am.
Jaquavius.
Yes, ma'am.
Do you understand that if you fail to follow all of the special conditions of your probation, then you will be subject to revocation of that probation for the balance of your sentence? Quantavius. Jaquavius.
Yes, ma'am.
You understand that you are not allowed to possess or use a firearm while on probation? Quantavius. Jaquavius.
Yes, ma'am.
Are you a United States citizen? Quantavius. Jaquavius.
Yes, ma'am.
Do you understand that by entering a plea of guilty today, you are waiving any and all defenses, including any mental health defenses? Quantavius. Jaquavius.
Yes, ma'am.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to the assistance of counsel, the right to the presumption of innocence, the right to appeal if convicted of these charges at a trial? Quantavius. Jaquavius.
Yes, ma'am.
Is it your decision to waive these rights and enter a guilty?
Excuse me, I'm not hearing Quantavius. He has to speak up.
Okay, if we could bend the microphone towards the middle, there we go. Okay, we're good. Just belt it out like you're outdoors. Okay.
Is it your decision to waive these rights and enter a guilty plea today? Quantavius.
Yes, ma'am.
Jaquavius.
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea? Quantavius.
No, ma'am.
Jaquavius.
No, ma'am.
Is it your decision to enter a guilty plea because you are in fact guilty? Quantavius.
Do you have any questions about that? Either pleading guilty or not.
Yes.
Okay.
That was Quantavius. Jaquavius.
Yes.
Quantavius Hammond. How do you plead to the reduced charge of robbery, 1 count of hijacking a motor vehicle in the first degree, 1 count of aggravated assault, 1 count of possession of firearm, during commission of a felony and indictment number 24 SC 003942.
Before you answer that, I want to make sure we're not backing into something that's hard to back out of. Is your understanding, Ms. Dilligard, that hijacking a motor vehicle is a probatable sentence? I'm wondering what I'm missing, because here's what 16.544.1 C1 says. Don't worry about all those numbers, but if you're convicted of what they're pleading to, it's a sentence of imprisonment from not less than 10 to more than 20 years, big old fine. Keep going. If it's your second one, you're in a whole lot of trouble. The punishment imposed pursuant to this paragraph shall not be deferred, suspended, or probated. I had always thought that carjacking was like armed robbery, where it was 10 to 20 to serve, but the difference was it was parolable, but not probatable. But then there's always the 1710 6.1E, but that applies to serious violent felonies, which is armed robbery and not carjacking, hijacking a motor vehicle. And so I don't want to impose an illegal sentence, although the only one who would be in a position to fuss about it would be the state. But really, I don't want to impose an illegal sentence. So I'll take the lawyers in whatever order, because I know the recommendation isn't 10 years to serve, it's 12 to serve 2. I don't know that that's a legal sentence.
I looked at the statute briefly before we got up here, and I quickly thought that it was saying that it just had to be at least 10 years probation, but now that you're saying that, I'm wondering if I was, because it doesn't say hijack first degree in the indictment. If you look at the code section, it is the first degree one. I think if it's hijacking second degree, it can definitely be probated, but I will double check. Can you give me my red book?
It's definitely first.
Yes, first.
Yeah, it's charged as first degree, it's B1, and that would fit the allegations because it's carjacking with a weapon, as opposed to second degree is just when it's a slider. A slider would be a B2, and this, at least as it's charged, is not a slider case.
Right.
So I flagged that only because if the state is committed to this disposition, then it might need to null pros count 2 and proceed with count 1 gets you your 12 to serve 2. So does the aggravated assault. I believe that going forward with carjacking requires a 10 years, but Ms. Nix, you may see it differently. She's striding forcefully up.
I always try forcefully.
And Judge, I was under the false impression that carjacking was, we're able to do a downward departure with that. So
Yeah, it's an odd one that falls between some cracks. It's mirrored on armed robbery because it's an armed robbery. It's just you're taking a car, but the way the legislature was trying to stick it to people was you can get an armed robbery and a carjacking, so you get 2 convictions. But otherwise, it's a lot like it's the 10 to 20. And the sentence that I'm stuck on is that one that says the punishment imposed shall not be deferred, suspended, or probated. And so if I were to say 12 serve 2 balance probated, that's probating, and it says don't do that. So I feel like that's an issue.
So way we'd be able to amend it to second degree without the complication.
You can amend it. If you want to reduce it to second degree, you can do that in the same way you're reducing armed robbery to robbery, and that would fix it. The difference would be that, you could still have that same final sentence. I'd have to structure it differently because second degree carjacking is 1 to 10, but I can still get to 12 with the robbery and the aggravated assault. So I don't mean to throw that wrench in there, but the clerk's office might throw the wrench in there if this is anything along the lines of what we're going forward with.
Yes, Judge.
Say you don't like it, I can't get the 12 due to because you're saying,
but it gives you what we go to trial. So you don't have the option to deny waiver. You do, but then you're gonna have to go to trial if I deny waiver. So either you can offer something or I can take a big offer.
Judge, we're just texting Deputy Rao for the
green light?
green lights, yes.
Okay,
It's certainly not the state's intention for them to serve 10 years, so.
okay.
And I was making sure that this downward departure wasn't, serious violent felonies, including these listed, that is specifically those listed.
Okay, Judge, we are ready to proceed.
Okay, so we're on the record again, and the state is moving to reduce count 2 to
Hijacking may become the second.
second degree, which has a range of 1 to 10. Okay, got it. Quantavius Hammond, did you follow what just changed?
Yes, sir.
Things got better for you. Okay, Jaquavius, did you follow what just happened?
Yes, sir.
All right, back to you, Ms. Dilligard.
Okay. So, Quantavius, how do you plead to the charges, the reduced charge of robbery, the reduced charge of hijacking, and the removal in the second degree, 1 count of aggravated assault, and 1 count of possession of a firearm during commission of that?
Guilty.
I'm sorry. An indictment number 24 SC 003942.
Guilty.
Jaquavius.
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charge against you?
Yes, ma'am.
You understand that you only have a limited right to appeal this guilty plea conviction, Quantavius?
Yes, ma'am.
Jaquavius?
Yes, ma'am.
You understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition, Quantavius?
Yes, ma'am.
Jaquavius?
Yes, ma'am.
You understand that for a felony charge, you only have 4 years from today to file a habeas corpus petition, Quantavius?
Yes, ma'am.
Jaquavius?
Yes, ma'am.
Judge, if this case were to proceed to trial, the evidence would show that on May 22nd, 2024, the victim, Ms. Jennifer Jackson, reported to Atlanta Police Department that she was a victim of a carjacking on May 20th, 2024, around 1 p.m. The incident occurred at 2645 Old Hapeville Road, where Ms. Jackson had gone to visit her ex-girlfriend, Ms. Juhan. Ms. Juhan is the mother of both of the defendants. Upon arrival, Ms. Jackson encountered Ms. Juhan's 2 sons, Quantavius and Jaquavius, both of whom she had known for over 6 years. During the interaction, the 2 boys unexpectedly brandished firearms, placed them to Ms. Jackson's head, and demanded that she exit the vehicle, which was registered to Ms. Jackson's current girlfriend. Ms. Jackson, shocked, hesitated, and when she did, one of the boys, it's the state's position that it was Jaquavius, struck her on the side of her face with the firearm right underneath her eye, causing a laceration. Boys then stole the vehicle, which also contained Ms. Jackson's iPhone 15. Ms. Jackson immediately went to Ms. Juhan's apartment, who called her sons and instructed them to return the vehicle. However, they refused and instead told their mother that they would leave the car at the Glen Hollow apartment on Candler Road. Ms. Jackson called 911, but after waiting for a while, just went to go retrieve her own vehicle. So she was able to recover her vehicle at 4 p.m. that day, but her iPhone was not there. Following the report, investigators reviewed body cam footage. They interviewed a witness who also confirmed seeing the two males there. The witness did not got camera footage of them there. She did not catch footage of the actual incident, but she did witness the entire incident. Her description matched the descriptions that the victim gave as well.
Description of the two people who were involved, or her description was, yeah, I saw this guy smack her in the head with a gun?
The witness confirmed seeing the two males, and it matched the descriptions of the suspects too, that Ms. Jackson gave as well.
Okay.
Ms. Jackson later positively identified both suspects in a photo lineup. Judge, we've had constant contact with the victim in this matter, who was conflicted because she's known both defendants for quite some time, and felt like they had a good relationship. She was very shocked by the incidents that occurred that day. Her wishes are just that they both do better, whether that be school or getting, a good education, getting a job. But she's also conflicted because she feels as though she could have lost her life that day, of course. So there are some concerns for the state regarding the retrieval of evidence. And so that is why we've recommended that we resolve this case in this matter. Also taking into account the defendants and where they stand age-wise. Also that they've been in no trouble since the incident. We felt as though this was a good resolution to this case. And I don't know if I've already stated this, but all this did occur in Fulton County, Georgia.
All right. That's a complicated set of facts. It's very simple what happened, just the connection with people is complicated. All right, Ms. Jackson, criminal history for either of these young men.
For Mr. Quantavius, Your Honor, he has 3 cycles. The last arrest was June the 1st, 2024, out of Decatur, Georgia, for possession of tools for commission of a crime. There was no disposition for that arrest. He appears to have an open case pending in Clayton County for theft by receiving stolen property and possession of tools for commission of a crime and misdemeanor obstruction of an officer. Nothing in addition.
Anything for Jaquavius?
He has 3 cycles as well. The last arrest was December the 26th, 2024, with the City of Atlanta Police Department for battery and criminal trespassing and misdemeanor obstruction of an officer. There was no disposition for that arrest, and there are no convictions.
How does he get arrested while he's on bond and nothing happens? This was Jaquavius. I don't understand. Okay. I appreciate that info. It muddies the waters more. All right. Ms. Singleton, I appreciate you spending so much time with us today. Do you have anything to add on Jaquavius's side?
He has a prior juvenile case, a theft by taking involving a stolen gun. That case involves him and his brother that he was received probation on in juvenile court on October 19th of 2023. That probation closed. An order was signed by Judge Crawford on November the 20th of 23, closing that. And I was listening, Your Honor, about, was that a December 2024 arrest?
That's what Ms. Jackson said, that while Mr. Hammond was on bond for this case, so a month ago, he was arrested, city of Atlanta, battery, and maybe had a gun.
That was not, no one contacted me concerning that case, Your Honor, and he has an ankle monitor on, and I never received any alerts about it.
No, these guys both have ankle monitors, so that's the disconnect for me. If ankle monitors are doing their work, we would have nipped that one in the bud, and Mr. Hammond, Jaquavius, would have not walked through the door he walked through today. Okay. All right. Thank you.
Yes.
All right, Ms. Wood.
Thank you, Judge. Can Ms. Rivers hear me? Okay, I know I talk loud. As you know, Judge, there's often two sides or more than two sides to every story. So, Mr. Hammond shared with me that actually there was a lot more to this story, that the victim was actually coming over, yes, to see their mother, but also to sell some drugs. And so
To mom?
Or to these gentlemen.
Okay.
And so that's why there was a congregation around the Mustang when it was discovered that and also not only drugs for sale, but also a firearm for sale.
Okay.
And so when it was discovered that the drugs were not up to par, there was a disagreement, and I don't know exactly. I think maybe the victim had a gun, but there was some sort of struggle over a gun. And I think that might have led to her getting injured on the side of her head. The report was made 2 days later. As you heard from the state, she didn't wait around for law enforcement. She took an Uber to the vehicle, and she found the vehicle because she talked to mom, and mom was able to tell her where the vehicle was.
At the Glen Cove Apartments.
Yes.
Right.
So while it is a very serious case, Judge, it's not stranger danger carjacking. My Mr. Hammond, Quantavius, served 63 days in custody. Judge, he's 19 years old. He currently lives with his father. He has one child, a 5-month-old daughter. He does have an 11th grade education. He's currently working on his GED. So our request of the court is to consider a sentence of 12 years probation to serve 63 days. I think if the court were to think more time would be appropriate, I would request weekends in jail to be served at Rice Street. I would ask that completion of the GED or full-time employment be a special condition. I'm also requesting a restitution hearing. And finally, I don't think a 3-year stay away from these brothers is appropriate. I think having them on probation is going to be, enough incentive for them to stay away from criminal activity, Judge. Lastly, Mr. Quantavius Hammond is asking to be treated as a first offender.
All right. Mr. Kraft.
Yes, Your Honor. I will start by informing the court that Jaquavius also wishes to be treated as a first offender. I don't have a lot to add to what Ms. Wood has stated before, because I believe Jaquavius and Quantavius' story has been the same in terms of how and why they were meeting up with Miss Jackson, the alleged victim in this case. I will tell you, Judge, that in speaking with Jaquavius over the past couple months, he's expressed to me his fear of going to prison, not just losing his liberty, but in terms of how it would affect him in terms going forward and remaining a law-abiding citizen. I think he'd be the first to admit that he's had some issues staying, on the right side of the law, but I believe he is maturing. I think you've heard from at least Miss Singleton, I don't know about that incident in December. This is probably the first time I've heard of it, and I think it's the first time Miss Singleton heard about it. But he had pretty much had stayed out of trouble while awaiting this court date. He has mentioned to me, one of the things he mentioned to me today, just kind of out of the blue, is how he wants to actually graduate from a high school and not take classes in custody. He's wanting to go to the Army. Now, we didn't talk too much about that, and I don't know how the Army treats first offenders, and it's been a while since I've researched that issue or asked anybody about it, but he has concrete plans for his future. And he is hoping that the court recognizes that he has intention to rehabilitate himself, and that he just wants a chance to do so. He understands the seriousness of this case. Whatever caused the incident, or whatever the level of culpability here for Jaquavius, he admits that it was whatever they did, split-second stupid decision. They tried to rectify that pretty quickly thereafter, but I don't think I need to remind the court that we are still talking about a teenager here who wasn't making the best decisions at that time, just due to his age. Your Honor, I'm asking the court to consider, and Jaquavius has asked me Jaquavius has told me he's willing to do up to 20 years probation. And while I think that is a significant amount of probation, I think that's a very long time. I am going to ask the court for some amount of probation that it thinks is necessary in order to avoid prison time, Your Honor. He has spent around a little bit more than 2 months in custody. If the court settles on time to serve, I would ask the court to consider a report date for him 2 weeks out from today on February 13th of this year. But I would also ask the court to consider other alternatives, such as a week in jail for any number that the court thinks is appropriate.
What needs to happen between now and the report date?
Judge, he's only expressed to me that he wishes to spend some time with his family. And if I could, just to clarify that, we were in the middle of negotiations on the 12 to serve 2 sentence. And that was one of the things he requested, is that if he was going to go to prison for 2 years, he wanted to spend just the last 2 weeks before he turned himself in.
Okay. There is this arrest in the system for Jaquavius. It looks like on Christmas Day, battery, criminal trespass, and misdemeanor obstruction. I can't get anything more about it. No paperwork. It's listed as a magistrate pre-filed case, but it's in the system. So that's why it's showing up with Ms. Jackson. What can your client share with me about that? I'm not interested in what his version of the facts are, but is he acknowledging he got arrested? And
he is acknowledging that, Judge.
Okay.
Ron, if you go to I was looking as well to jailings.
Yeah.
Each one's, I found the warrants.
Okay. I tried to find him in jailings, but because he's a juvenile, I thought that's why it wasn't coming up.
You have to click released jailings.
Okay.
On the right side.
All right, let me do that.
And then I clicked on.
Oh, look at that, include released. Okay.
And Your Honor, the only other tidbit of information I'll share, it does appear that the alleged victim was his significant other, somebody that he knows.
Okay. Here it is. Good old Hateville Road.
exactly what he's reading, whatever a Singleton told him to read.
I guess because I was around, you know, the situation over there, what was going on. And when they asked me what happened over there, right, I wouldn't talk to somebody, I wouldn't talk to them. Because like at the end of the day, you know, just you know, she did.
How old are you now, Jaquavius?
17.
So, Ms. Singleton, you're here because Jaquavius was under 17 when these charges happened?
That's correct, Your Honor.
Okay, whatever I'm sorry, I didn't mean to interrupt you.
No, he was 16.
Right. So whatever disposition flows from this wouldn't be a DJJ disposition, or it would because he was under 17 when it happened?
It would not be DJJ.
Okay.
Because he's 17 now.
Okay. Quantavius Hammond, anything you want to add or any questions about anything we've been discussing?
No, sir.
Okay. Jaquavius Hammond, anything you want to add or any questions about what's been going on?
No, sir.
So Jaquavius, you've been living with your mother, Old Hapeville Road, and you were supposed to swap and live with your father. Do I have that correct, or I have it reversed?
Yeah, we never swapped because the day after we left court, it snowed the next day, and we was waiting on my lawyer to contact us about that, but we never talked about that.
Okay, I don't mind that you didn't swap. I just want to make sure I've got people in the right place.
Okay. Yeah.
There seems to be a lot of trouble down at the whole Old Hapeville address in hearing about this case and reading the warrants in your Christmas Day, really Christmas night arrest. Quantavius, I know you would then be moving to where your mom is, which is sort of where this carjacking-ish situation happened, or at least stolen car robbery. Is that something you're real insistent on wanting to do, or would it make more sense to get both of you out of the Old Hapeville environment? I don't know where your dad lives. I mean, it's in the system here somewhere, but I'm wondering if your dad's living situation is less problematic than your mom's living situation in that apartment complex. Sounds like your ex-girlfriend, Jaquavius, lives in the same apartment complex. You throw rocks at her place, she throws rocks at your place. We've got Ms. Jackson coming down there to sell dope and have guns. And I'm just wondering if your father is in a completely different place, if that's the right home when the dust settles. But you would know that better. It's not going to change what sentence I give you. I just need your honest assessment of, no, actually, Dad's a pain in the butt. I don't want to be there either.
I was about to say, it's definitely a calmer community.
Oh, your dad lives real close to where your mom is?
No, I'm talking about where my dad lives.
When you say,
like
calmer, got it, calmer community. Okay, that's why you want to leave?
I mean, I already left.
Oh, you're not with your dad anymore?
I live with my mom.
Oh, so you relocated?
No, he's saying
like, that's why I left from, like, that's why when we first got out, I didn't go with my mom.
Correct.
I over there.
But the bond switcheroo was going to be, you're going back to your mom and your brother's going to your dad. You're okay if the answer is, no, you're staying with your dad.
Nah, we can switch because it's going to be better for him. And also my mom get to see my daughter.
Okay, but is it going to be okay for you to be in the less calm community?
Yes, sir. I'm mature. I can control myself.
Yeah, okay. That's a good perspective to have. Okay. I find there's a factual basis for both your pleas. I think this is something less than an armed robbery, something more than Ms. Jackson was up to no good, because it sounds pretty clear that in the end you guys rolled away in her car. And my guess is she didn't say, please take my Mustang and don't bring it back. I also find that your pleas are knowing and voluntary. You've been very well counseled and thoroughly counseled today. So I'm accepting your pleas. I'm sentencing you both to the Probation Options Management Act, which means that the part of your sentence that's on probation, if you have a small or a minor violation, you in probation will deal with that. I won't get in the middle of it. But if it's more significant, that means any arrest, no matter what it's for, that comes back to me and we'll work through that. So, Quantavius Hammond, the overall sentence that I'm going to impose in your case is 10 years to serve 1 year with the balance on probation. I'm going to go through the rest if you want me to, but really what you and Ms. Wood need to talk about is that something that you're going to go forward with, or should we go to trial? And you all need to have the same conversation because it's going to be the same sentence. And so I'd like you, the two groups, to break up, and just before you have the conversation, understand that I respect your decision to say no, but then that means we're gonna have a trial, and your trial is to the counts in the indictment right now. I don't control reductions, and these reductions that Ms. Dilligard made were purposes of the plea only. And I'm confident Mr. Kraft already told you, Jaquavius, and Ms. Wood told you, Quantavius, but hear it from me because I'm the one who'd have to sentence you. If you go to trial and a jury finds you guilty of either armed robbery or the carjacking as it's charged, which is carjacking with a weapon. In other words, if they believe Ms. Jackson, then I have to sentence you to at least 10 years to serve. At least 10 years to serve. And the armed robbery years are not parolable. The carjacking ones, I think, are parolable. It's a funky statute, but the armed robbery ones are definitely not parolable. And you can talk to your lawyer about it, but what that would mean is every day of the 10 years you serve, and the only credit you get would be the little bit that you've been in already. I just want you to understand the contrast, because I don't know what a jury will do, and they may hear from Ms. Jackson and say this is ridiculous, and you guys walk free, and that's a big win for you all. But the dice you're rolling are very, very big dice. And on one of the faces of the dice, it says at least 10 years to serve, no parole, which would mean you would be 27 before you get out of prison, and you'd be whatever 10 plus your age is. I'm not saying that's the outcome. Don't go to your lawyer saying the judge says I'm guilty of armed robbery. I'm not. I'm taking a plea of robbery because I think there's more to the situation than what just the indictment said. But a jury would decide that, and they'd be sizing you up. They'd be sizing Ms. Jackson up, and juries are hard to predict. So talk with your lawyers about it. I just wanted you to be clear on what plan B is, which is going to trial with the unknown of what's the sentence. And at the end of that trial, your lawyers will be very persuasive, but saying, hey, how about probation? That's not even to say those words is nonsensical because you can't get just probation. Okay? Yeah. All right. Huddle up.
Yeah, we need to try with that.
Yes, ma'am.
All right, back on the record in the Hammond's case. Ms. Wood, have you and Quantavius Hammond had an opportunity to discuss his options?
He did, Judge.
And what does he want to do?
He will accept the sentence of the court.
All right. I'll add the rest of it in just a second, but let's figure out what's happening with Jaquavius Hammond. Mr. Kraft, have you and your client Jaquavius Hammond had an opportunity to discuss the situation?
Yes, Your Honor.
And what is your client's election?
He is going to accept the sentence.
Okay. Let me finish talking about what the sentences look like, and then we can talk about first offender and reporting dates. So the ultimate sentence that I will impose for Quantavius Hammond as to count one, which has been reduced to robbery, is 10 years to serve 1 year with the balance on probation, credit for time served. Count two, which has been reduced to second degree hijacking of a motor vehicle. It's the same sentence. Count three is the same sentence. And count four it has to be 5 years consecutive. Oh, you know what? I don't have a mandatory 10 anymore. So let me restate that. Sorry, Ms. Nelson. Counts 1 through 3 are all 5 years to serve 1 year with the balance probated. Count 4 is 5 years probated consecutive to count 1. So the total sentence is the same. We don't have to have that suspended sentence hanging out there. It's 10 to serve 1, balance probated, credit for time served. Special condition of your probation will be to get a GED. If you knock that out before you get out, that's not a condition of probation anymore. I will not require you to have no contact with each other when you get out. You will need to stay away from Jennifer Jackson. By the time you get out, you're going to be even older, and I suspect a whole lot wiser. So I'm not going to say don't live with your mom or your dad. You're going to live where you live, Quantavius Hammond, when you get out. But it will be a condition of your probation that you actively seek employment. So if you're a month in and you're just sort of goofing around, et cetera, I'm going to, after 4 weeks of unemployment, you're going to have 5 hours of community service for every week you're not working. Just thinking if there are any other conditions. I will also waive your probation supervision fee for the first 3 months, because you got to get on your feet and figure out what you're going to be doing to earn a living. We'll talk about first offender collectively. Let me turn to Jaquavius. Jaquavius Hammond, same sentence. It's 5 serve 1 on the first 3 counts, followed by 5 years probation consecutive to count 1 with the final count. That's a total sentence of 10 to serve 1. You'll also get credit for all the time you've been in. You'll need to get your GED if you don't knock that out while you are in custody. You will also need to seek work when you get out, or I don't mean to preclude you may go to college, or if you're in the military, any one of those things qualifies. But if after a month of being on probation, you are not employed at least part-time or enrolled at least part-time in school, or you're in the US Army, then you'll be getting 5 hours of community service for each week. You also can have contact with your brother when you get out, but you will need to stay away from Jennifer Jackson and her Mustang. Restitution will be dealt with at a later date, should the state seek a restitution hearing, since that's been challenged. Any other conditions for either of the sentences, Ms. Dilligard?
No, Judge.
Any questions about the sentences, Ms. Wood?
Judge, I'm sorry, did you address first offender or are we?
No, I'm going to do that in a second.
Then nothing.
Okay, Mr. Kraft, any questions about the sentence?
No, Your Honor.
Two things. I'm prepared to give you a reporting date, but I'm nervous about it because even though you say you're older and wiser and all that, you're young and fast and you're going to think, I'll just disappear. The sentence that I just pronounced will be a first offender sentence if you show up on your reporting date. I will have 2 sentences to sign on your reporting date. And reporting is to here. You'll come back to 8D. And we'll figure out that date and time, and it's going to be the same date for you. So older brother can grab younger brother if he really is more responsible. Hey, you're coming with me. If you show up, it'll be the sentence we talked about. It'll be a first offender sentence. If you don't show up, then it is going to be 10 years to serve 5 years, and it will not be a first offender case. And I will sign that sentence that day that you're not here. And so eventually you're going to get pulled over, you're going to get a speeding ticket, this or that, and there'll be this warrant, and it will be for a 5-year custodial sentence followed by 5 years on probation, and it's not first offender. So you're going to make the decision, come here or don't come here. Mr. Kraft had asked for 2 weeks. Ms. Wood, same for Quantavius. I know he's got a kid, so it's a slightly different situation, but they need to be here same date, same time.
We're good with that, Judge.
So what I'm going to say then is Friday the 14th, because I'll be here. So that's Valentine's Day. Not the best way to celebrate it, but it's Valentine's Day. That is 2 weeks and a day from today. Does that not work?
No, hold on, Judge.
Well, we're going to make it the 13th.
Don't worry about that. We're fine, Judge.
9 a.m., Friday the 14th. Easy to remember. It's Valentine's Day. 9 a.m. This courtroom. You spent all day in this courtroom. You know how to get here. If you're running late, have your lawyers be blowing up my office's phone. They're on their way. Don't worry, they're going to be here. But if it's 9:30 and I haven't heard from Ms. Wood or Mr. Kraft and you're not here, I'm assuming you've picked option B, 10 serve 5, not first offender. And I will sign those sentences and they'll catch up with you eventually. So if something changes and you know you can't make it at 9 a.m. on the 14th, tell your lawyer so they can tell me. And if the doctor sends me pictures that you're in the hospital on, being taken care of, we'll move the date. But if it's just, hey, I'd like another day to use my PlayStation, play a lot between now and then, and be here at 9 a.m. on the 14th. First offender is something you both qualify for. It's a benefit in that if you successfully complete your sentence, you can get it wiped off. That helps with work and school and other things you might want to do with your life. But it carries with it a pretty big risk, especially for younger people who haven't necessarily mastered their ability to make good decisions. If while you are on probation for those 9 years, something serious happens, and by serious, I mean you get arrested again, you've got a gun on you, you got something more than a little bit of weed on you, that's going to come back to me. And without a trial, you'll have a hearing and a lawyer will represent you, but it's a pretty low burden for the state. I can revoke your first offender status and resentence you. And all these numbers that were little can get big. Robbery is still 1 to 20. The carjacking is still 1 to 10. Aggravated assault is 1 to 20. You add those up, that's 50 years right there. I'm not saying I'd sentence you to 50 years, but what I am saying is if you're back here in 3 years because you got picked up having a gun, because you cannot have a gun while you're a first offender, doing something like taking a car, whatever, you're going to have those new charges and you're also going to lose your first offender status because you would have told me, yeah, you wasted your time on this, Judge. I really wasn't ready to do it, and I haven't figured out how to do things differently. And I get to resentence you. And if it is a pretty serious new thing that you did, it'll be a pretty serious resentencing. Without a trial, some jury doesn't come in here and hear like, whoa, Jennifer Jackson, you're nuts. They're going to go full. I will go forward with you already having pled guilty. Quantavius Hammond, do you feel like you understand how first offender works?
Yes, sir.
You understand that there's a big risk associated with it? Yes?
Yes, sir.
Okay. Do you want to be sentenced as a first offender?
Yes, sir.
Jaquavius Hammond, do you feel like you understand first offender?
Yes, sir.
Is that something you want to do?
Yes, sir.
You understand that if we're together again in a few years because you got arrested for something, you could lose your first offender status and be sentenced to prison on this case that you're just doing a year on right now. You understand that?
I understand.
Okay. Then that's what we'll do. I will see you when?
You said 14th?
What time?
9 o'clock.
9 o'clock, courtroom 8D. Mr. Kraft, you do not need to be here, but you're welcome to be here. You just need to be available to work the phones if Jaquavius is calling you. Same with you, Ms. Wood. You may be here because we may be at the tail end of one of your trials anyway. But that's the situation. Someone had a question.
No, Judge, he had a question. You went through the total exposure just now, but those were the charges he just pled to. Earlier, I gave him a different number.
Oh, yeah. Without reduction, it's life plus 20 plus 20 plus 5 if the state hadn't reduced these charges. So life plus 45. The state's reduced, and so you're at 55. So I saw you say thank you to Ms. Dilligard. The way you thank Ms. Dilligard, the way you thank Mr. Kraft is don't come back here other than, hey, look, here's this student, Jaquavius Hammond, this new lawyer, he's here, whatever it is, come back that way. Don't come back through that door. Coming back through that door is the start to a sad song. Okay?
Your Honor, I have a question.
Yes.
As to the supervision for the next 2 weeks, the ankle monitor stays on, he has a 24-hour curfew. Is there anything that changes?
What's that?
Sorry, say that again. An ankle. Oh, between now and then, yes. Now and the 14th.
Yes.
Right. No, you have the same situation. You're still on bond. You haven't been. We've talked about what happened, and you've entered this plea. But until you turn yourself in, all the conditions of bond still apply. So ask questions now rather than Ms. Singleton's reaching out to me saying Jaquavius is in East Point and he's not supposed to be in East Point.
I was gonna say we gotta catch the train home, but we're not allowed to be around each other. How that work?
I mean, right. You don't worry about today. You're good until I'd say like 6 o'clock today. But you think you'd be, well, how long will it take you to get home?
Well, he gotta go to the south. Yeah, but he on the east side.
All right. But how long will it take you to get home?
I don't even know where the train is from here.
Okay. Go home. I mean, the ankle monitor is going to show us which way you go. If you're going to Decatur, you shouldn't be in Alpharetta.
Well, I know that.
Right? Okay, good. So start heading home. And same with Jaquavius, you're heading home, but Ms. Singleton raised an excellent point as usual. All the stuff that you've had to do with bond, you got to keep doing between now and the 14th. Okay. The other thing that would change things is if Ms. Singleton reaches out to me saying, wait a minute, Jaquavius is running all over town and doing this and that and not complying with curfew, then I probably need to change my sentence.
So is it that I have a curfew or is it a 24-hour house arrest where I can't go out the house at all?
So, Your Honor, he has a 24-hour house arrest except for school, which he does online.
Okay. So you're at home. That's pretty simple. That's a good, clear, bright line. It may be your brother can come visit you. In fact, I think he's supposed to be living there now. But you aren't supposed to go anywhere until the 14th. And obviously medical emergency. You fall and break your arm, you got to go to the hospital. Just don't fall. All right. Anything else, Ms. Singleton?
That's all. Thank you, Your Honor.
Don't leave quite yet. Ms. Simpson, I'm assuming we don't need to worry about reporting instructions. They're going into custody.
Yes.
14.
They'll get it on their way out. Okay. Great.
I ain't just gonna bring it. Thank you.
Can you hand me a
Thank you,
phone?
I'm real.
So you're welcome to do that. You just need to be here at 9 and you could talk to them about it. But I mean, they're going to learn. I'm assuming what they'll really be told is as they're being processed out of GDC, they're going to say PS, because they'll probably be on parole first. and then they segue into probation. Okay.
Thank you, Your Honor.
Thank you, Ms. Singleton. Bye.
Bye.
All right. Ms. Rios, you want to do something now? Or maybe it's all that's left is you.
Yeah, I think so.
Who's the Cobb County guy? Would you like to do that first? Okay, can we do Kimbro first? I promise not to ask lots of questions of these people.
You should be. Yeah.
About Kimbro? They really want him back. Okay, sorry.
We're playing musical ADAs and I'm doing this plea.
Okay. Go. Good afternoon, Mr. Kimbro. Good to see you again. Think we're gonna get through it this time? Maybe. We'll see. It's your call. This is position 2124 SC 0035554, State versus Kimbro. Mr. Kimbro is in court with Ms. Wood. We have Ms. Nix as the prosecutor, and Mr. Kimbro, Ms. Nix is going to put you under oath in just a moment. You'll answer her questions. I'll answer your questions if you have any, okay?
Mr. Kimbro, please raise your right hand. Do you swear or affirm that any statements or testimony that you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Can you put your hand down? Please state your true, correct, and legal name.
James Elwood Kimbro.
Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No, ma'am.
Is there a medication that you normally take that you have not taken or been given today?
No, ma'am.
How old are you?
44.
How far have you gone in school?
12.
Did you finish high school?
Yes, ma'am. Yes, sir.
Is English your native or dominant language?
Repeat that again, ma'am.
Is English your main language?
No. Yes, ma'am.
All right, I'm just pulling up the indictment.
Yeah. 24 SC 003554.
All right, Mr. Kimbro, do you understand that you've been charged with the following offenses? 2 counts of cruelty to children in the 2nd degree, possession of a firearm during the commission of a felony, and 2 counts of reckless conduct?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes, ma'am.
Do you understand that if you plead not guilty or remain silent and refuse to enter any plea at all, then the state is required to prove the charges against you at a jury trial?
Yes, ma'am.
Have you had the opportunity to review your rights with your attorney?
Yes, ma'am.
Have you had enough time to speak with your attorney about all of the charges in this indictment against you, including the facts and circumstances relating to each charge?
Yes, ma'am.
Do you need more time to discuss the case with your lawyer, Ms. Wood?
No, ma'am.
Are you satisfied with her services?
Yes, ma'am.
Ms. Wood, do you waive a formal reading of the indictment for purposes of the plea?
So waived.
And do you waive any and all defects in the indictment for purposes of the plea?
We do.
Mr. Kimbro, do you remember having been arrested on these charges?
Yes, ma'am.
Has your attorney advised you of the minimum and maximum sentence for each charge to which you're pleading guilty today?
Yes, ma'am.
You understand that today you're entering a negotiated plea of guilty, which means that the state will recommend the following sentence to the court.
Yes, ma'am.
She hasn't said the sentence yet.
Okay. I'm sorry.
State recommends
I'm sorry.
a 5-year sentence that you serve 2 years with the balance on probation. ADET and no firearms. That's the recommended sentence for counts 1 and 2. Count 3, state recommends 5 years probation consecutive to count 1. And counts 4 and 5, state recommends 12 months to serve concurrent with count 1. Do you understand that's the state's recommended sentence?
I want to make sure that I understood and that I explained it correctly. ADET is alcohol and drug evaluation and treatment, correct? That's not some program I don't know about.
It's what you said.
Okay.
Yeah.
Thank you.
Yeah. So I heard 10 serve 2, if you add everything together, because that 5 years consecutive. So the serve 2 is the big piece, followed by 8 years probation. And when Mr. Kimbro is released, either paroled out or on probation, he'll submit to a drug and alcohol abuse evaluation. And if that medical professional says, hey, Mr. Kimbro, you benefit from going to AA classes or this or that, that treatment would become part of your probation. And that's where we are.
Thank you, Judge.
Having that being clarified, do you understand that's the state's recommended sentence? Mr. Kimbro?
That's what they're asking for. We'll ask for something different when I get home. Okay. So say yes.
Yes.
Okay, do you understand that the court is not required to accept the state's recommended sentence?
Yes.
Do you understand that the court has the right to sentence you to the maximum possible sentence on each charge?
Yes, ma'am.
You understand that since there are multiple charges to which you're pleading guilty today, the court also has the right to run those sentences consecutively?
Yes, ma'am.
You understand that if the court decides to order a sentence that differs from the negotiated plea you were expecting today, you do not have the right to withdraw your plea of guilty?
Yes, ma'am.
Are you currently on probation or parole anywhere?
Yes, ma'am.
You understand that your probation or parole may be revoked based on your entering a guilty plea today?
Yes, ma'am.
You understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Yes, ma'am.
Do you understand that while you're on probation, you must follow all the special conditions of your probation?
Yes, ma'am.
You understand that if you fail to follow all the special conditions of your probation, then you'll be subject to revocation of that probation for the balance of your sentence?
Yes, ma'am.
You understand that you are not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that by pleading guilty to a felony, you may not receive, possess, or transport a firearm?
Yes, ma'am.
You understand that doing so could result in new criminal charges for which you face a sentence of up to 5 years?
Yes, ma'am.
You understand that by pleading guilty to a felony, you may not receive, you also may not use a firearm in a crime in the future?
Yes, ma'am.
You understand that if you were in the future to use a firearm during the commission of a crime, you would face a 15-year custodial sentence consecutive to the sentence for the underlying crime?
Yes, ma'am.
You understand that by entering a plea of guilty today, you are waiving any and all defenses, including any mental health defenses?
Yes, ma'am.
You understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, to remain silent, to confront witnesses against you, to the assistance of counsel, to the presumption of innocence, and the right to appeal if convicted of these charges at trial?
Yes, ma'am.
Is it your decision to waive these rights and enter a guilty plea today?
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes, ma'am.
How do you plead to the charges of 2 counts of cruelty to children in the 2nd degree, possession of a firearm during the commission of a felony, and 2 counts of reckless conduct in indictment number 24 SC 003554?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
You understand that you have only a limited right to appeal this guilty plea conviction?
Yes, ma'am.
You understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
Yes, ma'am.
You understand that for the felonies, you have only 4 years from today to do so, and for the misdemeanors, you have only 12 months from today to do so?
Yes, ma'am.
Judge, had this case gone to trial, the state would expect the evidence to show that on or about April 21st of 2024, the Atlanta Police Department responded to 4511 Campbellton Road, which is in Fulton County, regarding an 11-year-old victim with a gunshot wound to his stomach. The defendant, Mr. Kimbro, spoke with officers and reported that his son, JK Jr., was shot at a park down the street. Mr. Kimbro was erratic, and officers observed a strong smell of alcohol. Officers also spoke with Tasha Hill at another location, who reported that her son was suffering a gunshot wound to his stomach. Her son, MH, reported that his uncle, Mr. Kimbro, had shot him. He reported that they were at 2333 Omaha Road, also in Fulton County, gathered in the den. Mr. Kimbro was drunk and waving a gun around and shot at them. The investigation supported the fact that the defendant tried to cover up the incident. Nothing further from the state.
So one victim is Mr. Kimbro's son and the other is his nephew.
That is my understanding, Judge.
What is your understanding as to whether MH and JK Jr. are alive and they're clearly not dead as a result of this, but how are they doing? If you know.
I do not know, but I can see if there are notes.
Okay.
Judge, I'm happy to add when it's my part.
Well, that's fine. You should look at the notes, but we'll press on. And then if you found something that's different from what we hear from Ms. Wood, you can add that.
And once I'm here, Malachi Hill's mom.
Okay. That's Ms. Hill.
Yes.
Okay. We'll hear from you, Ms. Hill, in just a sec. Okay.
Okay.
Thank you. You've been very patient. Ms. Jackson, if you could just get me the criminal history information, please, for Mr. Kimbro.
He has 7 cycles. The last arrest was December the 20th, 2023 in Fulton County for battery, family violence. There was no disposition for that arrest. He does have a prior misdemeanor conviction. It was in 2017 out of Chris County, Georgia, for driving without a valid license. Nothing in addition, Your Honor.
Thank you. Was Ms. Hill on because you asked her to be on, or because maybe Ms. Drummond lined that up?
Judge, Ms. Hodge had told me that one of the parents was on, but then she told me that she had gotten off.
Okay.
So I didn't.
She's back on.
Okay.
Hey, Ms. Hill. Oh, Ms. Drummond. Yes, ma'am.
Yes, I'm sorry, Judge. I was unaware that was Miss Hill. It said Samsung, so that I do apologize.
Okay. Ms. Hill, why don't I hear from you? And then I'm going to turn to Mr. Kimbro's lawyer to see what she has to say.
Okay.
Tell me how Malachi is doing.
He's recovered very well. He's healed, back up and running.
Good. Literally running like a little kid running around?
Yes.
Good. How old is he?
11.
All right. And no lingering effects? Like he can use the restroom just fine and he can run with the other kids?
Yes.
Okay. Is he able to eat a normal diet?
His diet a little off. other than that, he's pretty much good.
How long was he in the hospital?
Close to a month.
How was that paid for?
Medicaid.
Okay. Did he miss a grade because of that, or is he still in the same grade with all his friends?
Yeah, he missed school. He wasn't at school when it happened.
Okay. But he didn't have to repeat a grade or anything?
No.
Okay. Any sense on how JK Jr. is doing? I know that's not your son, but maybe you know him.
Yes, he's doing good. He was released from the hospital like 2 days after the accident.
So he was not in as long as your son was?
Correct.
Okay. And is he running around like a healthy kid now?
Yes.
Okay. Anything more you want me to know, Ms. Hill?
No, that's pretty much it.
I appreciate you being patient. You've been on this call for a while. We've been working through a lot of cases today. But you're welcome to stay on and listen to the rest of this, or you're free to go. Thank you.
Thank you.
Bye-bye. Ms. Wood.
Thank you, Judge. Before I start talking, I don't know if Mr. Kimbro's wife is on. That's the mother of James Kimbro Jr. I'm not sure if she was able to log on. I know sometimes she has like a work schedule that interferes, but she was on Zoom when we tried to resolve this when Mr. Jordan still had the case. And so she did say exactly what Malachi's mother just said, that James Kimbro Jr. is well now. It was more of a superficial wound. Both are very serious. This was a terrible accident, and Mr. Kimbro is here today. He's maintained the whole time I've had the case that he's eager to accept responsibility. He understands that was a terrible mistake and decision he made to get drunk around firearms and children. Just a recipe for disaster.
Exactly.
He is 44 years old. He has no felony convictions. He's married to his wife. They have 5 children together. He's high school educated. He was gainfully employed, working at the airport at the time. He was also doing a little bit of a side hustle. He did construction work on the weekends to make extra money to provide for his family. So I know that his wife is eager for him to get back out into the workforce. And when he is able to do that, he will return to live with her and the children in Decatur. Judge, he's been in custody since April 22nd of last year, so 282 days. I'm asking the court to consider a sentence of 5 years probation, serve 1 year in custody, balance probated, and then of course the gun charge has to be the 5 years consecutive suspended. We have no issue with the drug and alcohol evaluation and treatment. I think it's applicable here. And finally, we are asking for first offender treatment.
Okay. Mr. Kimbro, the address I've got in the system says Omaha Road in Atlanta. Did you used to live there, or that's in Decatur now?
No, sir. That's the old one.
Old address, but your wife and all those kids, they've moved to Decatur?
That's new.
Okay. Does she work?
Yes, she part-time off and on though.
Okay.
She's going through it right now.
I bet with all those kids, who's helping take care of them?
No one. I'm just hoping I get,
Okay. Anything more you want to add?
That's it.
All right. Do you have a perspective, Ms. Nix, on first offender for Mr. Kimbro?
I do not.
Okay. Remind me the type of work you were doing before you got locked up. I know there was a main job and then some construction on the side. What was the main job?
Being a chef at the airport.
A chef at the airport. Okay, at one of the restaurants there, or for like one of the catering companies?
It's like a restaurant.
Okay. All right. Mr. Kimbro, I find there's a factual basis for your plea, and that your plea is knowing, meaning you've understood what's going on, and voluntary. No one's forced you to enter this plea. I'm sentencing you pursuant to the Probation Options Management Act. So for the part of your case that you're going to be, part of your sentence that you're going to be on probation, if you have a little issue, you and probation will work through that. But if it's a big one, you get arrested for anything, that comes back to me. Mr. Kimbro, your lawyer summed it up well, that this was a terrible decision that had serious consequences. And the main thing I feel is relief that it was as minor for your nephew and your son as it was, because someone could have lost an eye. It could have been in the liver. They bleed out. You could have had 2 dead boys in the den. And then we're not talking about probation in a few years. Is it 2 life sentences or concurrent life sentences? And your kids grow old looking at you through a wire gate. So that's the swing that we're going through here. I appreciate what your wife is going through, but I'm not particularly sympathetic to you other than that I know you want to go and help. And that part's good, and that's a good instinct to have. And we got to help you tackle the alcohol or drugs or whatever the substance abuse was. Mr. Kimbro, I'm going to sentence you on count, let me do the math right, counts 1 and 2 to 3 years to serve 18 months with a balance on probation. Count 3 has to be consecutive, has to be 5 years. I will probate that. And counts 4 and 5 will both be 12 months to serve. They'll run concurrently with counts 1 and 2. So it's a total sentence of 8 years to serve 18 months with a balance on probation. You'll get credit for all the time you've been in. These are parolable offenses. The special condition of your probation is that you submit to a drug and alcohol abuse evaluation when you get out. And if that medical professional recommends any treatment, that treatment becomes a condition of your probation. I'm not going to sentence you as a first offender, and I'm going to wish you the best once you get out for when you reunite with your family in Decatur. Okay? Any questions about any of that? All right. Ms. Wood, anything else?
No, Your Honor.
Ms. Simpson, anything you need to tell Mr. Kimbro about reporting other than that he'll hear about it when he's paroled?
Yes, he'll just need to make sure he reports within 48 hours.
Okay. If you continue to be in Decatur, you'll be reporting to, I think it's in Conyers. It's pretty far out, the office, but they'll tell you where. You don't have to guess where that is. And then you'll plug in with probation and we'll go from there. All right. Good luck.
Thank you, Judge. Go that way.
Do you need our permission to sign the indictment?
Not today.
Okay.
Thank you for giving it. I meant to ask that. So we have Mr. Statum. You ready on that? Hey, how are you? Ms. Jackson, I'm going to ask you to give me Mr. Statum's criminal history now, and then you can go. Oh, I don't mean for you to hunt. It's position 8 on the inquiry calendar.
Are you ready, Your Honor?
Yes, ma'am.
He has 40 cycles. The last arrest was December the 6th, 2022 in Fulton County for a failure to appear. The underlying charge was not listed. He does have prior felony convictions. One in 2021 for entering an automobile and financial transaction card theft. One in 2017 for entering an automobile. One in 2016 for possession of tools for commission of a crime. One in 2015 for entering an automobile. One in 2011 out of Coweta County, Georgia, for forgery in the first degree. One in 2009 out of Whitfield County, Georgia, for forgery in the first degree, and a violation of the Georgia Controlled Substance Act. One in 2007 for possession of cocaine. One in 2006 for possession of controlled substance. One in 2005 for possession of controlled substance. There was an additional one in 2005 for burglary. And there's a misdemeanor sentence and a conviction.
I don't need the misdemeanors. You've given me plenty of information.
Okay, nothing in addition, Your Honor.
Thank you, Ms. Jackson. We have one plea tomorrow at 3. I don't know if you're covering that, but if we could have someone from your office join us at 3 tomorrow, that would be great.
Yes, sir. Thank you. Have a great one.
You too. Thanks for your time. All right, Ms. Rivers, you still with us?
Yes, I am.
Thank you for your stamina. We'll go on the record. This is position 8 from the inquiry calendar, State versus Torrance. Is it pronounced Statum?
Statum, yes, Your Honor.
Mr. Statum is here. It's 23 SC 191548. He's in court with his lawyer, Ms. Rios. Ms. Dilligard represents the state. And Mr. Statum, my understanding is that you're entering a plea actually to 2 cases, or we're resolving 2 cases today. Is that correct?
Yes, it is, Your Honor.
Could I have the case number for it? Maybe, is it in your email? I'll find it. But we'll handle both those cases. Ms. Dilligard is going to put you under oath. When you're under oath, you'll need to answer her questions truthfully. If you've got any questions of your own, I need you to make sure you ask them of me or Ms. Rios so that I'm comfortable you understood what we're doing.
Yes, sir.
All right, Ms. Dilligard.
Mr. Statham, please raise your right hand to your best of your ability. Do you swear or affirm that any statements or testimony that you shall give in the matter currently before the court shall be the truth, the whole truth, and nothing but the truth?
I do.
You can lower your hand. Please state your true, correct, and legal name for the record.
Torrance Leonard Statum.
Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No, ma'am.
Is there medication that you normally take that you've not taken or been given today?
No, ma'am.
How old are you?
I'm 51.
How far have you gone in school?
High school graduate.
You understand that you've been charged with the following offense in 22 SC 182038. It's count 1 is entering auto. Count 2 is criminal trespass and damage to property. In 23 SC 191548, count 1 is criminal attempt to commit a felony. Count 2 is criminal damage to property in the 2nd degree. Count 3 is possession of tools for commission of a crime.
I understand.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes, ma'am.
Do you understand that if you plead not guilty or remain silent and refuse to enter any plea at all, then the state is required to prove the charges against you at a jury trial?
Yes, ma'am.
Have you had enough time to speak with your lawyer about all the charges in both of these indictments against you, including the facts and circumstances related to these charges?
Yes, I have.
Would you like more time to discuss the case with your lawyer?
No, ma'am.
Are you satisfied with your lawyer's services?
Very.
Counsel, do you waive formal reading of both indictments for purposes of this plea?
Yes.
Do you waive any and all defects in both indictments for purposes of the plea?
Yes.
Mr. Statham, do you remember having been arrested on all of these charges?
Yes, ma'am. Unfortunately, I do.
Has your attorney advised you at the minimum and maximum sentence for each charge to which you are pleading guilty to today?
Yes, she has.
Okay, so I'm just going to run through them. For 23 SC 191548, count 1, the minimum and maximum being 1 to 5 years. Count 2, 1 to 5. And count 3 is 1 to 5. For 22 SC 182038, count 1, the entering auto is 1 to 5 years. Count 2, criminal trespass and damage to property, the maximum is 12 months.
I think the range for the criminal attempt is probably 1 to 2.5 because it's attempted entering auto. If entering auto is normally 1 to 5, attempt is usually half that. So it's not going to change what we do here, but okay. I just, in looking at what you all have negotiated, I'll need to make sure I don't say 5 years to serve or something, or 5 years probation on that count 1, because I think it's capped at 2.5 because it was an attempt.
And Your Honor, I guess we can just rearrange it of how to get to what we want, but.
I'll do the math.
Okay.
Yep.
Thank you.
Do you understand the minimum and maximum on all the charges?
Yes, ma'am.
You understand that today you are entering a negotiated plea of guilty, which means that the state will recommend the following sentence to the court. Judge, for both cases, the state is recommending 8 to serve 2.
With the credit.
with credit for time served.
Always. Okay. Any conditions of it's 8 to serve 2 balance probated?
Yes, Judge.
Okay. And so any conditions from the state on the probation?
Judge, no contact with either of the victims.
Okay.
And
we did not discuss it.
We did not discuss.
Okay. All right. It'll be basically, I mean, the main condition of probation is stay out of trouble.
Yes, sir.
That's not been easy for you, but we'll work through that in a little bit.
Yes, sir.
Okay.
Okay. Is that your understanding of the recommendation?
That is. Yes, ma'am.
Do you understand that the court has the right to sentence you to the maximum possible sentence on each charge?
I do.
You understand that if there are multiple charges to which you're pleading guilty to today, that the court also has the right to run those sentences consecutively to each other?
I understand it.
Do you understand that the court decides to order a sentence that differs from the negotiated plea you're expecting today, that you have the right to withdraw your plea of guilty?
Yes, ma'am. I understand it.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on your entering of a guilty plea today?
Yes, ma'am.
You understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
I understand it. Yes, ma'am.
Do you understand that if you are on probation, you must follow all the special conditions of your probation?
Yes, ma'am.
You understand that if you fail to follow any special condition, then you'll be subject to revocation of that probation for the balance of your sentence?
Yes, ma'am.
You understand that you are not allowed to possess or use a firearm while on probation?
I understand.
Are you a United States citizen?
I am.
You understand that by entering a plea of guilty today, you are waiving any and all defenses, including any mental health defenses?
Yes, ma'am.
You understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to the assistance of counsel, the right to the presumption of innocence, the right to appeal if convicted of these charges at a trial?
Yes, ma'am.
Is it your decision to waive these rights, which means not to use them, and enter a guilty plea today?
It is.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is it your decision to enter a guilty plea because you are in fact guilty?
It is.
Okay, Mr. Statum, how do you plead to the charges of entering auto, criminal trespass and damage to property in indictment number 22 SC 182038?
I plead guilty.
And Mr. Statum, how do you plead to the charges of criminal attempt to commit a felony, criminal damage to property in the second degree, and possession of tools for commission of a crime in indictment number 23 SC 191548?
I plead guilty also.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
I understand. Yes,
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
yes, ma'am.
You understand that for a felony charge, you only have 4 years from today to file a habeas corpus petition?
Yes, ma'am.
Judge, in regards to 22 SC 182038, if this case were to proceed to trial, the evidence would show that on October 6th of 2021, officers were met with Atlanta Police Sergeant and another investigator who had the defendant in custody. The officer who responded spoke with the officer who had the defendant in custody, who stated that he was standing in the parking deck adjacent to the open parking lot located at 215 Pryor Street when he witnessed Mr. Statum use an object to break the passenger rear window of a pickup truck in the parking lot. He stated he watched Mr. Statum toss his bag inside the vehicle and then climb in through the window. He approached the vehicle and ordered that Mr. Statum exit the vehicle, and he placed him into custody at that time. All that occurred in Fulton County, Georgia. In regards to 23 SC 191548, this was to proceed to trial. The evidence would show that on February 8th, 2023, an off-duty officer was working an off-duty job, reported that a Black guy wearing dark clothing and a beanie hat had shattered a window to a vehicle and was seen standing by the car based on CCTV footage. Officers received the report and followed in the direction that the suspect was headed. Officers maintained a visual on the suspect, observed him matching the description of the suspect that was relayed. They approached the defendant, who was breathing heavily. The defendant advised he had recently come from an area which was very, very far from the incident location. When asked about the incident, he stated he didn't want to say too much to incriminate himself. He was very out of breath, as if he had been running. Officers detained him. Nothing was taken from the vehicle, neither was the vehicle rummaged through. The police report mentions that the employees reviewed video footage and it showed Mr. Statum standing near the vehicle. All of that occurred on his person, he had a glass punch. All of that occurred in Fulton County, Georgia.
Okay. Thank you. I already heard from Ms. Jackson. It's a long list. Ms. Rios.
Yes, Your Honor. Mr. Statham is 51 years old. He has 2 adult children, a son and a daughter. He was working before he got arrested again at Breakfast and Barney's. He was doing that for how many years?
Roughly about 6 months.
6 months. And he did graduate from high school and did 7 years in the Army in Korea. In regards to Mr. Statham and the history of what happened, he was initially in Veterans Court for the 22 SE case.
That explains, because this bounced, it went to Glanville and this and that, and
So he
okay.
went for that, and then he picked up the 2023 case. He had a moment of depression, relapsed, and had no money at the time. He was missing paychecks, so this happened. Glanville then revoked him a year, so he's been in continuous custody since February 8th of 2022 or 2023. So he's been in for 2 years, almost 2 years, just a week shy of 2 years. So February 8th, 2023 would make 2 years. So that's why we're asking for it to be.
Okay, he was revoked on whatever got him. Oh, I see. There's this 413 days and okay. I guess I was waiting to get into accountability court. You spent a lot of time in jail. Okay, but the consequence of being terminated from Veterans Court was a 1-year revocation on whatever case got him into Veterans Court.
Yes. So
okay.
That's what equals. So he's just has not set foot out since then, but he has made good use of his time in jail. He brought me these certificates. He has completed 9-credit program for business and customer service technology. He has completed a job skills program. He has completed an emotional intelligence program. He has completed a customer service program and a certificate achievement
spiritual program.
And he also finished some college credits while he was in that I have here. He finished some courses when he was in jail. So he wants to make a change when he gets out. He was doing everything he possibly can to improve himself while he was in custody. And when he gets out, he's done with this. He's too old. He wants to spend time with his children. I believe he has grandchildren now.
I have 2 grandchildren.
2 grandchildren. So that's what he wants to do. And he's spent a considerable amount in jail already, Your Honor. So I'm just asking that he be able to be on probation, whatever drug testing and everything goes on with that. And he thinks he would be able to do very good on probation this go around.
Okay. What I'm seeing on the jailing screens is that Mr. Statum was released on the 30th of November in 2023, after having been in for a long time, in connection with the more recent case, which is still old, but the busting the attempt, but not going into the car, breaking the window, but not going in. But he got released on November 30th, and then the next arrest isn't until just before Halloween of last year. So there was almost an entire year when he was out. What am I missing?
Prison.
I went to I got revoked on the 27th of October, and I got paperwork to verify that.
Okay, so when you were, I'm sorry to interrupt, but just so when you were released, that this release date of November 30th, 2023 may well have been released to the Department of Corrections.
When I actually went off to the Department of Corrections, yes, sir.
Okay.
About a month waiting to go to prison. Yeah. But I never hit the street though, sir.
Okay, well, you, Ms. Rios, are gonna need to help Ms. Nelson with those dates. I'm not doubting you, but some of them aren't popping up in Odyssey, and Ms. Nelson can't invent dates.
Okay.
So you'll get credit, Mr. Statum, for time that you served. That we just need to figure out what those numbers are. And if for some reason you're still in and you think you haven't received adequate credit, you reach out to Ms. Rios and she can help us look at all those numbers to see what's going to happen. All right. Anything you want to add?
Well, yes, I do. I just want to say that I am, very sorry for putting myself and my family and the victim, of course, in this position right here. I've had some time to really contemplate. It wasn't something that I sought out initially doing. I had a bad, just dark cloud in my life that I was dealing with at the time, and I made a bad decision. That has led me to be off the street for 2 years. Like I say, I've been working on it, and I'm trying to get myself together, Your Honor. I've been trying, hard to stay in contact with my family support or whatever, and they're expecting me to come back out.
Okay. Is there some addiction that's connected with, if you're in Veterans Court, there must have been something going on. What was that? Was it alcohol, drugs?
Crack cocaine, sir.
Okay.
Yes, sir.
And you were getting some treatment for that in Veterans Court?
Yes, sir.
Had you ever received treatment before then?
I have, Your Honor, and I didn't do too good then either.
Okay.
But it was years ago. It was years. It wasn't.
All right. I mean, you may have reached a point where you're just sick and tired of it. And sometimes that's the best treatment of all. We'll see.
I have one other thing, Your Honor, to add also. As far as those dates go, I have paperwork to show that out from here, releasing me to the Department of Corrections. What if you'd like to see that?
I don't need to see it. Ms. Rios will look at it and then she'll get it to someone on my team who will verify all that. You served in Korea. You're not old enough to have served in the Korean War. You were posted in Korea in the army or something.
Yes, sir.
Okay.
I was there for a year.
Up in the DMZ or down near Seoul?
I was about 30 miles from the DMZ. Okay. A place called Camp Hovey. It's northern South Korea, but it was an experience.
And you were there for 7 years?
I was there for 1 year, but I did 7 total years in the Army, sir. Okay. I had my paperwork from the military also inside here.
All right. Well, I appreciate that. I don't need. Clearly you were if you were in Veterans Court. All right, Mr. Statum, I find there's a factual basis for your plea to both cases, and that your pleas are knowing and voluntary, meaning no one's forced you to enter these pleas and you've understood what we talked about. Do you agree with that?
Yes, sir.
I'm sentencing you pursuant to the Probation Options Management Act while you're on probation, which you will be for a few years. If you have a minor issue, you and probation will work through that. But if it's something more significant, you get arrested for something, or there's too much drug use, they may send it to me and then I'll work through it.
Yes, sir.
Ms. Rios, is it all right if someone in my office signs the indictment for you, or the indictments?
Yes, Your Honor.
Ms. Dilligard?
Yes, Judge.
And Mr. Statum, can we electronically sign for you showing your 2 guilty pleas?
Yes, sir.
All right. In 23 SC 191548, I am sentencing you on count 1 to 2 years to serve. Count 2 will be 1 year probation consecutive to count 1. And count 3 will be 5 years probation consecutive to count 2, which gets us to 8 to serve 2. You'll get credit for the time that we can document, and the balance is probated. No contact with the victim in that case. And in your other case, which is the 22 SC 182038. Your sentence on count 1 is 3 years to serve 2 years with the balance probated, and Oh, that's a misdemeanor. Can't really get that high. It's going to be 5 years to serve 2 years, balance probated, and count 2 is 1 year to serve, 12 months. It's a misdemeanor, 12 months to serve concurrent with count 1. And your sentences in your 2 cases run together. So overall, it's what you and your lawyer have been talking about, which is 8 years to serve 2 years, and the balance on probation. Special condition of probation in both cases, when you get out, you will submit to a drug and alcohol abuse evaluation. And if that professional recommends that you go to NA classes or AA or whatnot, that treatment is part of your probation.
Yes, sir.
Okay?
Yes, sir.
You need to get reporting instructions from Ms. Simpson.
Mr. Statham, zip code, please.
30311. 30311.
Okay, so just to clarify, he is receiving credit for time served.
Right. He's not going to get out right away, but he probably won't leave Rice Street. There'll be such a small amount of time left that they won't ship him out.
Okay, so then you're going to report to the Atlanta office within 48 hours of your release.
Yes, ma'am.
The Atlanta office is 276 Memorial Drive, and it's right around the corner from here. I will
By
have
Garnett
everything-
Station.
I'm sorry.
By Garnett Station, train station, down by pre-trial.
Oh, yes,
Yes, ma'am.
yes. I will have all the information for you, document for you, as soon as we finish.
Yes, sir. Man, thank you.
That's it.
One more question, Your Honor, if I may. So just so I'm clear, my 2-year completion date would be the 8th of February of this year, is what I'm understanding?
I don't know the math, but it would be, you're getting credit you're claiming that you have not been out since you got, yes. Based on what you said, if you've not been out since you got arrested, when they said you were out of breath and you broke the window but didn't go in the car, if you've not been out since then, the maximum would be February 8th.
Yes, sir. All right.
Okay, this is why I'm saying you're not going to get shipped out. That's so soon. The sheriff has the authority to say, you know what, we're in 2 more days and get you out. It's not 2 years to the door. Okay?
Gotcha. Thank you, sir.
All right.
Thank you.
That's it. The deputies are going to take you that way. I think all that's left is Mr. Newmeister. I don't know, it is so late if he's still okay. I'm good. I feel terrible for all of you. But if we can do Mr. Newmeister, we can. If we should bring him back, we can do that too.
So, Judge, he's eager to get out here and try to resolve the situation. I was telling Ms. Nix earlier, this is something that's not as simple as my usual probation application. So I don't know if the court wants to reset it. I did speak with his mother today. She was not gonna be able to be on Zoom, but she did want me to share with the court that while she is supportive and hopeful to be able to support him, right now it's not in the position of he can come live with her.
Got it. Okay. Is there a place where he can stay?
Not that we verify.
Okay, then I'm gonna have him come to the door and I'm gonna explain and I'll own it. But then you're gonna need to find a place for him to stay.
So that is part of our issue right now, Judge.
I bet.
He's refusing, so Ms. Wiggs at the jail has tried, and then Ms. Ross with my office has also tried, and so that's part of the predicament we're in.
Okay, all right. So we'll bring him back soon, but I don't want to bring him back before the predicament has been resolved. Is there something I should address with him that might crack open a door? He's refusing to do what? He won't talk with them?
So the programs that we partner with, you have to be on your medication, basically.
Okay.
So that's a big issue. Ms. Primovic did speak with him earlier, so it may be that she can help me out.
Okay.
Further, but yeah, that's where we are right now.
All right, well, why don't I talk to him briefly? He'll go back and then you can say, look, put it out 30 days, whatever, but we'll do that. And then I just want to talk real briefly with you guys about whatever we're going to try to do on Monday. I'll still send an email out, but let's see. Okay, but Newmeister just needs to come to the door.
Brian Newmeister to the door. Yeah.
Who was that? You said, you said, oops, no, can't do that. Sorry, because it was a 5 to serve 3 on the first account?
No, 5 to serve 2, and then 12 months to serve concurrent. Sorry. Hey, Mr. Newmeister.
Hello, sir.
Good to see you again.
Good to see you as well.
I'm sorry that we kept you here all day today. It's been booked. Lots of people, as you've seen back there, and we had people out here. It's now late enough that they're gone. I wanted to give you an update, and then you may have something real brief you want to share with me, and then we need to bring you back here when your lawyer can have a few more pieces in place. It sounds like we're very close to resolving the revocation piece. People have been talking with your mom, who remains very supportive of you. But the main issue is finding a place for you to stay when you get out. I'm not interested in saying to you, good luck, find a place. That's not safe. It's not fair. There are some programs that likely would be open to having you stay there, but it is always, always, always conditioned on someone taking medication, and no one can force you to take medication. So what I need you to be thinking about between now and when I next see you, which will be soon, just a matter of days, is how you're going to navigate that, because you retain that independence to say, I appreciate it, but I'm not putting that medicine in my body. Should you make that decision, you tie your lawyer's hands, because she and Ms. Ross, who may have tried to visit you, Ms. Wiggs out at the jail, they are finding programs where they say, Mr. Newmeister can stay here, but he's going to need to take medication for your safety, for the safety of the people around you. And I don't know how you want to do that. Today isn't the day you have to decide, but I wanted to tee that up for you, because when I see you next, that's the heart to heart we have to have, is how are you going to manage that? There aren't places other than home, and home is saying right now you can't go back home until you're stable on the outside, where they're going to say, yes, Mr. Newmeister can be here, but he doesn't need to take his medicine.
I spoke to Ms. Wood about it. In working with the medical staff at the Fulton County Jail, has been extremely helpful. They put in a stop order for medication, and then they restarted it and had a discussion with me about why I need to be on medication. And I'm not confused about why I need to be on medication one bit. But I got the support I wanted, which is the staff at the jail had told me they don't personally believe I need to be on medication, but that doesn't change my need to be on medication for purposes of fighting the program. And so I accepted that I need to be on medication for purposes of fighting the program, because Ms. Wood reminded me that Grady Hospital has, I mean, the 55 Park Place, and there's the open clinic, and basically I need to go talk to the Grady Hospital if I want to do something with my medication. That would be the plan immediately, would go talk to them about working that out. And so I'm completely fine with that. I've heard of the Salvation Army as being interesting. I'm not picky about programs, but
okay.
The medication, I'm not confused about the medication thing. The staff that work with me at the Fulton County Jail, I need to be on the medication to get into the program, but they agree that they don't think I need to be on it from a long-term.
Right, and long-term is a different question, but I want to modify the thing you're saying only slightly. You need to be on medication to stay in the program, not just to get in. It's not like, hey, today everything is good, but for you to be there, because my requirement would be, Mr. Newmeister is, let's pretend it's Salvation Army. I don't know, it would be, he needs to be at Salvation Army for at least 3 months. Well, they're going to make you leave on day 2 if you say, now that I'm in, I'm flushing my medicine down the toilet. You would need to be taking your medication in order to stay there. And as long as you, so I get it, it's not a forever thing, but to be at Salvation Army, for judge said 3 months, judge said 4 months, then while I'm there, I'll be taking medication. I can also go to Grady and work on titrating off it and be talking to my mom about maybe coming home. But your commitment would be, I'm taking it now, good relationship with the folks at the jail, and I will take it as long as I am at Salvation Army or whatever place we find.
No, to be completely honest with you, every time I take the medication, it makes my heart race and I start self-harming. And that's the part where I'm really confused about the medication I'm taking specifically. And I spoke to the jail about it. You know, they get blister packs from a supplier, and I don't know what they're giving me, but I've bitten myself a number of times with the medication that they are giving me, and I've documented this, and I've documented with the staff and spoken to them about it.
Okay.
And so that's the part, I understand everything you say, but that's what's going on with me, so I hope we can figure something out about that.
We need to, because those are the type of side effects that are not okay. It's one thing if, hey, a little bit of hair is coming out or my fingers are tingly. It's another to self-harm. And so I would hope that the staff at the jail would be saying, we need to try something different. I know the folks at Grady will do something different. And so that's another reason to try to get you out into a program so that you can be working with the folks at Grady, okay?
They told me at the jail that they can't change the prescription.
I don't know.
I have spoken to them extensively about it, but as of right now, Ms. Weeks has told me that she's waiting for the next mailing at the next address to take me to. And as of right now, they have a blister pack they will send with me to the next location.
Okay.
And I'm absolutely wanting and interested to be medication compliant.
Okay.
These are my complaints. And so I think that's all I have to say.
Good. We've had a good conversation. I will get you back here soon once Ms. Wood tells me they've lined up one of those options for you, okay?
Okay.
Be safe.
Thank you, sir.
Take care. Anyone else back there?
That's it.
Okay. Thanks, guys. We've had 2 marathons this week. I feel bad. But we've been playing catch up after all these weeks off. Thank you, Ms. Simpson. Sadler, you guys did great. Let me do this.